good morning, good morning, good morning, amazing law nerd. We are going back to court today. It is day 6. Are we on day 6? Are we on day 5? I don't even know. Day 6 of the Banfield trial? Yes, day 6. Day 790 million. Day 6, 7. I don't pick one. We're just going to court because, well, courts in Fairfax, Virginia in real time on Tuesday, January 27th, 2026 are still closed. And that's totally fine. It's Snowmageddon, ice is everywhere. Roads are closed, power's down. Sure. Court's closed. Fine. All good. But we have another day of trial that is going to, I think, test my level of optimism and what we are going to learn and what, if anything, will go smoothly for the defense today, because honestly, I'm not sure. I'm just not sure where we're going to be. I'm really not. It's just today is, well, we'll see. Day 5 yesterday, we covered it, was one of the most painful days in court I think I've ever seen. And I've seen some tough days in court, and I've never seen anything quite like that. The defense is really struggling with a deep lack of organization. And it seems that defense is surprised that they're like in trial all of a sudden. But this isn't a case where I think there was ever a plea offer. It was always going to go to trial. So I don't know. So maybe today will be better. Maybe we will learn something new. Maybe we will see if the defense does things that helps set the groundwork for the defendant to testify. And maybe after Snowmageddon, the defendant will get back to court and be like, I changed my mind. Let's wrap this up. Who knows where we're going from here? But I can tell you one thing's for sure. We're going back to court and we're going to do it together. So law nerds, it really is about the friends we make along the way, because this trial is an experience. And since we're all on the roller coaster together, let's just go to court, right? Roller coaster. We're just gonna add that to the trial playlist. Roller coaster. Sure. Why not? Let me know where you're coming in from, what you're drinking, or how many inches of snow and or ice you got, and we're gonna go to court. Let's roll. That's not in the right spot, Emily. What are we? No.
Destination
That's better.
For live court coverage. I break down the law, the strategy, and the
Even
evidence
the text tired
in
of
real
this
time,
case right now.
so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
Even the intro's like, nope. The intro's just like, nope. The intro's like, I'm out. The intro's out. All right. So the attorneys came into court. They immediately went to sidebar for like 15 minutes. We're starting with the jury coming in because we heard nothing that they put on the record. It was just, we have a matter. Can we approach? So we'll see as we get into court. The jury's coming in. You know, the Honorable Penny Askarati presiding. The Honorable Law Nerds in the chat to witness whatever the fuck this is. We've got it. I don't think I've ever felt as bad for a jury. All right. They're walking in slow.
You are available for tomorrow, is that correct, for testimony? All right, perfect.
Remember, this is from Thursday last week. So from Thursday last week, the judge was trying to see if the jury would be available for Friday last week, because the judge said, I am not doing trial on Fridays. Judge A, I think, does motions and all the other things that need to be done on a Friday. But because she was fighting the snowstorm, Judge A was like, if they can come in on Friday, we'll do it. So she confirmed with them they could come in on Friday.
All right, your next witness.
And they're going to do it.
Casanova.
Officer Casanova.
Are you making this argument about the Juliana?
Your Honor, can the
prosecution keeps forgetting that their microphones are on when the light is on, and so we keep hearing them having conversations about what they're thinking about. The prosecution ASMR about who's making this argument. I don't even know what's happening. But it's so weird to hear all of the whispering. Also,
I have no idea what's happening, But I'm ready for Officer Casanova. Sure. Fred, really? Fred, leave those cardinals alone. Fred, it's too early. Fred has pushed everything on my desk out of his way to get to the window to see the cardinals. All right.
I'm not quite sure what the prosecution really wants to do, but here we go.
The main screen be released if it isn't already.
It is. There's nobody.
Okay, thank you.
It's fine.
At least now there is one thing I am confident in. Whenever we hear all of the aggressive typing, it's definitely the prosecution table.
Because their mics are on. Because they keep their mics on. Now I feel like I have to. I feel like maybe
You swear or affirm to testify truthfully in this case under penalty of law. Thank you.
So, I guess we're going to figure out what's going on with Officer Casanova.
Morning, Officer Casanova.
Morning.
I'm just going to ask you a few questions, but the first question is I wanted you to identify the picture that's in front of you. Do you see a picture?
I have a blank screen. Now I have a picture.
Okay.
Cause I've got a blank space, baby, and I'll write your name. I mean, oh, okay. Sure. We just need to start keeping track of the songs at this point. Where are we at today? Blank space. What did we do before that? There was something else. Damn it, I've already forgotten.
Is there any way, based upon just that snapshot of your body cam video, as to whether this is your video?
I can't say for certain.
Okay, let me move forward.
Oh, Leonard's my deepest apologies. I mean, I have on my EDB Air hoodie. It's not a gray hoodie, but hoodie apology. I can't believe this is normal speed. We're going to 1.25. My bad.
And just stop me.
Oh,
if
it
you
was
see
roller
anything that
coaster.
Makes it
It
clear
was
to
roller
you.
coaster of love. That's right. It was. It was not Phineas and Ferb roller coaster, which is roller coaster, roller coaster. It was.
This does appear to be
It's a
my video. I
roller coaster of
recognize my
love.
watch.
Okay. Sir, I'm going to go ahead and play this video.
You have to identify it.
Oh, sorry, Your Honor. That would be identified as Defense Exhibit 86, I believe.
I have an 86.
87.
87. Do you wish to have
6'7".
evidence?
All right,
Yes,
I'm
Your
done
Honor.
now.
Any objection?
Yes, Your Honor, which approach?
Okay.
I guess they knew exactly what was coming when they were deciding who was going to make the argument. Because they knew what argument they wanted to make.
Because they knew exactly what argument they wanted to make. That was me.
So 87 will be introduced into evidence without audio.
Oh, there must be
Does this need-
And sir,
hearsay.
can you,
I'm sorry. Does this need to be under seal? I don't know what it has on it.
I don't believe it does, Judge.
He does not go upstairs.
Correct.
Judge, I hate taking the risk, but I do not believe that Officer Casanova goes upstairs in the house. I believe that he remains on the first level.
Is that correct, Officer Casanova?
I never entered the house.
Never entered the house. Okay, so.
Maybe
so-
we just approach about one other thing that I might see
Okay.
on there.
Okay. Oh. This is the video that they put under seal and have no sound on. Right. Okay. There's no sound and they don't show the video. So we are going to zoom because it's this. For the entirety of this, it's this. So we're going to zoom past this in court of whatever video they show with no audio and see if there are any actual questions. Oh, and that witness is gone. That was it? Hold on. Where did they excuse the witness? Perfect. Good morning. Here's a video with no sound. Wonderful. We're just going to zoom till they excuse the witness, just for completeness at this point. I want
Michael Hayes.
to see if he asks any questions.
Sir, is this the end of your contact with Juliana Perez Magalhaes?
I believe I check on her a couple times, but for the most part, yes.
Okay, in the car?
Yes.
Okay.
Repeat. I'm not sure which cruiser she was in, but it was not mine.
Okay, you know that it wasn't you.
Yes.
What other than checking on her, were you given any other duties while there?
I'm sorry, can you repeat the question?
Other than checking on her, which you
Jeez.
testified to, were there any other duties that you began after she was in the car?
Yes, after a short while, I took over traffic control duties, restricting vehicle access to the roadway.
Chat, the static is the court mics. It is. It is the court mics like gained up. It's awful. I don't know.
Your Honor, this is 2545. And that's, those are all my questions for this officer.
All right, so just to be clear,
Huh. No more questions.
then you would just want 87 in evidence up to 2545, correct? All right, and that'll stay under seal then, okay. All right, thank you. Cross-examination? All right.
No
Is this-
questions.
Is this witness subject to recall?
No, Your Honor.
All right, you're free to go, sir. Thank you.
Thank you.
Your next witness?
Okay. So that was the defense witness number 6. They admitted a video with no sound that was 12 minutes and 45 seconds long. That's under seal, that involves contact with co-defendant Juliana, the au pair. Next witness.
Sergeant Brian Ames.
Sergeant Ames?
Oh, the audio. I don't know what's overgained, but it is. I'm optimistic it clears up. I can hear static and the prosecutor's typing. And that's literally it. It is rough. All right, next witness.
To testify truthfully in this case under penalty of law. Thank you.
This is defense witness number 7, if we are counting properly. So yes, we've had a full 6-7 day.
Good morning, Sergeant Ames.
Good morning, sir.
And are you a sergeant?
I am.
Okay. Where are you currently? What's your current position?
Good morning, Sergeant Ames. Are you in fact a sergeant? Good.
I'm in the IB, sir. Internal Affairs Bureau.
And
Okay, no static. Okay, Sergeant Ames, Internal Affairs. Maybe we'll learn something about everybody getting transferred. That I'm really interested in. Sir, what's the T? We want to know T. What's the T? Who said no more questions?
during the period of time, February 24th,
There.
2023
Red.
through the end of 2024, where were you assigned?
Did the Blue Jay see you?
I was assigned to DFS in November 2024 to February 2025. Before that, I was a street supervisor.
Okay. Sir, I'm going to have you take a look at,
Did the streets
some
behave,
exhibits.
sir? Or did they say, fuck that, I'm for the streets? Sorry, my brain is struggling with this defense attorney. A lot. We're on 1.25.
here, and I'm going to use the
Okay.
overhead if I can.
It's fine, we'll switch over to that. You just have to hit the button on the top.
From the top, make it drop. Thanks, Your Honor. Imagine imagine these jurors coming
So can
in
you
for
see that
another
document?
day,
I can, sir.
thinking about wanting to go buy storm
You can
snacks,
straighten it out.
and this is what they're
Are you
what they're
familiar with that
doing.
document?
Sure. Yes, sir.
Okay. And,
Sure. Sure sounds
I'm
confident.
specifically looking at, and I'll
Sergeant.
just put my pen in there, at this particular area. Is that something that you authored?
I did, sir.
And so the sign out is Ames. That's you?
That is me.
And this is your title here.
Yes, sir.
Now, just what is it that you're doing here with regard to this communication?
Your Honor, I'm going to object to the witness reading from the item. It hasn't been identified or offered in evidence.
I don't think the question was to read it.
No, it was not
Okay.
treated.
All right, I'll overrule the objection at this point.
What were you doing?
Prosecutor,
This
you gotta
appears to be an
wait.
Email thread. What were you doing?
Looking at the email, it looks like I received something from Lieutenant Giaccio, and I was sending it out amongst the people who work for me. It looks like I CC'd my captain.
Judge, I am going to object. He's reading from the letter. If his recollection of this email is such that he can testify to its contents, then certainly.
So it'd be a foundation objection.
Yes,
Sustain that objection.
And sir, this is an email that you authored and you sent on to your colleagues. Is that correct?
We're back to struggling with foundation. Good. Good. Great.
That is correct.
Okay. Your Honor, I move this in as a Commonwealth's Exhibit number 88.
Any objection to that?
No.
Okay, 88 in evidence, and we can
Now, I would
publish
just
it
like
to the
to
jury.
ask you another question. The people that you were saying you were writing to were people that were within your section, is that correct?
It looks like I CC'd my commanders and two of the detectives that work for me.
Okay, and the two detectives are both named Brendan Miller?
Yes, sir.
And is one of those detectives the digital forensics analyst for this?
The defense has not asked the witnesses to spell their name for the court reporter. It's inconsiderate. Then again, I'm not surprised because he also has forgotten to mark all of his exhibits. Again, one of the things I said with Elaine Bredehoft is that it seemed like she was much more familiar with doing depositions. This is the same. It feels like this attorney does probably not do a ton of trials. And it's surprising to me because even in opening, he was like, well, back in my day when I was a prosecutor, at some point you might have done some trials, but in deposition, when objections are made, you're not arguing them. The objections are made for the record and you just keep going and the court rules on them down the road if that comes in or out. You're not arguing objections to keep things in or out. So this feels very similar to that where, yeah, it's
This case?
tough.
Yes, sir.
Okay, and he's obviously in your section. And is this officer in your chain of command?
No, sir.
Okay, what?
Your Honor, counsel's making reference. He said this officer. I'm not sure who he's speaking
If you
about.
could.
I was just
records.
pointing, yes, I won't point, sir. David Giaccio
The prosecutor's like, objection vague. Oh, so counsel, you don't need to help him.
says Lieutenant David Giaccio.
He was not in my division.
Okay, and yet he's communicating you regarding, what is it he's communicating about?
That's hearsay.
An executive summary.
Okay, is that Brendan Miller's executive summary? Do you recall?
I don't recall, but looking at this, I would have to say,
Judge, I'm going to object to any further answer. He does not recall.
No, overruled. You can finish answering. That's fine.
You can finish answering, you were saying, but looking at this.
it appears to be an executive summary.
Okay, now,
So you talked to the witnesses before putting them on the stand or nah? Or not? I'm at 1.25 and this is how slow it's going, y'all.
was there a particular executive summary that Brendan Miller completed that was at issue while you were there in cyber security?
There was no executive summary issued while I was there. I was only there for 4 months, sir.
Okay. Was there...
You were in cybersecurity for 4
Were
months?
you aware of any disputes with the executive summary, either within your division or another division?
I know that executive summaries are written on every case.
1.25.
How about this case? How much contact did you have with this case during your time there?
With this case, not very much contact at all, sir.
So, why the fuck are you here? Why are you here? Why? Why? What? I'm waiting for the prosecution to be like, objection, relevance?
Okay, and so what we're seeing is
Relevance?
this extent of your contact?
Pretty much, sir.
Okay. Sir, I'm going to take 87 off, and I'm going to have you look at,
Judge, I believe that was 88.
I'm sorry.
Is that correct? He referenced 87.
Oh, sorry.
That was
Did I
88.
say-
You just did 88, yes.
okay, then that was 88 that I took off.
Right.
I'm going to identify what will be marked as Offense Exhibit 89. Can you see that email?
I can't.
Okay, and is that appear to be an email that you forwarded on?
It is.
Actually, you know what? I'll just let you tell me what it is.
Huh.
It looks like Lieutenant Giaccio forwarded a proffer to me,
Okay,
and then I forwarded on to my detectives and CC'd my supervisors.
okay, and you said a proffer, or are there two proffers there?
I don't know. Normally the system works where you get two different angles. I can't recall
Okay,
if that's one or two.
so you never examined those proffers?
No, I'm sure I clicked on them before a meeting, but I don't recall if it's two separate parts or if it's just
Sir?
two angles.
This is
Okay,
not a
and,
deposition. This is
the,
not where you explore the
Where you
evidence.
sign off as Ames, that's you, correct?
Yes, sir.
And Sergeant Brian Ames, all of the things relating to that were correct as of the time of this writing on
Yes, sir.
November 8th, 2024?
Yes, sir.
And you're CCing, I assume, superiors?
Chain of command. Yes,
Chain of
sir.
command, okay. And Brendan Miller and Brendan Miller are the two people that this is directed to.
Yes, sir.
Okay, now,
Did you just say there is a Brendan Miller and a Brendan Miller? Are there? That can't be correct. There's two? What? Also, in my DA training class, we had a Andrea, an Andrea, and an Andrea. Yes, they were all spelled the same way. It broke my brain. And then everybody's names got shortened, which was easy with Drea. But there's a Brendan and a Brendan Miller. Okay. Oh, okay.
Brendan Miller and Brendan Miller are the two people that this is directed to.
Yes, sir.
Okay, now they're in your chain of command. Would that be an order that you're providing them?
Well, that's what we learned today.
Can I move this in as Comments Exhibit 89?
Any
He didn't answer. His response was,
objection?
No.
All right, 89 evidence.
If we can have that published.
I mean, yes, I guess since I'm their supervisor, if I
His
if I
response
send
was,
them that, I guess it could be perceived as a command, but that's not really the way it works. It's their detectives looking at a case.
Okay.
Okay.
So, let me ask you a question about that. By saying their detectives looking at a case, you're saying you leave the detectives alone to do their thing?
I'm saying that I had 4 months there. I wasn't really caught up to speed on digital forensics. That's not my specialty. Like I haven't been trained in that.
Okay, so you're
Ivy, Aylin in the chat said, I teach high school. Last year I had 6 students, all named variations of Caden, spelled C-A-Y-D-E-N, K-A-Y-D-E-N, K-A-I-D-Y-N. My oldest, Travis, is in that age demographic where everyone is named Caden, Hayden, Aiden, Braden, Jaden. Yes. And then people were like, Travis? Correct. But yes, there is an epidemic.
You're a supervisor for the people that are trained and as experts. Okay. And as a sergeant in your chain of command, are you being ordered to do something by the lieutenant from Homicide?
I think
These emails, are going to get so fucked up. But it's really funny that it's Brendan D. Miller and Brendan C. Miller, but it's Brendan, BRENDAN Miller at fairfaxcounty.gov. And then Brendan, BRENDON. Those emails are getting fucked up all the time. You put the middle initial in the email. Because between Brendan and Brendan, that email, there's no way those emails aren't getting totally screwed up and everyone's getting the wrong emails all the time. Just all the time. The email dated 10/25/2024 says, JPM proffer, guys, I will need you to watch the proffer and look at the timeline. We will need to relook at the data in context of this new information. Please let me know if you have any questions. Thank you, Ames. Okay.
being asked to look at this, like this is the way information sharing would happen. Is we're not homicide detectives over in that squad. We're kind of we're a support unit over there, so that's how the information would come in.
Okay. So if I understand you correctly, criminal investigation, cyber and forensics bureau is a support bureau for homicide?
Well, specifically to digital forensics
is
a support bureau for all the other bureaus when they have digital evidence.
Right.
Okay. And is it common for the lieutenants from other bureaus to communicate with you in this way, to have your detectives?
It's a support bureau for everybody.
No, there's a lot of back and forth. Like when I was in that position, I kind of feel the calls, send stuff up the chain of command, figure out what the detectives think are best for the case, stuff like that.
Okay, so you're going up the chain of command. Is it something related to the communications that you're receiving, or is that something that you would do with every communication?
Since I was a newer sergeant at the time, it was my understanding the expectation out of my command was to link them into.
So you were a new sergeant in cyber and you were there for 4 months? Mm-hmm. Okay.
Pretty much everything that I was doing.
Okay, in the form of, in the immediate moment you received an email?
If I was doing ESRs, like they got them, if we had a case that was unusual, or if we had anything, like I said, I was a newer sergeant. It was my understanding the expectation on me was to forward stuff up my chain of command. That is correct.
Okay. So this is commonplace, what these emails show.
I would say at that point, when I was in DFS, me being newer, I looped them in on a lot of stuff.
Okay. Thank you. Your Honor, I've moved 89.
89 isn't it?
Yeah, homicide detectives don't like it when they're out of the loop. They're going to want you to forward everything to them. All of it.
Okay. Sir, I'm going to have you look at what will be marked as Defense Exhibit 90. Do you recognize that?
I don't think the witness is necessarily unprepared, though it's very possible that the defense subpoenaed the witness, told him nothing of what it was about, put him on the stand cold, and then is asking him confusing questions. And so this witness is like, what is your point? And also, it seems like at least numerous people have been transferred because of this case. So it's probably I imagine there's a little hesitancy on the side of the witness. And then the defense's questions aren't clear. And it seems to me that the defense didn't even tell him why he's calling him to testify, which seems to be to go through these emails. So, yes, because if you're not told what to review, you just show up in court and sit down and somebody asks you questions. But, wow.
I know you send a million emails
Yeah,
a day,
I
but
send
do
an
you
awful lot.
recognize this
I-
particular one?
Yes, this is my email, sir.
Okay. And this.
Here's your email from 4 years ago.
And appears to be you. That's the way you would sign off.
Yes.
Is this you?
And this would be all of the information that's accurate as to where you were working at the time.
Yes, sir.
And what about this up here? What was that? Do you have any idea?
I think the defense is
I don't know without seeing it.
Trying to go-
I mean, based on the content.
in context of the defense's opening statement. The defense said that there was pressure within the police department, that people didn't agree with the catfishing theory, got transferred. So I think the defense is going to try to build that there was fuckery amongst the police, that it was a everybody fall in line or else, and then people got transferred. And maybe we'll see. Maybe there is fuckery. I don't know if we're going to see Karen Reed level fuckery, but even in the Richens case, we have seen the fallout from the Karen Reed case with the way that the defense is trying to build the Richens case. The Karen Reed case is going to impact prosecutions, particularly from the defense, going forward for years to come. And defense attorneys are going to be pulling on threads they might not have pulled on before. And I think trying to get to private cell phones, et cetera, in ways they didn't before because of what happened in the Karen Reed case. So everybody might not make fetch happen, but I think they're going to try.
Text here.
For sure.
It looks like it's a timeline from Lieutenant Giaccio
Okay.
related to the proffer.
Do you know, and let me just call your attention to, and this is 89, correct?
That's 90.
90. Your Honor, I moved this in as Exhibit 90.
Any objection?
No, ma'am.
90 in evidence and published?
Sir, I'm going to put 89 there next to it.
Where's 90?
89. Oh, he's been 89, okay.
I didn't ask you about, with regard to 89. Do you know what that is?
I mean, given the context of this, it appears that it's a timeline related to this case.
Okay. And I'm going to have you look back at 88. Do you know what the attachment was on 88? And when I say do you know, I'm asking, did you open it or did you look at it or anything like that?
I mean, I'm sure.
Also, yes, the defense attorney should have a legal pad next to him or a printout of bullet points of his questions. Bullet points of what documents he wants to use with this witness. And then in the margin, you write the number with a pen as you admit it into evidence. Bullet points, documents, pen. Okay, this is an email to Brendan and Brendone. In my head, I just hear Prestone. I love that guy. That's what's happening in my brain. This is from Ames on November 8th, 2024. There's an attachment that says Digital Forensics Section Executive Summary .doc B1 and B3. I'm guessing B1 got hired first. You sunk my battleship. B1 and B3. Also, when you have a Brendan Miller and a Brendone Miller, do we really assign them to the same section? B1 and B3, we will also need to revisit this document in light of the proffer. Please let me know if you have any questions. Thanks, Ames. I know. I don't know where B2 is. You know what it is? B2 in the chat is so iconic that they knew to skip it. They knew to skip it, B2. They knew. B1 and B3. You sunk my battleship. Oh my goodness. All right. Well, I went battleship, y'all went bingo, fair. So again, take a look at this, is what this email is. So there was a period of time when the Long Beach Police Department had a sense of humor in their partner pairings. And we had partner pairings with the funniest last names. but they included Officer Sturgeon and Officer Trout. Yep. And so when you would see that the pairs come into court, you would just be like, somebody had fun with the assignments, didn't they?
I looked at it, but if you're asking me right now if I know what that is exactly, all I can say is I can assume that it's an executive summary that has to do with this case.
Okay, thank you very much. Now, on 88, you've added Brendan Miller's, I guess, B1 and B3, they're called?
Yes, sir.
Okay. On 89, you added Brendan Miller, and then CC'd your command staff?
Yes.
And on 90, I don't see Brendan Miller. Would that have been forwarded to them, or is this just specifically for your command
That's
staff?
just for my command staff.
Okay. And so there wouldn't be an additional email to show what you sent to Brendan Miller and Brendan Miller?
I don't believe so, given the context of this. I don't believe I forwarded that, but I don't know.
This appears to be dated November 7th, 2024. Is that correct?
Yes, sir.
And let me go back to 89.
I'm waiting
This was
for this
dated
to.
November 8th, 2020.
I have a point, but these are the emails I just previously read in. He's putting them back up and now reading them, I guess.
24, correct?
Yes, sir.
And number 8.
At least they're printed out.
88 is dated November 8th, 2024 as well, correct?
Yes, sir.
At least
No,
they're
I'm
printed
gonna-
out. So there's that, right? I can't imagine the jury is not
Sir,
a little put out at this point.
do you see that on your screen?
I need to feed my Snorlax.
Yes, sir.
Okay, and same questions. Is this how you sign out?
It is, sir.
Okay, and this information is all correct?
No, that is, maybe I didn't change my,
That is not correct. then.
my signature line at that point.
Okay.
I don't know exactly when my first day was up there,
Okay.
but that was my previous position.
Okay, and that's your email, correct? You authored that email?
It is.
Okay.
Judge
And
A's
this-
face
Just
is
to point out a few
spacing.
things, November 8th,
Oh,
2024.
Judge A, we feel
And
you.
it's to your command staff, not to the Brendan Miller and Brendan Miller. And there's an attachment, and that's the same, appears to be the same attachment as number 88.
Boy.
Is that I can show you 88 again if you'd like.
I mean, it appears the same, but I couldn't tell you what it is.
And this email is from Lieutenant. Who's this email from?
I object to leading, and I object to the continued characterization of the items in the email that the witness has indicated he does not recognize and cannot tell the court or the jury what they are.
I understand.
Your Honor, I object. This sucks. Correct.
As to leading, I'll sustain leading.
Who's this email from?
Appears to be Lieutenant Giaccio, sir.
Okay, and nothing's changed about his position or your position since we looked at 88, 89, 90.
I'm not sure why my title line is like that. I don't know. I believe at this point I'm in DFS, given the fact that I'm writing emails to that chain of command. I don't know why my subject line is different.
That's fine, as long as you can identify that as your email, that's fine.
That is my email.
Your Honor, I'd move this in as Defendant's Exhibit 91.
Any objection?
Yes, Judge, I'd object to contain statements made by a party not testifying would be hearsay.
All right.
Your
I
Honor,
assume that's a hearsay objection.
Yes.
Okay.
Your Honor, I would just identify that for now.
You just identify, you don't want to put it in evidence?
I won't put it in evidence. I'll put it in evidence when I call the next
Okay,
witness.
so 91 is not in evidence. Okay, next question.
God bless.
Now, Sergeant Ames, in your training as an investigator, are you the type of investigator that follows the evidence, or are you the type of investigator that follows a theory before the evidence is developed?
Objection, compound.
Me as an investigator, I go with evidence.
Okay.
Big fan of evidence.
As an investigator, when you question individuals that may be suspected of a crime, do you let them just tell you the story without challenge?
Objection is deleting.
Normally the
All right,
first
stay
time.
as leading if you want.
What, if anything, do you
What if anything is not a cure-all? Just a friendly reminder, what if anything is not a cure-all? It seems like the defense is trying to develop that the person, the people, the officers that interviewed Juliana interviewed wrong and interviewed her without challenging her statements. And it feels just like a Twitter argument to me at this point. It's just like, do you just let someone tell the story without challenging them? Oftentimes in the first proffer, yes, you do. Especially if you know you're going to have multiple interviews with them. Because the inverse is that you question them so much they shut down, or that you start feeding them information. And you don't, and then the defense comes in and are like, well, you were asking them these pointed questions. So they didn't really tell you what happened. You told them what happened. So yeah. You don't always challenge them on the first go. But I think what the defense is trying to develop here is saying, see, they interviewed her wrong. See, y'all were doing anything you can to just, get on board. You were trying to fit the catfishing theory. You were trying to make the facts fit the catfishing theory, not the other way around. Which again, seems very much inspired by the Karen Reed trial. It's not that this is not a defense that has been used before, it has. But arguing that the investigators are trying to make the evidence fit the facts doesn't always fit. In the cases it does, holy shit, it's obvious. Okay. I might have to put this at 1.5 instead of 1.25.
You do when you question a suspect in terms of their story?
I have a conversation with them, sir.
Okay. And if the conversation isn't consistent with the evidence that you have, how do you handle that?
If I have the opportunity, I clarify it.
Okay. And in clarifying, what is it exactly that you're doing?
All right, let's give 1.5 a try. We might have to slow it down if we get to cross-examination, but it is painfully slow. Yeah. Yes, Diane, yes, that was at 1.2. We were at 1.25. That was at 1.25. I know.
When you have a dispute with, or a conflict with.
Replay crew, we're now at 1.5. So if you've got us already sped up and this speeds, yes.
What you know versus what the person's saying.
That's better.
Can you ask that again, sir?
When you have a situation as an investigator that you're trained to be, and the facts, as you know them, are different than what the person is saying to you in the story or whatever conversation you're having, how do you handle that?
If I have the opportunity, I follow up and ask questions that I need to know the answers to.
Okay. And
it's interesting to me because the defense is like, but if what you're interviewing is wrong with the facts you have, good investigators should keep their mind open in an interview to that the facts that they might have or the theory they have about those facts might be wrong. And when they interviewed Juliana, they had a theory, but also who's doing what on the computer and whose hands are typing on a phone. You only know what was typed into the phone. You don't know who's holding it. So you have to be open to new information or you shouldn't be having the conversation.
would there be any reason that you wouldn't have the opportunity if you're talking to them?
No, I mean, defendants, if you're talking about a suspect of a crime, I mean, they don't have to tell you. You can ask the questions, they don't have to tell you if that's what you're asking.
Well, I'm just asking, say, let's assume that nobody's claiming the Fifth Amendment. There's just a statement based upon what the evidence you know. What I'm trying to get at is how do you get to the evidence to determine if what you know is correct through the person that you suspect is the criminal?
You listen.
If you're asking what I do, I generally ask questions till I understand.
Okay. And in
Right.
terms of the types of questions,
You
how do you do
listen.
that, or how were you trained to do that?
Judge, I'd object to relevance at this point. I'm not sure where we're going with this witness.
I think it's relevant
He's trying to use this witness as like an expert in interviewing and investigations. So of course the relevance objection.
to the investigations that would go on in any case, in any criminal case.
I'll sustain the objection as to relevance to this case.
Sustained. He didn't do it in this case, and
In
he's
that
not an expert
situation-
in police procedure.
That we were just talking about. Would you challenge an individual or not challenge an individual?
Same objection, Judge, relevance.
I'll sustain the objection.
Okay, I'll move on, Judge. You've seen defense exhibit 88, 89, 90 have been moved into evidence.
Yes.
91 has been identified by you, sir. Were there any other additional communications, either telephone or meetings relating to the subject matter of these three exhibits that you know of?
This has been so long ago now, I don't know.
Okay.
I mean,
Right.
there quite possibly could be another email or text. I don't know.
Okay, I'm just asking if you know of something. I'm not asking for you to speculate.
He said he doesn't know.
I don't know.
During the time frame you were there, I think you said February 25 was when you left.
I believe it was February 25.
Okay. Had Brendan Miller, the digital forensics detective in this case, had he been transferred at that point?
I think he transferred either right before or right after I left.
Okay. Did you have any role in his transfer, whether administrative or making the decision?
No, not making the decision. I think my role was figure out where Miller wanted to go initially and just be a first-line supervisor for him.
Okay.
So they asked, when they transferred Miller, they asked him where he wanted to go. Okay, he wasn't in that much trouble then, because we've seen how the transfers have gone in Norfolk. It's not quite what unit would you like to go to.
And would that include, would that first line supervisor role, would you have a lot of contact with him?
I mean, I had contact with him every day.
Okay. And would the contact that you had with him be related to the Banfield case?
Anniversary yarn made in VT.
If things came up, yes, I would have contact with him about the Banfield case, but it wasn't, it's not like I'm doing forensics or anything. If questions come up, I generally shoot an email at my chain of command or stuff like that. I mean, I'm not advising him how to go through data or anything like that. It's, my job was, I had other things that I was doing budgets and distributing cases, new cases coming in.
Okay. Did you have anything, were you a decision maker in his transfer? No.
He already said no.
Do you have any idea why he was transferred?
I wasn't brought into those conversations. I pretty much was told
It was
that
happening.
the decision had been made.
Yeah.
I wasn't involved in those.
Okay. And was there anything that you were told about the decision that was made?
Hearsay. That's hearsay.
Not that I can remember. I mean, there was, right, it's a police department. There's rumors going around, but I don't know what would make the difference. I don't know where the rumors would stop and what, I don't think I was told specifically why he was being transferred.
Okay. Well, I don't want to put you in that spot, so if you don't know. Now,
he said twice he didn't
were you
know.
aware of how the experience that Brendan Miller had, the one that was transferred?
I knew that he was a.
Why does it matter? Why does this witness was a supervisor in that unit for 4 months. Why would it matter? You called him to get those emails in when he's like, hey, please take a look at this. Hey, it's me. Ange said, please launder that ping when we change witness. We will. I can't promise it's going to get any better, but here we are. I think that the emails are the point of this witness?
Can't think of the terminology. Certified. Sorry. Yes, I know that Miller is experienced.
Okay. And he'd been there for how long do you think, prior to you leaving, or prior to him being transferred?
I don't know.
Okay. In terms of your making the decisions of assignment of cases, where would he be in the decision process for you?
I don't know what you're asking, sir.
Would he be one of the more experienced ones that you would assign to, or one of the less experienced ones?
The other Miller was kind of the person who I bounced what we were going to do. He was the other Miller was the more senior Miller on the squad, so I bounced most of my decisions off of him.
Okay, and then he'd assist you with that?
He would, yes, he would assist me with that.
And do you know how long he had been in the digital forensic section?
I don't know.
Okay.
I know it was a while, but I don't know.
Okay. Judge, I don't have any further questions.
All right, cross-examination.
I'm going to leave 91 there if that's okay.
Oh, that's fine.
Good morning.
All right, I'm going to put cross at 1.25 and see how that goes. The prosecutor does tend to speak a little bit quicker. I can't imagine what the cross is going to be in this.
How are you?
How you doing?
All right. So just so we're clear, you weren't in digital forensics very long, correct?
I was not.
Okay. And you didn't get involved in any of the actual digital forensics involved in this case, correct?
No, ma'am.
Okay. And you weren't involved in Detective Miller's transfer,
No, ma'am.
and you weren't involved in Detective Miller's work on this case, correct?
No, ma'am.
What did
Okay.
you do?
These emails
Why
have
are
been
you here?
shown, you just passed them on. Is that correct?
That is correct.
They didn't require any specific action of you, correct?
No, ma'am.
Okay. And those requests were to examine the evidence in this case in the context of new evidence that had been received. Isn't that correct?
That's correct.
Okay. Did you change?
I think that it's really important to remind the jury. I guess they probably know this, but to have the reminder that you can evaluate a thing with the evidence that you have, and when new evidence comes in, you should reevaluate the thing. That's the thing you should do. And the defense is like, oh, now you're asking them to look at it in light of new evidence. Yes, you should.
Distort or hide any evidence in this case?
No, ma'am.
Did you direct anyone to change, distort, or hide any evidence in this case?
No, ma'am.
Thank you. Nothing further.
All right. Any redirects?
No, counsel, no. You don't know. There's nothing
Sir, I
you need to
appreciate your
ask.
answers. Did you feel as though anyone was suggesting that you distorted, changed, or did anything to evidence based upon these emails?
No.
Okay. Thank you. I don't have any further
Is he
questions.
subject to recall?
No, Your Honor.
No, ma'am. All right, you're free to go, sir. Thank you.
Thank you.
Okay. Your next witness?
Yes, ma'am.
So the prosecution thinks that this is exactly where the defense is going. Because the prosecution's question indicates why they think this witness is called. Did you distort, hide, or change any evidence? No? Okay, then. Bye-bye. Bye-bye. Bye-bye.
Excuse me?
Detective Leah Smith.
Detective Smith?
Next witness. Detective Leah Smith, I love the green. Is that green and navy? It might be green and navy. I dig it. Look at that, a court suit. How novel.
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
I dig all of it.
Can you please state?
Ma'am, I dig the suit. I dig the blouse. I love it. Great combo. It just goes so well with your colors. I feel very Legally Blonde. No, I couldn't handle curls. I don't have your bone structure. I love it.
State your name and spell it for the court reporter.
Leah Smith, Leah Smith.
And what division in the Fairfax County Police are you currently in?
Homicide.
Okay. And were you in homicide during the time of February 24th, 2023?
I was.
Okay. So you're familiar with this case, the Banfield case, and the Juliana Perez Magalhaes case?
I am.
Okay. And as a homicide detective, you're trained in certain investigatory techniques, correct?
Yes.
What are those? If you could just tell the ladies and gentlemen of the jury.
Motion, sua sponte, yes. I'm making my own motion to just put this at 1.5 until we get to the point where we can't, because we're here. Emily in the chat said, he didn't spell Casanova, but Leah Smith. Look at me, self-referential. But Leah Smith, that's the one he needed to get to. Yeah. Yeah, 100%.
So we are gatherers of facts. We will respond to scenes, talk with patrol officers who have already arrived. They'll give us a briefing of the case. We'll identify people that we need to talk to, places we need to go, and gather other information
I
and
think
track
this is
down
the first homicide
what
detective
information
we've
we have gotten,
seen.
and if we need surveillance video or go to stores and track back movements, identify people to talk to. We'll canvass a neighborhood. We'll talk with crime scene to figure out what needs to be done in their capacity and how that will work in our capacity. We will just gather all the information that we can and put together to the best of our ability what happened in a particular incident.
And how do the theories of cases emanate from an investigation?
So the best
an
course
interesting
of
way to phrase
action when
that.
you're investigating a case is to collect facts and information. You don't have theories to begin with. You have an open mind going into it because you don't know what happened. And then you try to gather all of the information so that it gives you a clearer picture as to what happened.
And in terms of gathering the information in order to get a clearer picture for, I guess, the entire squad, what mechanisms do you utilize in order to make sure everybody's on the same page?
We discuss what we've done, who we've talked to, what information we have gathered or captured. If crime scene will let us know what they have. We usually have a detective who is with crime scene as they're doing their work, and they'll pass on information. If we have other entities doing work on our behalf or assisting us in any way, they'll provide information, and then that will be discussed amongst the squad so that we all have a full picture of what we know.
Okay.
So beginning with February 24th, 2023, had you developed any theories on that day based upon what you saw at the crime scene?
No.
Okay. Give the ladies and gentlemen the
I can only imagine that with that crime scene and with the 911 call and with everything, and we haven't seen the interviews, we know that interviews were given. I don't know if defendant spoke to law enforcement, but we know that some interviews were given. I imagine law enforcement was like, what happened here? Because he stabbed her, I shot him, or I shot him, he stabbed her. There's a lot of information missing when you have no forced entry and you have the other individual, Joseph Smith, good Lord, Emily, Joseph Ryan. We're conflating all the names together. We have Joseph Ryan's car parked in the driveway and his wallet in his backpack. Like there's so much that you're just like, what is happening? So it's, I imagine they were just like, what? Just what?
jury as to kind of what the timeline is for any theories that you may have had.
Personally?
Yes, as an investigator.
So I did not, and
I mean, I don't think this was her
don't
case.
have or don't create theories as I'm investigating a case until I have all of the evidence that we can collect. And even then, a theory of the case and how it's going to be presented in court is really something the Commonwealth's attorney is going to do. They're the ones who are going to present it. So we will give them all of the facts and all the information that we have, and whatever theory that's going to come from that is something that they're going to present to it. We do make a
That's
determination
fair.
if there is probable cause to get warrants for somebody in a case. So in this particular case, I did not have a conclusion until we had all of the evidence in the room.
Okay.
I think he might get farther if he said, how do you start to pull together an idea of what happened?
People-led evidence and all of that stuff that was really understood.
Okay. What was the time frame on acquiring all of that information in order to potentially have theories? If you were
Those pieces came in toward the very end of the investigation, a full understanding of the sequence of events that we could tell and understand in the room that came toward the very end.
Okay. But in terms of the hard evidence that's done, like DNA, fingerprints, digital forensics, when is the evidence?
So your testimony, ma'am, is that your full understanding didn't come until the very end. So after you heard from Juliana then?
Available in order to arrive at conclusions or rule things out or any of those sorts of things?
That's a sliding situation. So things are submitted to the lab and you might get information and lab sheets back in different times. It's not all given to us at once. And so having that portion of the investigation, you might submit something and then realize that you need to submit more things, or the lab will only take a certain number of things, and then you do a second submission. So then your lab sheets will come in as they come in, kind of in a longer time period.
And the decision process amongst the homicide investigators, is that just within the room of homicide, the actual investigators?
Let
me see if I can articulate that a little better. You've just described the gathering of evidence and the discussions. Would that be with the homicide detectives, or who else would be included in that?
It could be anybody who's involved in the investigation. We do briefings with all the entities that are part of it. So it could be computer forensics, it could be crime scene. Our supervisors are there. If we're having, so it could be different meetings over the time period of the investigations. There might be different people who are present during those discussions.
And is it, would you describe the homicide group as being the investigators and the supervisors in another way?
The homicide detectives are the investigators, yes.
Okay. And just so it's clear for the jury, the chain of command going up, the supervisors, they're not investigators, correct?
They are not investigators, they're supervisors.
They're supervisors.
Did there come a time when supervisors were suggesting theories to the homicide investigators in this case?
So we had a briefing within the first week of the incident where we were discussing everything that everybody had done and the information that was collected. And our supervisor at the time told us there were two theories in the case and we needed to get behind the right one.
Who was the supervisor?
Lieutenant Smug.
Okay. Who is it?
I have no idea what that lieutenant's actual last name is. Closed captioning heard Smug. I heard something else. But her answer is, within the first week, someone in the chain of command said to them, there are two theories in this case. You need to get behind the right one. Okay. That's worth a 1 point. That's worth a 1.2. That's worth a 1.25. So I can hear the supervisor's last name properly, but that's not great. A briefing within the first week, there's two theories, get behind the right one. Way more direct than do the right thing, but it's not good.
Of the incident.
I'm very curious about that.
So we had a briefing within the first week of the incident where we were discussing everything that everybody had done and the information that was collected. And our supervisor at the time told us there were two theories in the case and we needed to get behind the right one.
Who was the supervisor?
Lieutenant Smug.
Okay. Who was in the room?
The homicide investigators, the detectives.
Okay. Were there any other people?
I don't recall if there were victim services or advocates or our crime analyst or others who might be there during a briefing when we have just had an incident.
How did they have that?
Was one of those
How did they have two theories a week into this case?
theories catfishing?
It wasn't stated what the theory was. It just said there were two theories and you need to get behind the right one.
Okay. At some point.
How do you know which one's the right one? And if you don't hear that there's two theories, what were the two theories?
What it was. When did you find out?
I'm not sure who said exactly that it was catfishing, that was what it was. That's just what I had begun to understand and hear from other people.
Now, did you or any of your, well, actually, I can only ask you.
What theories?
What, if anything, did you do, given what you just testified to the ladies and gentlemen of the jury about your methodology? What, if anything, did you do or say after hearing that?
I told Lieutenant Smug in the room full of investigators that at this point in time, nobody should have a
I still don't know what lieutenant's last name is. I can't tell if it is smug, smut, schmuck. I have no idea. We're just going with S. But I appreciate that she's like, no, I said there shouldn't be any theories at this point.
I told Lieutenant Smuck in the room full of investigators that at this point in time, nobody should have a theory in the case, that we are still at the very beginning and we should only be investigating and gathering facts and information.
And how was that received?
There was no response.
And did this meeting end? Did the conflict between your statement?
Oh, look, supervisors asking for things they shouldn't be asking for. I like her. She's like, no one should have any theories. We're a week in.
And the theory that was sitting out there continue in conflict after this meeting? Like in future meetings?
Good for her.
I would say that the investigators on this case knew to investigate with an open mind, even though that might not be along the lines of what the supervisors might have wanted us to look at, how the case to investigate a particular line.
Good for you.
And did there ever come a time, I know you said at the end of the case, that the catfish theory went away?
Objection leading, objection, facts not in evidence.
That's leading us.
Did the catfishing theory go away? No, it was in your opening statement. It didn't, in fact, go away.
When,
When, if at all, did the theory of catfishing go away from this case?
I don't know.
When, if at all? How are we finding new variations if what, if anything? Fucking stop. When did the catfishing go away? We're here now. What?
Was that then, well, did it ever go away?
I don't know.
Okay. And would that be for you to know, or would that be someone else within homicide?
Judge, I'm going to object to the form of the question. I don't think go away is clear enough. And obviously, we're here on a catfish theory.
Your legal objection.
Judge, it.
The prosecution, ma'am, your legal theory. Your Honor, we're obviously here on a catfish theory. The speaking objections.
Form that is an unclear question.
Overruled. Go ahead. You can answer. Remember the question.
You can answer it if you
Just mind
can.
repeating the question.
This witness is like, what the fuck?
To determine over the lifetime of the case, was the catfishing theory ever disregarded or put to the side?
No.
Was there, during the life of the case, was there periods of time where the homicide squad was not supporting the catfish theory?
So everything is on the table. I wouldn't say that it wasn't. We explored all options, and that was always on the table.
Okay. And when was it that in your mind catfishing was confirmed or negated?
Counsel, first of all, yes, we're still at 1.25 speed. Counsel, is that really the question you want to ask of the homicide investigator? The homicide investigator. You want to ask the homicide investigator when she confirmed the theory of catfishing that is antithetical to the case that you're trying to make. I thought that in opening statements, what you said is that there was no catfishing. And you're asking the homicide investigator when she confirmed the theory of catfishing? Because she's going to tell you. Did you just ask her to say that she believes the co-defendant? This is a question that needed to stay unsaid. I'm real curious what the answer is going to be, though.
It was toward the end, I would say, that once we understood the full for the investigation, catfishing is maybe how you got to a point, but what happened in the room, in the bedroom, that is really what you need to figure out. That's the determination of who would be charged in the crime of murder. So
she's being
once
mindful.
you understood all of that and what happened
And
within
restrained.
the room, and then you have the other evidence of it coming forward and through the digital forensics and the interviews and all of this stuff. That decision was made on who to charge for it based on the forensics evidence.
And you charged,
She was much kinder than I think some investigators would be. Notice she didn't say the interviews first. She said based on the digital forensics and then the interviews, we figured out what happened in the bedroom. Fair.
Juliana Perez Magalhaes in October of 2023, correct?
Yes,
So was it concluded at that point?
she was charged for her involvement in the crime. So she wasn't charged with Christine.
Right. And so was it
I don't
based
think the
upon
jury
her
knew that yet.
recantation that Brendan Banfield was charged?
No.
No.
Hey, counsel, you want to make fetch happen? But the jury has now heard multiple times that Banfield was charged before Juliana flipped. He's going to keep calling it recanted. She didn't recant because she never admitted to anything. It's not the right use of the word.
In terms of the catfish theory, actually strike that, Judge.
See, when you prepare your questions, you can think through what not to ask this investigator.
I don't have any further questions, Your Honor.
Oh, smart.
Good morning, Detective.
Good morning.
So
On
you've
the
told
cross.
us that you conducted your investigation in a manner consistent with following the evidence. Is that correct?
That's correct.
Okay. You explained to us that theories were certainly discussed, but that they did not drive how this investigation was conducted, correct?
Ultimately, no.
All right. Counsel asked you about this meeting where you were told and detectives were told that there were two theories and you needed to get behind the right one. You challenged that.
I appreciate the counsel's in a jacket. I'm still vibing with the jewelry. And do you see how much easier it is when the prosecution gets to cross-examine the officers? So your supervisor said, get on board with the right theory. And you pushed back and said, we don't even have a theory yet. And then you followed the evidence, and the evidence led you to charging Juliana and then charging the defendant over here. That's where the evidence led. The evidence led to this guy sitting here on trial for murder. Right? Cool. Honestly, kind of a dream if you're a prosecutor that you get to just cross-examine all the cops. Okay.
Counsel asked you about this meeting where you were told and detectives were told that there were two theories and you needed to get behind the right one. You challenged that, correct?
Correct.
Okay. Did that statement impact how you investigated the case?
No.
Did you see that statement impact how your coworkers investigated the case?
No.
Your investigation was focused on who killed Joseph Ryan and Christine Banfield, correct?
That's correct.
And you followed the evidence in your investigation, and that evidence led you to charging decisions, correct?
That's correct.
Okay. Juliana Perez-Maglis was charged because you were able to prove that she shot Joe Ryan. The evidence supported that, correct?
Correct.
Okay. And Mr. Banfield was charged when?
Why do you let a prosecutor do this? I mean, she's having a great time. Like, literally, don't threaten me with a good time. Look at how happy she is. You never want to make a prosecutor this happy, defense. What are you doing? She's just having a good old time. Okay, so you charged Juliana with shooting Joe Ryan because that's where the evidence led you before Juliana even told you shit. And then you charged Brendan Banfield with both murders based on where the evidence led you before Juliana even gave an interview that proffered what happened in the room because that's where the evidence led you, right? JW said, shouldn't he object? He can object all he wants, but it's a proper line of questioning. You've let her have too much fun. Okay.
And the evidence supported that, correct?
Correct.
Okay. And Mr. Banfield was charged when? What was the turning point in your recollection of when Mr. Banfield
Here
was
it goes.
charged?
When we got the blood evidence back.
Thank you. Nothing further.
All right, redirect.
Boom. Don't let the prosecution, well, whatever. I mean, defense stepped right in that. When did you charge Mr. Banfield? When the blood evidence came back. Boom. Look at that following line of cross. So your supervisor said, get behind the right theory. And y'all went, no, that's not how we do it. Thanks for your input, boss. And then. What did we learn from this witness that helped the defense?
Who killed Joseph Ryan and Christine Banfield?
I had to back
correct?
it up one
That's
more
correct.
time.
And you followed the evidence in your investigation, and that evidence led you to charging decisions, correct?
That's correct.
Okay. Juliana Perez-Maglis was charged because you were able to prove that she shot Joe Ryan. The evidence supported that, correct?
Correct.
Okay. And Mr. Banfield was charged when? What was the turning point in your recollection of when Mr. Banfield was charged?
When we got the blood evidence back.
Thank you. Nothing further.
All right, redirect.
Follow the blood.
Detective Smith, were you ever feeling pressure to follow a
Redirect.
theory instead of evidence in this case?
I did not.
You spoke out about it, correct?
Yes.
Did you feel pressure to follow a particular theory? I did not. Ma'am, do you think some of your supervisors are idiots? Because I bet the jury can relate. Did you feel pressured? No. Ma'am, did you get transferred? No. Okay. Don't ask questions you don't know the answer to, counsel.
I did not.
You spoke out about it, correct?
Yes.
Yikes.
Did you feel pressure by command after you spoke out about it?
No, I did not feel pressure. I know what I have to do as an investigator. I know how to investigate, and no matter what they thought or the theories they want to put forward, that was not how I was going to investigate or provide mentorship or counsel to other investigators on the squad.
Did you raise that with other investigators?
I dig her. I dig her. It's giving, no, I'm not listening to what these men tell me to do. Yeah, no, I know what I need to do. I'm not. Yeah, no, I don't feel pressure. It's giving, come at me, bro. I like her a lot. I like her a lot. She's like, I know my job. I'm good. Oh, I like her a lot.
Investigators, the appropriateness of command staff suggesting theories?
Yes.
And did you address that with the group?
Individually as a group, yes.
And who was it that was applying the pressure to you?
She didn't say she felt pressure.
Whoever was in charge at the time, at the beginning, Lieutenant Smuck, who made that comment in the first time.
After March 24th,
She didn't finish her
March
answer.
24, 2024.
It would come from Lieutenant Giaccio and I think at the time it was a Captain Brusch.
Thank you. I have no further questions.
All right, just subject to recall? No? No? All right, Detective, free to go. Thank you.
Thank you.
All right, ladies and gentlemen, since we started a little early, I'm going to go ahead and have our 15-minute recess now. All right, do not discuss the case and do not do any outside research. We'll see you in 15 minutes. Okay?
Well, the court is taking their morning break on day 6, and we have unlocked a new form of what if anything in Where If Anywhere. And the defense called homicide investigator Smith and seemed to be pursuing that the catfish theory was at some point set aside. It wasn't. That the supervisors were pressuring homicide to get on board with the right theory. And that statement definitely raises some eyebrows for me, that in a meeting a week into the investigating of this case, supervisors said there's 2 theories in this case. Get on board with the right one or get behind the right one. But when we got into redirect, the defense asked the detective, did you feel pressured in this case? No. I knew what I needed to do to investigate this case. Did you feel pressured by supervisors? No. Because she said in that meeting, she said, no, we shouldn't have any theories at this point, and stood by it. And she wasn't transferred. And then the defense tried to ask, so when was the catfishing theory put aside? And the prosecutor objected and said, objection, Your Honor, we're here on that theory. And then the prosecutor got up in cross-examination of the homicide detective and said, so you followed the evidence in this case. And with the evidence in this case, you charged Juliana with the murder of Joseph Ryan. And then you followed the evidence to charge Brendan Banfield, Brendon, apparently it's the Bryant of this case, but to charge Brendan Banfield with the murder of Christine Banfield and Joseph Ryan. What evidence led you to that decision? It was when the blood evidence came back. I have no further questions, Your Honor. It was when the blood evidence came back. And then the defense tried to say, but you felt pressured, right? And this witness was like, no. I don't think the jury's going to walk away thinking that Detective Smith was swayed by anyone or anything. Because Detective Smith was giving come at me bro energy in her testimony. And I have no idea what in there helped the defense. I'm going to need you to tell me, chat, did the defense eliciting that the supervisors were like, get on board, sway your opinion of this case more, less, or did her answers at the end answer some questions for you? Why was he charged so much later? Because I think what I'm going to remember from this witness is, why was he charged so much later? Oh, because the blood evidence wasn't back yet. Once they had the blood evidence, they charged him. That's the thing I'm going to remember from this witness. And that her supervisors were trying to tie this thing up in a bow really early on, and they couldn't do it because they didn't charge him. The supervisors are like, get on board. They didn't charge him for a year after they charged Juliana. When you don't have him being charged, Juliana wasn't charged until October. This crime happens in February of 2023. Juliana's charged in October 2023. He's not charged until November 2024. No, September 2024. If the defense is going to try to go rush to judgment, where's the rush? Where's the rush to arrest him? Is it in the room with us? Or is it hiding with counsel's prepared questions? I don't know. All right, they're taking the morning break. Let's zoom past the morning break to more of, well, whatever this is. More of day 6. But I think that that witness helped the prosecution more than the defense. I think that that's not helpful. Oh boy. All right, we're back from the morning break. The jury's taking their seat. We're still at 1.25.
All right.
A lot of you are asking, what about the blood evidence made them charge Banfield? I think it's beyond what the blood expert got into, but the blood evidence shows, one, that Joseph Ryan had Christine Banfield's blood dripped on him, not sprayed on him as if he was stabbing her. And there are some voids in the carpet that indicate where Joseph Ryan's hand was. She wasn't able to get into it. They alluded to it. You can see it, and the jury can make their own determination, but it shows that his hand was down, like top of his hand down on the carpet before his hand was moved onto his body. And the way that the blood is on Banfield's clothes are more consistent with blood dripping off a knife than with him trying to render aid. Among other things. So I think that's some of it, but the jury doesn't have all of that. The defense actually did a pretty decent job in keeping a lot of that out.
Matt Nilssen.
Matt Nilssen.
All right, we're moving on to defense witness number 9. Someone not named Brandon. Hello, Matt.
Raise your right hand. Do you swear or affirm to testify truthfully in this case under penalty of law? I do. Thank you.
Good morning, sir.
Good morning, sir.
Can you please tell the ladies and gentlemen of the jury your name and spell your name for the court reporter?
We're back to spelling.
Matthew Nilssen, Nilssen.
Please
And where are
don't
you
eat the
currently
microphone.
I'm currently employed with the Fairfax County Police Department as a detective sergeant with the Major Crimes Bureau.
Okay. Were you previously in the homicide division?
Yes, I was.
When was that?
I was employed as a homicide detective prior to my promotion to sergeant from approximately February 2023 until what would have been November of 2024.
Okay. So I'm sorry, you were the homicide sergeant at that time.
Counsel, did you count him in the transfers? Because if he got promoted and moved from homicide to major crimes, that's not a transfer that's like a negative thing. Were you counting him in like all these cops got transferred out of the unit? Because getting promoted and moving to a more prestigious unit isn't that.
I was a detective on the squad.
Okay. And then you transferred to where you are now, which is in the homicide division?
I work for the Major Crimes Bureau. I am not the supervisor of the homicide unit.
Okay.
I work for
What areas are you working in?
I supervise the sex crime squad.
Okay. Gotcha. Now, calling your attention to February 24th, 2023, were you involved actively with the homicide that occurred at the Banfield house?
Yes, I was.
Okay. And what role did you play in that?
I assisted beginning on that day with the investigation by handling investigative tasks such as writing search warrants, and then throughout
I'm
the
not
remainder of the
leaving. I'm just-
investigation with tasks that were assigned to
I want
me
to see what George is
by my
doing.
supervisor and other detectives handling the investigation as
seconds.
primary.
Okay, and based upon the time frame that you said you were there, you were still there in October of 23 when Juliana Perez Magalhaes was charged, correct?
Yes, sir.
Okay, and were you involved in that?
Yes, I was.
Okay, was there any sort of planning that went with that?
Yes.
Okay, what was the ultimate goal of charging her with murder?
I would state there were several goals that included the fact that evidence supported probable cause to charge her with murder at that time. But based on our investigation, there was belief that there was more to the story that could be elicited from her. And the effect of charging
I
her
see
with a
where we're going
crime
with this.
was effectively a way to introduce a change in circumstances between her and Brendan Banfield that could lead to the elicitation of more information about what happened.
Okay, so charging her, keeping her in jail.
Well, counsel, see, we had enough to charge her with murder. And so we charged her with murder, and then we hoped that she would talk to us. Okay. George is here. He was, I don't know what he was doing. I think the birds moved away, but George is not going to let me pick him up and say hi on camera. Only Travis gets to do that. George, anything? No? Okay. I tried. Change of circumstances. Okay.
The pressure that would be caused, was that part of the plan?
Yes, in terms of in any type of incident in which you have multiple people involved in
Somebody's got to talk.
the carrying out of that act, there is competing interest between self-interest and cooperation. And by introducing circumstances that would encourage cooperation with law enforcement over cooperation with other parties, it could change the outcome of the investigation, change the amount of information.
You mean like her cooperation with the people paying for her lawyers and putting money on her books and the rest of it? Oh, wait, she wasn't in custody yet. You didn't know that yet. It's real interesting when she goes into custody who's supporting her financially, isn't it?
Available to us as investigators.
Okay, like a plea agreement to a lesser charge and no further jail time, something like that?
There's a number of different ways that could be accomplished. Or the ultimate goal could be accomplished.
And that's ultimately what happened, though. That's what caused the change in Juliana Perez Magalhaes.
My understanding is she did at one point cooperate with detectives. I was not involved at that point in the investigation.
Now, while you were on the homicide squad, were you ever assigned to listening to the jail phone calls?
No, I was not.
Okay. Was that something that was employed in order to determine whether or not she was subject to the pressure that had been intended?
I know that someone was assigned to review those calls, and the information.
The EDB summary of those calls. Baby, I love you. Baby, I love you. Baby, I miss you. Baby, I wouldn't say anything. Baby, I'd ride or die for you. In addition to the other types of frisky phone calls they may have been been listening to. Yeah, that's exactly how those phone calls go. And that's exactly how that went up until he was arrested. And then she was like, oh shit, me or him? I choose me, right?
Learned from those calls was part of our investigation.
Okay. Thank you, sir. I don't have any further questions.
Cross-examination? All right, is this witness subject to recall?
Wait, that was it? Okay.
All right, you're free to go, sir.
Thank you, Your Honor.
Your next witness,
Your Honor, Patrick Brusch.
Patrick Brusch.
That was fast. No cross. I mean, I don't know if anybody is under the impression that that's not how it works with conspiracies. I don't know. I don't know if any of the jurors are sitting there going, wait, you mean when they charged her and arrested her, they thought that she would change her mind? Yeah, you don't normally get to arrest the person at the tip of the spear first. So you kind of work your way up the ladder. We're going to zoom until this witness comes into court.
Raise your right hand. Do you swear or affirm to testify truthfully in this case under penalty of law?
George has taken over my arm.
Good morning, Mr. Brusch.
Good morning.
Can you please state your name and spell it for the court reporter?
John Patrick Brusch, Brusch.
And you previously were with the Fairfax County Police Department?
That's correct.
Okay.
Where you work now?
In what capacity was your final position?
I was the deputy chief
Okay.
of the Administrative Support Bureau. I'm sorry.
Yes. At some point prior to going to the
Administrative support, you say? Administrative support, you say? I have questions.
well, were you transferred from another department to go to the Administrative Support Bureau?
Just for clarification, are you asking my previous assignment before
Yes.
that?
Yes.
Yes, sir. I was the deputy chief of the Major Crimes Bureau.
Okay. And you were transferred from there?
Yes, sir.
Okay. And was that of your own volition?
Yes, sir.
Okay. You wanted that transfer to the Administrative Support Bureau?
Yes, sir.
Okay.
Why?
Now, during your time as deputy chief of the Major Crimes Division, you were overseeing or supervising the homicide squad at that time, correct?
It was one of several squads under the Major Crimes Bureau.
Okay, I'm just asking about the homicide squad. You were supervising the homicide squad.
Could I have permission to clarify?
Yeah, sure.
It was
So
one of
I was
several.
the head of the entire Major Crimes Bureau, which encompassed the Domestic Violence Unit, the Sex Crime Squad, Child Abuse Squad, Robbery, Cold Case, as well as Homicide.
Okay. And
Right.
were you involved or were you in that position at the time of February 24, 2023?
So at that time, I was the captain of the Major Crimes Violent Crimes Division, so not a deputy chief.
And when did you become deputy chief?
I became a deputy chief in January of 2024.
Okay. And did you have contact or involvement in the case that we're here for today?
Yes, sir.
Okay. And how would you describe your role in that case among all the other ones that you were handling?
Overall, my responsibilities are similar for all the cases in the Major Crimes Bureau, to include this one. So it's oversight, it's providing advice as needed, support, guidance, and then also raising concerns in the investigative process if those arise.
Okay. Were there concerns in the investigative process by you in this case?
I think that's fair to say, yes.
Okay. And did it relate to forensic?
Tell me more about that.
Yes, sir.
Okay. And just to get to it, were you involved in the transfer of Detective Miller from digital forensics to child sex?
Yes, sir.
Can
Okay. In
we
fact,
just Counsel, I know it's a picky thing on my end, but can we just use the full title of that unit, please? Short abbreviating that unit is just not ideal at all. But he had issues in this case and was part of the transfer of Brendan, not Brendone, Miller. Let's tell me all about that.
you at one point spoke to,
Objection leading.
All right, I'll sustain us to leave.
what, if anything, did you say to Deputy Chief Freed about Brendan Miller to have him transferred?
I had indicated that as far as I was concerned, Detective Miller was not to work another digital forensic case that pertained to the Major Crimes Bureau.
And were you aware of his history prior?
That's a strong admonishment. Deputy Miller was not to work another case involving major crimes. Oh boy. That's a strong admonishment.
I was concerned, Detective Miller was not to work another digital forensic case that pertained to the Major Crimes Bureau.
And were you aware of his history prior to you making that, I guess, happen?
Could you please clarify?
His work history there in digital forensics?
Was I aware that he was a detective within the division, the bureau? I guess I'm looking.
Well, I'm assuming you were aware of him being a detective in the bureau. Were you aware of his background in digital forensics?
I guess I would have to say no at that point.
Okay. Was that anything you took into account with regard to Detective Miller?
No, sir.
I'm interested to see if at the end of this witness this helps the defense. But what's the impression this leaves you with at this moment? What impression do you have? I decided that Detective Miller was not to work another digital forensics case in major crimes. It's not giving competence. And yet it seems that the defense is trying to rely on Miller's determinations. This seems to be why the prosecution didn't call Miller in it. Oh boy.
And so is it fair to say, or what if anything, or what if any case was the reason that you asked for him to be transferred?
It would be this case that we're here for.
Okay, and what item of this case was it that caused you such concern?
Could I actually go back for 1 second? I didn't say.
What if any case is a new permeation that's been unlocked? We're just speed running. I didn't know that there was a final boss beyond what if anything, but where if anywhere and what if any case seems to be in there too.
That he needed to be transferred. I indicated that he wouldn't work a case for the Major Crimes Bureau. That was Deputy Chief Reed's decision whether or not he ultimately would be transferred.
Okay,
I just said he couldn't
you
work
as
with
the
us.
Head of you're the deputy
I didn't
chief
say
of
transfer
the
him.
homicide or the Major Crimes Bureau.
I'm just not dealing with your
By
shit.
saying that, you essentially caused the transfer.
Judge, I'm going to object to his characterization of the evidence. Objection is to form. The witness has testified that at this point in time, he was the captain of major crimes when the decision was made, not the deputy chief.
No, he didn't say that.
Is that correct?
I was the Deputy Chief of Major Crimes when I made that
Sit down, counsel.
statement.
Okay, and when you're the deputy chief, you make that kind of statement, especially with major crimes, that gets things moving, correct?
I certainly acknowledge that had influence on his transfer.
Okay, and his transfer was classified as performance management. Do you know that term?
I didn't know that that's what his transfer was classified as.
Okay, have you ever heard that term?
But we have a performance management document.
Okay, but not a doctrine that allows transfer without documenting discipline?
I couldn't comment on that.
Was there discipline as associated?
I don't know what corporate consultant worked with this police department, but performance management is giving, this is not the right fit for you. You're gonna go do something else. It's not giving Proctor, a whole different thing. It's giving yeah, no, digital forensics is not your area, right? Like you're just not doing what you should be doing. Kind of like the accident reconstructionist in Reed, who's just like, well, the crime scene just kind of spoke to me. Yeah, performance management would be the thing.
With this decision?
Not that I'm aware of.
Were you disciplining him by moving him out of your area?
Absolutely not. I actually retained him in the child exploitation unit.
Okay, so where he is right now.
Yes, sir.
Now, calling your attention to immediately after the killing of Christine Banfield. Were you in meetings at that time when you were a captain?
Yes, sir.
Okay.
It's also interesting that he's like, no, I don't have an issue with Miller. I have an issue with Miller doing digital forensics. I retained him in this other unit. Just not doing that. You're just not doing that. That's not for you. Interesting.
Were you involved with any theories relating to the case after the killing?
I'm sure at some point.
Okay. Do you know what catfishing is?
Yes, sir.
Okay. Was that something that you were pushing with your homicide detectives at any point?
I wouldn't characterize that as pushing.
Okay. Would you tell them that this is the theory? Is that not pushing?
So I had a specific meeting with then Lieutenant Harrington. I believe it was in November of 2023. I was asked by the two commanders, Lieutenant Matthew Lewick, as well as Lieutenant Aaron Weeks, to meet with Lieutenant Harrington. During that time, I actually proposed 3 separate theories to Lieutenant Harrington. And we discussed those theories at that time. So
what
there was
are
not
those
only
theories?
one theory I was pushing, or presenting, I should say. Ultimately, I was looking for an objective and comprehensive analysis of all the facts and evidence in this case.
And when the catfish theory came up, had there been a collection of all of the evidence, all the digital forensics, fingerprints, DNA, all those things?
Just like with any investigation, it was fluid.
Okay. Had that theory of catfishing come out before any of that was finalized?
I'm sorry, could you go back to the things you had listed?
DNA, digital forensics, and fingerprints.
The digital forensics,
Also, it was fluid, tracks quite a lot in this case.
for the most part, had been back at that point.
What time frame was that?
And that would probably be the spring of 2023
Okay, so
to fall of 2023.
So my question is, within weeks of the killing of Christine Banfield, did you suggest the catfish theory in a meeting of the homicide detectives?
I don't recall ever being in a meeting with homicide detectives. I do recall talking to my command team about that possibility.
And who was your command team?
Lieutenant Weeks as well as Lieutenant Luke.
Okay, and
Excuse me, counsel. He doesn't talk to the investigators. He talks to the bosses that talk to the, he's the bossy boss who talks to the bosses, and then the bosses talk to the people. He's at the top of the command chain. So he's like, no, I was not in a meeting with everybody. I just talked to, no, I was not. I was the bossy boss of the bosses.
where was Lieutenant Giaccio there at that point?
He was not.
Okay, but you brought him in, correct?
That's correct.
Okay, and that was March of 2024?
That's correct.
And it was at that point that you had decided that catfish theory was?
Objection leading.
State as the leading.
What, if anything, had you concluded about catfish theory at the time that Lieutenant Giaccio was brought in?
I hadn't made any conclusions at that point. Did I have a strong working theory that this was a catfish? Absolutely.
Okay, and was that something that you told Lieutenant, I guess, Giaccio when he came on with you?
I don't ever recall explicitly having that conversation. I think he probably came to that conclusion on his own.
Okay, but the two of you were pretty close in terms of the investigative issues, correct?
Yes, we were.
So, counsel, did you call him to just testify about why the prosecution's correct? Okay.
You were both in narcotics together at one point?
Yes, we were.
And you brought him in to major crimes, correct?
I did. That was a collective decision amongst my command team.
Okay. And so is it not true that you insisted you had to have Giaccio come in March of 2024?
That is not true.
Okay. Were you aware that he was on the Brady List?
Yes, sir.
Okay. What's the Brady List for the ladies and gentlemen of the jury?
It's basically an indication of a time or a potential in where you weren't totally forthcoming.
So truthfulness?
It could be.
But that's essentially the basis of the discipline in the police department, truthfulness, correct?
I think that could vary as well.
Okay.
Ethics, not necessarily truthfulness, so it varies.
But at the time you hired him into that division, he was on the Brady List, correct?
I did not hire him.
Okay, at the time that you asked him to come in and be a lieutenant in your section.
So could I have an opportunity to explain the transfer process?
Judge, I think at this point in time, I would object. I'm not sure the relevance of a non-testifying witness's being on
Brady
the Brady
status?
list.
Oh, I think we've already established.
No, he wasn't. He had already been hired. He was transferred into the unit despite being on the Brady List. Okay.
That if you want to move on from that.
Yes.
Okay.
Which means they didn't think it was a big issue.
At the time that he was hired, he was on the Brady List, correct?
No.
When he was hired by the police department?
No, by you.
It's a transfer, counsel. It's a transfer. You don't get hired. Oh, fuck.
As a lieutenant within major crimes.
Again, I'd have to explain the transfer process.
He was not
March
hired.
24, was he on the Brady's list?
Yes,
Okay. And this is a 2024, March of 2024.
correct.
And has he been put on the Brady List again during this time?
Objection is to relevance.
What's the relevance as to this time?
Judge, it goes to truthfulness, which will ultimately come in.
It's not this witness. If Giaccio or whatever is going to testify, then Giaccio can explain why he's on the Brady List. Also, the defense was telling the judge like a day ago, Your Honor, they didn't call any homicide detectives. Maybe this is why. Okay.
To the decisions to have him involved, the decision to
At this time, I'll sustain as to at this time.
Okay. Now, sir, you indicated that you decided that Detective Miller was not going to be, I think as you said, involved in any other major crimes while you were there.
Any of the digital forensics for the major crimes cases, correct.
And then he was transferred.
Within weeks, I would say, yes, sir.
Okay. And
Well, yeah, that makes sense.
what was your basis for that?
So there
Oh,
were
dear.
a few factors. Would you like me to expand on this?
Were they related?
Oh, I would love you to expand on this. Did you think all his conclusions in this case are wrong? Because the defense is trying to rely on Miller, and it seems like that's about to just get blown out of the water. You sunk my battleship style, so I would love to know.
Related to this case?
Yes, sir.
Exclusively related to this case?
Yes, sir.
Okay. Was it related to his work product?
Yes, sir.
And were you talking about the executive summary work product?
That was part of it.
Okay. And
Oh,
so
boy.
his conclusions were not agreeable to you?
I wouldn't word that way.
How would you word it?
I would word it that his analysis was incorrect.
Okay. And at that time when you determined his
Okay.
analysis wasn't correct, had you had any training in digital forensics?
I have my master's in computer forensics.
Okay. So did you look at some of the items of evidence?
I'm sorry. Counsel. Stop. Counsel, if you don't prepare the witnesses, then you don't know what answers are coming. There's no way the defense knew that that was going to be the answer to this question when he asked it. There's not a chance that the defense prepared this witness. There's not a chance. I have a master's in digital forensics. Oh boy. Don't ask questions that you don't know the answer to. It's like, and how are you evaluating his work? Sir, that's what my master's degree is in. What are the chances? That's really funny. His analysis was incorrect. And what experience do you have in digital forensics? More than him, as it turns out. I had to rewind. That's funny. That's funny.
Agreeable to you?
I wouldn't word that way.
How would you word it?
I would word it that his analysis was incorrect.
Okay. And at that time when you determined his analysis wasn't correct, had you had any training in digital forensics?
I have my master's in computer forensics.
Okay. So did you look at some of the items?
I have my master's in computer forensics. Whoop, there it is.
Of evidence in order to arrive at that informed decision?
So he had provided me a zip file of a Cellbrite, but that wasn't able to be downloaded.
Okay. So you didn't really review anything in order coming to that conclusion?
Well, I can get into the specifics if you'd like me to.
Well, I'm asking some questions right now and perhaps we'll get.
Oh, stop asking permission. It's direct. Just start cramming those answers in there, sir. Don't ask him. You're not on cross. You're on direct. You get to just answer. Just answer it. Just let us know. Make the defense, who chose to call you as a witness on direct examination, make them object to your answer to their question. Because we haven't seen that in this courtroom in a minute. And I believe that answer was also about a cat. So, why not?
There.
Okay.
you didn't actually check the source of his findings. with the
Objection leading.
What, if anything, did you do to check the source of his findings, the digital forensics?
I didn't conduct my own digital forensic analysis, if that's what you're asking.
Okay, and I think you said you couldn't get into the portable case when you were given to.
The zip file of the Cellbrite, correct.
Okay, and so what would be the reason that you would differ from your expert's opinion?
Oh boy.
Because of some of the unsubstantiated deductions that he made.
Oh
Okay,
shit.
so it's based upon his decisions relating to his digital forensics expertise.
So
This continues to get worse for the defense. The unsubstantiated conclusions. Oh, man. What did you disagree with? His unsubstantiated conclusions? You mean the conclusions that the defense is trying to rest their case on? Those conclusions? Huh.
What would be the reason that you would differ from your expert's opinion?
because of some of the unsubstantiated deductions that he made.
Okay, so it's based upon his decisions relating to his digital forensics expertise.
So the deductions and the wrongful analysis.
Okay, so
Oh, it gets worse.
decisions.
I wouldn't use that word. I'd say deductions and wrongful analysis.
Okay, and the wrongful analysis
Wow.
relating to the actual digital forensics that were downloaded?
Some of them, yes.
Okay, and did you ever go over those with him in detail?
I would ask clarifying questions.
Did you tell him exactly what it was that you disagreed with in terms of his deductions and his analysis?
I think a couple of them, yes.
Okay, how many, so.
How bad
many
was
were
it?
there in total?
Off the top of my head, I could probably list at least 4.
Okay.
Oh, boy.
And so it was based on that, based on your reading of his executive summary, that you decided that it had gotten to the point where he's no longer doing any more major crimes under your tutelage.
Digital forensics for major crimes cases. I retained him as a detective within the Major Crimes Bureau
understand
Child
that.
Exploitation Unit.
I understand that. The digital forensics section.
He was not going to do digital forensic analysis for any other major crimes case.
Okay. And
Okay. Well, even though the prosecution didn't call this witness, I'm locked in. For the first time in the defense case, I'm locked in. I'm locked in. We've gotten to Detective Miller was removed from digital forensics, retained as a detective, but removed from digital forensics in part because of his unsubstantiated deductions and wrongful analysis. What was Miller's analysis? Well, it seemed that a lot of it was that Christine Banfield was the one using her devices. Oh, boy. Mm-hmm. Oh, I thought I had unpaused and he's just blinking at the defense attorney and I didn't realize it was unpaused. Okay.
sorry, bear with me for a second.
No. It is unbearable, counsel. But we're invested in this witness. And I'm very curious about more than defense counsel sniffing.
Were you aware that his work was peer reviewed outside of the police department?
What?
I was.
And were you surprised to see that they concurred in his findings?
I have a question to clarify. Did they concur on his extraction or his analysis?
Both.
That's news to me.
Okay, so that peer review held no weight for you because you had already decided that the analysis was wrong.
Objection leading.
All right, sustain as to leading. You want to rephrase?
Why was it that the peer review did not hold any weight for you?
Because ultimately the analysis was incorrect.
Okay. Now,
Oh, shit. I really am beginning to wonder if the peer review was on the extractions or not, because nobody has said that anything was wrong with the way the devices were extracted or the data on the devices. Everything we have heard is that the conclusions derived from that data is the problem, but the data itself is not. So if they peer reviewed the extraction and said, oh, we extracted it fine, that makes sense. Yeah, the extraction was fine. Nothing was altered, manipulated, changed, deleted. And he's like, Oh, so the peer review thought the analysis was fine? News to me. Because the analysis was incorrect. Okay. Okay. Ah. This witness is not going
In
to
terms
just
of-
acquiesce to the defense's questioning here on direct because they called this
In
witness.
terms of the Cellbrite messages that you say you reviewed, what was
He
it
didn't
that was
say
the
he
problem
reviewed
with
it.
those?
The Cellbrite messages that he had provided,
Yes.
I wasn't able to open the zip file.
Okay, so we don't know anything about the Cellbrite messages as to your decisions on his analysis.
Celebrite doesn't have messages. It has an
Were
extraction.
you privy to a printout of his communications on FetLife?
Yes.
Okay. Were you privy to the communications from Telegram?
Yes.
And
Cherry Bottas, I think, in the chat, and I apologize if I pronounced it wrong, since all the user handles have changed on YouTube, it's been a struggle. Over under on prosecution saying no questions, not a chance. Not a chance. The prosecutor is going to ask all of the leading questions with glee about how wrong Miller was and how correct the catfishing theory is that they are in trial on. Yes. No. The prosecutor is going to have the best time.
do you understand how those were obtained?
Through the digital forensics.
Do you know how that's done?
It's essentially tied to software that then downloads both from a cell phone and or laptop or any digital device.
And did you review that data?
I didn't review all the data, no.
What data did you review?
I reviewed the correspondence.
I'm sorry, the what?
The correspondence on Telegraph, the correspondence on
Okay.
FetLife. There's a significant amount of data when they download these items.
Okay. Now, are you still working as a police officer?
I'm not.
Okay. On July 10th, when we were here before the court, you had just moved to the Administrative Support Bureau, correct?
I moved there in February of 2025.
Okay, so, but that's when we found out you had moved, or I found out that you moved to the Administrative Support.
Objection, counsel's testifying.
That's not the proper legal objection,
Correct.
but
I can't testify to that when you found out I was
Okay,
moving.
on the 10th, we talked about this, correct?
because it calls for speculation. Where did you go? And why?
Yes.
And how you had enjoyed this position and you were really looking forward to, you know, the things that happen in an Administrative Support Bureau, and the challenge of not having, that's being in more of an administrative role than being in major crimes.
I would agree that it was a completely different assignment than I'd had throughout my entire career.
And that's something that you sought, correct?
Correct.
Isn't that what you said?
Yes, sir.
And it's something that you're really excited about, correct?
I don't know if I'd say really excited, just
Well, when you were here on the 10th, you said that you were very interested and excited about your new
So
challenge.
happy with
sure.
Okay. And when did you retire?
July 25th, 2025.
When did you put in your retirement paperwork?
July 11th, 2025.
So the
So you got transferred into administrative support, which is normally where people go when they're in trouble. There have to be bosses, of course, but normally administrative support is where people go to sit. Like before Proctor was taken off of duty, you go to admin support. Like you go to the desk, but you're in court July 10th and you put in your papers on July 11th after a new transfer in a pretty cushy position. What happened? Huh. I have questions. I have so many questions.
Friday after the Thursday that we were in court here?
Correct.
Okay. So what happened, if anything, about the excitement with the Administrative Support Bureau?
Yeah.
Judge, I would object and ask to approach.
I mean, counsel's probably right, but what the fuck happened? Huh. That's That's odd. I'm curious if we're going to get any answers on that, because we might not. Why is the feed being feisty?
So why did you retire one day or put in your
Oh, I'm very curious.
retirement paperwork one day after the hearing that we had here on July 10th?
For personal and professional reasons.
Okay.
And what are those?
You're no longer a police officer.
I'm not.
And
Sir, I'm going to change. Back here for a little while. Your Honor, I think we have ID 91, so 92 would be the next.
All right, yes, sir.
I'm curious if he planned on retiring when he went to administrative support. But I'm curious. But I have questions. And I guess that's the point, is I have questions.
Sir, if you can look on the screen in front of you, are you able to see this communication?
How long was he in admin support? I've already
Yes.
forgotten.
Okay, and who is that communication between?
Director Fayez.
Okay, and Director Fayez, who is that?
She's the Director of Victim Services.
Okay, and was she someone that was within your command structure?
Yes, sir.
Okay, exactly where does that fall in the major crime?
And then he moved on.
Command structure.
She's part of the command team.
Okay, so would she be involved with?
It could be medical.
Command staff meetings?
Yes, sir.
Is she supposed to be there?
Yes, sir.
Okay, so here we have, it looks
Yeah,
like.
it could absolutely be medical.
Counsel,
Thanks,
go back
Chad.
to the microphone. The jury won't be able to.
Sorry.
Chad said went to admin support in February, retired in July. I mean, it would not be the most unusual if there was a medical reason to do that. The timing with going to court and then putting in the papers is odd. I don't know if it's a coincidence. I don't know. I'm just curious, and I don't know if we're going to know.
Yes, I can.
Okay, looking at the exhibit that's going to be identified as Exhibit 92, do you recognize that?
Yes, sir.
Okay, and there's reference to a jail call. Is that you or is that someone else?
They're responding where it says my name.
Okay, and so who else was on this thread?
I believe it would have to be, based on the response of one last favor GI, would be Lieutenant Giaccio.
Okay, and so it was the three of you.
Really curious.
And you agree that's a communication that you had with all three?
Yes, sir.
Okay, Your Honor, I move that as Defense Exhibit 92.
Any objection?
Judge, it contains hearsay statements. Two of those individuals have not been called to testify.
All right.
I'll identify
ID
it,
it?
Judge,
Okay.
and we'll get to it later, and
All
that's
right, ID is 92.
92.
A lot of you are asking if it was medical, why wouldn't he just say it? I don't know how old the witness is, but depending on what the witness is doing next, not every employer takes kindly to medical. So it might just be because he doesn't have to say any more about it, but I don't know. I'm not going to speculate on it. I don't know. I'm curious. For sure.
Sir, do you see that on the screen?
Yes, sir.
Okay, and it looks to be three people.
That's correct.
Okay, and who are those three people?
Based on the text message, it would be Chief Kevin Davis, myself, Director Fayez, and Lieutenant Giaccio.
But now I'm stuck on that and I have questions.
And the date of Friday, October 25th, 7:32.
Correct.
Does that have significance for you?
I believe that's the date that Juliana proffered.
Your Honor, can I identify this as Defense Exhibit number 93?
93 identified as 93.
And I'd move that into evidence?
Objection contains hearsay.
All right, sustain as hearsay at this moment.
I'll just identify it,
Okay.
Your Honor.
There's no way the defense is going to keep track of the things marked as identification and the things he actually got into evidence. We saw that yesterday. So this is from what? The date right before Juliana, the date is the day Juliana proffered? Okay.
Sir, do you see what will be identified as defense exhibit number 94?
I do.
Okay, and is that a message group that you were involved with?
Could you just give me a second to read this, please?
Absolutely.
Where are the messages from?
Yes, sir, it is.
And this message that you sent
Are these group
is
texts?
on October 25th, 2024, correct?
Correct.
And the same significance as the previous message?
Are you saying this day of the proffer?
Yes.
Yes, sir.
Okay.
Counsel keeps calling them messages, but are they group texts?
Have I identified this one yet?
You identified it as 94.
94. I'd move that into evidence, Your Honor.
Same objection.
Objection.
All right, I'll sustain the objection at this point.
Okay,
It is
I'll-
ID as 94.
ID is 94. Thank you.
How are we making group messages painful? I'm going to have to back up. Because he was talking about jail calls. Chat, thank you for allowing the replay, because I'm still stuck on the quickness of the departure and I missed it. So I'm gonna replay real quick to reorient and try to focus, and then I'll zoom past it. I'm very curious as to what he's asking about.
3 people.
That's correct.
Okay, and who are those?
Hold on, I missed a question there. Oh no, I didn't. Sorry, chat.
Sir, do you see that on the screen?
Yes, sir.
Okay. And it looks to be 3 people.
That's correct.
Okay, and who are those 3 people?
Based on the text message, it would be Chief Kevin Davis, myself, Director Fayez, and Lieutenant Giaccio.
And the date of Friday, October 25th, 7:32.
Correct.
Does that have significance for you?
I believe that.
Part of the problem is that the defense's questions are so bad, it's hard to know where the fuck we are in anything, and it's painful.
That's the date that Juliana proffered.
Your Honor, can I identify this as defense exhibit number 93?
All right.
93 identified as 94.
So witness said based on the text, this is from the date of the proffer, October 25th, 2024. It's identified. It's not being marked in to evidence because there's hearsay in it as to the other people in that group text.
I do.
Okay, and is that a message group that you were involved with?
Could you just give me a second to read this, please?
Absolutely.
Okay. We're back where we were.
Yes, sir, it is.
And this message that you sent is on October 25th, 2024, correct?
Correct.
And the same significance as the previous message?
Are you saying this day of the proffer?
Yes.
Yes, sir.
Okay. All right.
And?
Have I identified this one yet?
You identified it as 94.
94. I'd move that into evidence, Your Honor.
Same objection.
Objection.
All right, I'll sustain the objection at this point.
Okay,
It is
I'll-
ID as 94.
ID is 94. Thank you.
Oh boy. We're still on 1.25 speed, chat. We're still on 1.25.
I can.
And I'd identify this as Defense Exhibit 95. There are a number of people
We've gotten more sniffles than actual questions at this point.
involved in this message, correct?
It appears that way, yes, sir.
And the names there, does that match up with your memory?
Could I review this as well?
Of course, of course.
I've reviewed it. I don't recall this correspondence, but my name is certainly on it.
Do you have any idea who is writing in the blue boxes,
I can't tell.
even by the discussion?
Well, my issue with being able to tell is that the banner, it's very small initials.
Okay.
Okay.
Your Honor, I think I've identified this as 95.
That's correct.
Okay. I'll ID this and
Okay.
come back to it.
Yes, sir.
So who's in the blue text bubble? IDK is the answer.
Defense Exhibit 96. Take some time to read it.
We're sped up and this is painful.
Lieutenant Giaccio?
Defense asks, is that a correspondent with you and Lieutenant Giaccio?
I couldn't say. I see my first name up at the top.
Okay. Your Honor, I'd move to admit that as
There's no
Exhibit
foundation for that.
96.
Judge, two objections, hearsay, and it has not been recognized by the witness as having been his statement.
Sustain the objection. It's just ID is 96.
Hearsay and
this point.
foundation.
Sir, please look at this message. This is going to be identified as Defense Exhibit 97.
I'm
If that's
zooming.
me as Patrick and or who this correspondence is with.
Okay.
Again, he's like, I don't know.
Let's talk about that. PB, Patrick, that doesn't show up on your text messages?
Well, it appears that this is with somebody else, so it's what appears on their text messages.
Okay, so do you have any idea, based on the content of it, who that person would be?
Are you asking me to take a guess?
Do you know? I want you to conclude who that person is. Can
He's
you do
like,
that?
I have no idea.
I can't definitively say who that's with.
Okay. Your Honor, I would move that in.
No
as
foundation.
Or Defense Exhibit 97.
Same objection.
All right, I'll sustain the objection, but ID is 97.
No foundation.
97. Your Honor, is that
That
right?
was 97.
Okay, okay, thank you. What will be marked as Defense Exhibit number 98? Please read it.
The initials PB. I don't recall this correspondence.
Your Honor, I'd move into Evidence Exhibit 97.
98.
98, same
sorry.
objection, Judge.
All right, I'll sustain the objection. ID is 98.
Just if we're keeping up, it seems that he's showing the witness a bunch of group texts or text messages or snippets of text messages. And he's marking them for identification. There's no foundation for them as to this witness. He's like, I don't know if that's me or not. I don't know where these are from. I don't remember. And the defense is like, move them into evidence. And the prosecution's like, nope. And the court's like, correct, nope. So the jury is sitting there watching things that may be text messages get shown to this witness. They can't see them. And being asked, and he's like, I don't know, over and over and over again. Tell me if you recognize this message.
Defense Exhibit 99.
All right.
Correspondence. Again, I see that my first name at the top, the initials. I just don't recall this correspondence.
Your Honor, move in
Nope.
Defense Exhibit 98.
99.
99, objection, Your Honor.
99, sorry.
Sustained, just ID is 99.
You have any recollection, based upon your review of the content of these messages, as to whether or not that's yours?
This I do recall. Yes, sir.
Okay.
Really? We've got
and
one.
Were you the one who wrote about Klingon and Kelsey and not holding off on bringing Klingon and Kelsey?
Objection is to counsel's reading the documented evidence, but it's not being admitted.
All right.
Just trying to identify which message.
All right. Well, you can have, just point to it. That's
Which,
the same objection.
I'm pointing to that one right there. Is that you, or is that the person you're talking to?
Based on how this is presented, that would be me.
Okay. And in that message, you're talking about Eric Klingon, the prosecutor, correct?
Yes.
And Kelsey.
So the former prosecutor on this case, I think they talked about that a little bit yesterday, that there was another prosecutor on this case. Okay. I just feel like everybody in this conversation knows what they're talking about and none of the rest of us do. And I hate it. I hate it so much. It's like when Real Housewives are fighting over shit that didn't happen on camera and nobody knows what's happening. They all know and we don't know. We're like, what are we not seeing? It's so frustrating.
About Eric Klingon, the prosecutor, correct?
Yes.
And Kelsey Gill, the prosecutor?
Yes.
Okay. And whomever you're speaking to, you're saying, hold off on.
Objection. It has not been admitted into evidence. Counsel cannot read what is written.
I'll sustain that objection.
Okay, Your Honor. I'd move this into evidence as Exhibit 100.
And again, Judge Commonwealth would object. It contains hearsay.
All right, I'll sustain the objection, but ID is 100.
Okay.
So again, it's
Sir,
not coming in.
This is going to be identified as Defense Exhibit 101. Do you recognize that message?
He's got 99 problems and foundation is at least half of them.
Do you know if that is your?
He said, I don't
communication?
recall that
You don't
specific
remember the
message.
Content?
I don't recall.
Your Honor, I'll hold this as identification
101.
before moving in.
Okay.
101.
I am trying to scoop.
Yes, sir.
Okay.
I'm trying to like boot, scoot, and boogie past some of these things, but this is painful.
And do you know who you were communicating with?
Lieutenant Giaccio.
And which color of the bubbles are you communicating on?
Gray.
And this is Friday, October 25th. Well, tell me the date. What does it say?
It says Friday, October 25th.
Okay, and what's the significance of that?
That's the date of Juliana's proffer.
Okay. Your Honor, I'll hold off and
All right.
move that.
That's
This is 102.
ID is 102.
This message that's before you.
Yes, sir.
Okay, we're on
And is that a
103.
message that you participated in?
Yes, sir.
Okay, and are you in the gray?
Yes, sir.
Okay. Your Honor, this would be identified as Defense Exhibit 103.
All right.
He didn't say who
103.
the message was with. but-
Identified.
Now, sir, in your communication, you reference someone else in the fourth grade communication down. Who is that person?
That's Director Fayez.
And Director Sally Fayez?
Correct.
Okay. Your Honor, it's identified as
Identified as 103.
103.
Yep.
This is painful.
Participating in?
Yes, sir. I'm again in the gray.
Okay, and
We're on 104, I think.
second box, those are your words?
Yes, sir.
And these are your words?
Yes, sir.
The jury
And do you
can't
know who you were
see,
speaking with?
the jury can't see anything because none of them are in evidence. So when he's like, is this your words? Are those your words? They can't see what he's talking about or what he's pointing at. They're just sitting there going, is anyone going to tell us?
Lieutenant Giaccio.
Okay. Your Honor, I identify that as 104 and we'll move in for.
All right. Identified as 104.
This is Defense Exhibit 105. Do you recognize that?
Yes, sir.
And are those your words?
Yes, sir.
And who are you speaking with?
Lieutenant Giaccio.
Your Honor, I'd identify and move to be admitted at a later time.
Okay. So just right now, it's identified as
Marked.
105.
A number of you are asking, what is a proffer? We're going to take a moment from the mind-numbing pain of this. The proffer is the first conversation that the co-defendant had with law enforcement and prosecutors to say, okay, I'm going to tell you what happened. If you're offering me a deal, I'm going to tell you what happened, because here's the story. So that first interview that she proffered what she would testify to is the proffer. The defense kept calling it the recant, but the proffer would be, if I were to testify, this is what I would testify to. Generally, the agreement going into a proffer, because otherwise a defense attorney would never let it happen, the agreement going into the proffer is that if they are not able to work out a deal, then the proffer cannot be used to prosecute either individual. So if you sit down and say, this is all the information I have, and the prosecutor says, bet, we want you to testify, here's the deal we're willing to offer you, then they can use what's said in the proffer and that individual's testimony. But if they get done at the proffer and are like, none of this is helpful for me, we're not going to use you to testify, they can't use what you say in that proffer against you or against anyone else. So it's negotiations. It's the jumping off point. So that's what they're talking about with the proffer.
I'm going to identify this as Defense Exhibit 106. Do you recognize that communication?
This is painful. We're in
I do not.
1.25. That's how long
Are you not a
these
participant in
pauses
this?
are.
I don't know if I am. I can't tell.
Okay. Your Honor, identified as 106.
The judge is like, okay, zoom, my guy. Let's zoom. Let's zoom.
Sir, I'm going to ask you to identify what will be marked as Defense Exhibit 107. Are you involved in that message?
I don't believe I am because I'm referenced in the third person. So if you see the second gray box down, wasn't for your leadership and Brusch believing in you. I don't refer to myself in the third person.
Okay, but you don't remember it if, in fact, you were included in this?
I don't recall.
Well, we know it's in that text. For Brusch believing in you, he's like, I'm not there.
Okay. Your Honor, I'd move that. I would identify it as
Identified as 107.
107. Quite frequent and with the same group of people. Is that correct?
Nope.
I guess.
I mean, would that be your, a group that you rely on for discussion about the case?
Certainly people I was in text communications with.
Okay. And the text communications that we know from what we just saw were what you told us, Lieutenant Giaccio and Sally Fayez, Director of Victim Services, correct?
Well, there was definitely other ones where you had group people on there as well.
Right, but we didn't identify them.
What?
I think there was one line that said Dan Spital in there as well.
Okay, was he part of your command staff?
Yes, he was.
Okay, and were there anybody else that you saw in there?
I believe Tom Harrington was on one of those
Was
threads.
he part of your command staff?
Yes, sir.
Okay, and anybody else that you saw there?
I don't recall. I have to go through those again.
Okay. Your Honor, court's indulgence.
All right, yes, sir.
No. The lack of organization is just killing me. Oh, he's conferring with his client. I mean, honestly, at this point, counsel, your client might have better questions. You could have met with these witnesses. You could have prepared these so that the messages that you were showing to the witness were messages you knew that you could show were his. But here we are back on the stand. Have we learned anything from these text messages? Not yet.
Your command structure, who is below you
As in how would it
within
appear?
homicide? Yes.
That's
My command
not
structure would have
accurate.
been myself to Major Spital.
His command structure, because his unit was in charge of like multiple units, it's more like an org chart than a ladder.
Then underneath him would have been Captain Harrington, Captain Bobel. Let me clarify. I assume you're talking in this 2024 timeframe.
Yes.
Yes. And then the direct report to Major Spital. I think by the way the diagram was, as I best recall, would have been Director Fayez.
And so Director Fayez had a direct report. Major Spital had a direct report.
Yes, I was his direct report.
And is that something that's put into the structure that was set up?
Could you clarify what you're asking?
Well, are you the one who's asking for the direct reports, or is it just based upon their position that they're?
It's based upon their position.
Okay. Was Lieutenant Giaccio ever a direct report?
He would have then been underneath, at the way it was structured, Captain Bovell.
Okay. Was there ever any concern by the people in your command staff regarding Lieutenant Giaccio directly reporting to you?
Yes, sir.
Okay. Was that an issue that you had to deal with?
It wasn't an issue for me.
Okay. Well, in a command structure such as yours, who would Lieutenant Giaccio have to go to if he wasn't a direct report?
I think I'd like to be careful about the word have to. It's a command structure. So there is a hierarchy, and I would be at the top of that hierarchy.
Okay. And would you be the person who would give him permission to bypass the others to get to you?
I could.
Okay. In this case, specifically this case, did you tell him to come directly to you and bypass the others?
I did not tell him to bypass the others, but it was known that he would be reporting directly to me.
Okay. So you gave him that assignment, and then he just took it from there without talking to the others?
I actually spoke to the others. They were part of my command team.
Okay. So you then disseminated whatever he said to you directly?
Yes.
Okay. Now,
For those of you just joining us, court is still closed in Fairfax County today. We are catching up on day 6. Why? Because apparently we're in to just see what's happening while we're all, while the roads are icy
when
and
you
we're
came into
stuck at home. We're just
your position as deputy chief,
snowed in together
well, were you told to clean up the homicide division?
to see how
No,
bad
sir.
this is. This I'm curious about. Were
Did
you told to clean up?
tell anybody to clean up the homicide division?
No, sir.
Were you aware of anybody saying that they were here to clean up the homicide division?
Objection as to relevance.
Overruled. Answer.
I'm very curious about cleaning up the homicide division. Very curious.
No, sir.
Counsel, wouldn't you know where you're going with this
Good
cross?
gentlemen, further questions?
All right.
Oh,
Examination.
God, that was awfully painful. I said cross. I didn't even mean cross. That's his witness. That's the defense's witness. But the thing is, the defense asked a lot of information that was damaging to his case and not a ton of information that clarified anything. But what the defense elicited from this witness is odd timing on a retirement that I have questions about. Sure. Group texts that seem to reference the prosecutor. And honestly, if they're group texts saying that the prosecutor that offered Juliana time served is a motherfucker, I don't know if I would be all that offended by that. Honestly, I'm real curious what they say. Cops and prosecutors don't always get along. They don't always see eye to eye, and they're not always happy with the way things go down. The cops don't get to help, and they don't get to make that decision. And then he said that the digital forensics done by Miller had wrong conclusions. Okay. Curious what cross is.
Good afternoon.
And we're on cross.
So are we to understand that you were involved?
Did he not respond to the good afternoon at all? Huh. Okay. Did you see the look? Good afternoon. Oh, interesting.
Good afternoon. So
Oh,
are we
shit.
to understand that your involvement in the Banfield investigation was as a supervisor only?
As a commander, yes, ma'am.
Okay. And you did not collect any evidence in this case?
That's correct. I did not collect any evidence in this case.
Did you direct that any evidence be ignored?
No, ma'am.
Huh.
You spoke about Brendan Miller and your concerns about his work. You specifically made the statement that he had unsubstantiated deductions. Is that correct?
That's correct.
Was one of those unsubstantiated deductions recorded in his executive summary that Christine Banfield was the operator of her devices when interacting with the FetLife account?
That's correct.
Okay. And was it that type of unsubstantiated deduction that caused you concern?
Exactly.
Okay. Did you do anything to change his report?
Interesting. So one of the unsubstantiated deductions was that Christine Banfield was the operator of the account when interacting with FetLife. Okay.
Never.
And did you do anything to change the evidence that he had collected that he believed substantiated his report?
Never.
Judge, I don't have any further questions on this.
Redirect. I'm sorry, could you?
I had one other exhibit that I neglected to introduce.
All right. Do you have any objection to him? Just, he has one more.
No, you're
text
asking
message.
questions, certainly not.
That's fine. Okay, go ahead.
And he's reopening because he forgot one.
It would be 108, Mr. Carroll.
108, yes.
So this is redirect.
Let me just, I'll do my cross and then.
Okay.
No, you're not doing a cross. You're on redirect. He's doing redirect and he's being allowed to reopen, essentially direct to let in another exhibit. The prosecutor didn't object to it. You're not doing your cross, sir. Though the problem is we couldn't really tell the difference when you were because your cross wasn't leading questions anyway.
Would be 108, Mr. Carroll.
108, yes. Let me just, I'll do my cross and then, or my
Redirect.
Mr. Brusch, the word unsubstantiated can be a difference of opinion in digital forensics, right? Correct?
I guess it would depend on how it applies.
And your statement that it's unsubstantiated was in conflict with your digital forensics expert statement that she was in control of her devices on the FetLife communications, correct?
I don't know that I agree with part of that statement.
Oh boy.
Okay, which part?
So there was a conclusion that Christine Banfield was always in the possession of her devices. The crime scene definitively
Relating
demonstrates
to
that to
FetLife,
be
which is what she
incorrect.
asked.
I'm very curious about this, and though it's going to be painful and I'm going to regret it immediately, I'm going to lean into the regret and I'm going to put this at normal speed because I can feel it coming in the air tonight. This witness is kind of done. And if counsel keeps asking about his disagreeing with the conclusions, I don't think it's going to go well. And if they're going to talk over each other, we're going to do it at normal speed. Oh boy.
Your statement that it's unsubstantiated was in conflict with your digital forensics expert statement that she was in control of her devices on the FetLife communications, correct?
I don't know that I agree with part of that statement.
Okay, which part?
So there was a conclusion that Christine Banfield was always in the possession of her devices. The crime scene definitively
Relating
demonstrates
to
that to be
FetLife, which is what she
incorrect.
asked. The question was relating to FetLife.
So could you repeat the question?
So you want me to go all the way back to the difference between unsubstantiated and what?
No, the part where you're bridging unsubstantiated with the FetLife.
Yeah, that was the question that you were asked by Ms. Sands. And so what I'm asking is, you've indicated that it was unsubstantiated. I'm assuming as to the question as to the FetLife communications, correct?
That's what Ms. Sands asked me, correct?
Yes. And so I think your answer was you were talking about generally the the statement in his executive summary that she had not relinquished any of her devices. Is that what you were talking about?
Well, those are two different things. I answered Ms. Sand's question, which would be that, yes, his deduction that Christine Banfield was communicating with Joe Ryan was not only actually unsubstantiated, it was wrong.
Well,
Oh,
so
shit.
what did you look at to make?
That's the first time any witness in this case has said that Christine Banfield was definitively not the person communicating with Joseph Ryan. Elicited by the defense from their own witness. That was a pretty strong, definitive answer. That the conclusion that Christine Banfield was communicating with Joseph Ryan was incorrect. Oh boy.
Yes, his deduction that Christine Banfield was communicating with Joe Ryan was not only actually unsubstantiated, it was wrong.
Well, so what did you look at
Wow.
to reach the conclusion that it was unsubstantiated?
Oh,
did you-
counsel, no, you don't want to ask that question. Chat, since we're watching the wheels come off in real time together, this is what you do not do. This is not gonna help. The defense seems to be trying to say that Christine Banfield was communicating with Joe Ryan. In the defense's opening statement, they said that in this case, law enforcement was rushing to judgment and that the catfish theory couldn't be proven, and that Christine Banfield set up a liaison with Joseph Ryan, and he came to her house and stabbed her, and his client busted in and shot Joseph Ryan after Joseph Ryan stabbed Christine Banfield. That's what he said in opening. And you have a witness on the stand saying not only was the conclusion unsubstantiated, but it was flat wrong. And now you are going to give dude who does not seem thrilled to be there in the first place an open-ended question to explain why it's wrong? Bro has a master's in computer forensics, and you want him to walk the jury through why Christine Banfield could not have been the person communicating with Joseph Ryan. This is a bad choice, counsel. But I'm real curious about the answer now. And all of you are like, code red. It's a bad idea. It's a bad idea, but I don't think it's fuckery. I think it's a bad idea. I think counsel has stepped in it. We need like a code brown for this. Counsel has stepped in it, and now he's just smushing it into the carpet at this point. Oh man.
Well, so what did you look at to
I want to know the answer.
reach the conclusion that it was unsubstantiated? What digital forensics did you look at?
So going back to my education and being a computer and master's in computer forensics,
Shit.
you never attribute a device and or a username to a person.
Okay, and
That wasn't so bad for the
what
defense.
you're relying on to
Don't make it
that
worse.
point?
With regards to Ms. Sand's question, yes.
So that's not supported by any review of the items that were extracted from the 60 different devices that he did?
60?
Well, by
60?
happenstance, it is unsubstantiated.
60 devices? We're going to have to come back to 60 devices. Okay, the shit show didn't get worse. We're still in the shit. But he said, he didn't say anything other than you never attribute a device or a handle to a person. Okay. But he's continuing to ask. Counsel doesn't see that he doesn't smell it yet. It's probably because his nose is so stuffed up. He doesn't smell that he has stepped in it yet. Okay.
Unless Detective Miller was sitting next to Anastasia or Taco Supreme, he could never attribute whomever was talking on those devices.
And so what your position is that you're not going to believe that you can conclude someone's control of the devices unless you have a video or you have someone who was watching it?
It just would be forensically incorrect to make that conclusion.
But digital forensics makes that conclusion.
Objection, counsel's arguing.
I'll sustain that objection.
Okay.
So argumentative. Taco Supreme was the other username on FetLife. Maybe counsel's going to be able to pull out of this and without it getting worse. Because that's not the worst thing that has happened in this redirect. Okay. Maybe it won't get worse. Because right now what we're at is you never attribute who's using the device. And that's information that the jury's already heard. Okay.
Sir, I'm going to show you what will be marked as Defense Exhibit 108.
All right. Maybe we're not going to make it worse.
You recognize that?
This is the exhibit he forgot.
Yes, I do.
And do you recall the date?
I believe that's going to be October 25th. Is that correct?
Yes. It doesn't say, but if you recall it that way, that's
consistent with my communication with Lieutenant Giaccio on the date of the proffer.
Okay. And is it your understanding that he was in a separate room outside of the proffer? And you were communicating with him?
I wasn't on site. I don't feel comfortable answering that question.
You don't know personally?
I don't.
Okay. But it was while it was going on, correct?
Correct.
Okay. And is this the communication with Lieutenant Giaccio?
This was my communication, as I recall it, with Lieutenant Giaccio.
Your Honor, Defense Exhibit 108, we'll ID it.
It's identified as 108.
Okay. He's conferring with his client, who remains writing quite a bit. All right. I'm going to zoom and see if he has any more questions. All right. I'm going to put this back on 1.25 and see how it goes. I'm actually surprised that counsel was able to pull out of the tailspin because that was heading in a not helpful direction for counsel. And ultimately, the answers that are in weren't any more damaging than answers that have already been in. Okay.
Were you also involved in the transfer of Kyle Bryant, the lead detective?
Yes, sir.
And was that due to his performance?
Performance due to inexperience, as well as the phrase I would use. I believe he was in over his head as a homicide detective.
Okay. And so Miller, so from the group that was in place in October, Detective Brendan Miller was transferred?
He was transferred, I believe, in November.
Okay. But and then Detective Bryant, who was the lead homicide detective in this case, was transferred?
He was transferred in January of 2025.
And that was as a result of your deciding he had to go?
I just didn't believe he was experienced for the homicide squad.
So you transferred?
He was transferred to the sex crimes unit.
Okay. And in that same time frame, you were transferred, correct?
I was transferred in February of 2025.
And Lieutenant Giaccio was transferred?
Correct.
During the same time frame?
Right around that same time frame.
Okay. I don't have any further questions, Your Honor.
Okay.
Based on Exhibit 108, did you have any questions? Since that was a new,
No, but it was not offered into evidence yet.
no, it's just
so,
ID'd.
yes.
Okay. Is this witness subject to recall?
Not by the Commonwealth.
No, are you free to go then? Thank you.
Okay.
All right, your next witness.
Well,
Giaccio.
Giaccio's the next witness. We got a little bit into the rehoming of various individuals. And we heard again the answer that you do not attribute devices to individuals and that Miller's analysis was just wrong. All right. Giaccio's up next. I knew there had to be a notepad. I don't know if it has any questions written on it, but there is in fact a fucking notepad. All right, we're gonna zoom until Giaccio's on the stand. It looks like Giaccio's being sworn in as he walks up. Okay, next witness for the defense.
Good afternoon, sir. Can you please state your name and spell your name for the court reporter?
Lieutenant David Giaccio, Giaccio.
And where are you currently
I
stationed?
definitely
The
spelled
Sully
that wrong.
District Station,
Okay. And where were you prior to the Sully District Station?
the homicide unit.
We're at
Okay. And you were lieutenant
1.25.
there?
Yes,
Was that under, at one point, Deputy Chief Brusch?
yes.
Okay. Or actually, during the entire time you were there, was under?
During the entirety of the time I was there.
Because he transferred as well, correct?
I'm sorry.
Because he had transferred around the same time you did.
Yeah, I think about a month before I arrived, he was there.
Okay. I am going to
Okay.
ask you to identify what has been marked and introduced as Defense Exhibit 88.
It's just been marked, not introduced, but.
Oh, sorry. I thought 88 was.
Oh, 88 is, you're right. 88 is evidence.
Oh.
Do you reckon?
That's the first time that he's like, no, I thought 88 was in. And the court's like, actually, you're right. Actually, you're right. Good. Good.
Recognize that.
It's an email.
Okay. And what's your?
This is the
what's your
email
role in
with
this email?
B1 and B2 or B1 and B3.
Without context, it's hard to say. I think it has to do with an executive summary that I was having Detective Miller review.
Okay, so is that the executive summary right there? Was that the attachment?
I believe so.
Okay. Well, during that time frame, perhaps you can recall, during the time frame of November 8th, were you communicating with Sergeant Brian Ames then?
Yes, I was.
Okay, and you were communicating about the digital forensic executive summary?
That's correct.
Okay. Your Honor, I think that's in evidence.
That's in
Can we
evidence.
publish that? Is it already?
It's already been published.
Okay.
If it's in evidence, we publish it.
Sir, I'm going to have you look at what has been marked as and moved into evidence as number 89. Does that give you more context in identifying it?
Yes, I believe this was after the codependent in this case came in for a proffer. And those attachments or links, I guess would be the better term, at the bottom are links to the attachment or to the body worn camera that was used to record that proffer. There were two parts.
Okay, and in this instance, you went to Brian Ames with the two proffers, correct?
That's correct.
And was there a phone call that went along this? Where did he get his direction from?
I don't recall. I think we
We already
talked.
saw Ames
I don't remember
testify
if it was a phone call or an
about
in-person
this.
conversation. But after the proffer, we had a conversation about some of the forensic reports and the need to revisit them.
Okay, and the need to change them, correct?
No, sir.
Okay.
Every single witness has said we need to revisit them. None of them said we need to change them. And in fact, they weren't changed. Okay.
Was there an attempt to update? Sorry, I'll leave that there so you can see it. Was there an attempt to update the digital forensics based on the proffers that you sent?
So we had a meeting. I think it was after these emails. There was a meeting set up with Sergeant Ames and the two Brendan Millers. Names are slightly different, but they work in the same unit to go over the
The two Millers.
basically all the digital forensics and to understand why they came to certain conclusions previously and understand how the evidence was correctly would have been correctly analyzed.
Okay, and that was entirely based upon the proffer of Juliana Perez Magalhaes?
I think it was partially based on it. I think there was some question about the analysis from the leadership, both me and above me, prior to that.
Are you talking about Deputy Chief Brusch?
Yeah,
There was concerns about the digital forensics before they spoke to Juliana? Of course there were. Because you don't write digital forensics reports definitively saying who was doing a thing. The user. It's always the user. Now, some cases it really could only be one person using it, but that's for the jury to decide. So I'm not surprised they had some questions.
he would be one of the people, yes.
Okay. And so, well, I guess, so what you're saying is that you analyzed the digital forensics and you arrived at a different conclusion than your expert?
So I reviewed the data, and I think the data is what the data is. I think the context and how you analyze what it may mean is different.
Okay. And
Right.
so you were looking at the more the conclusions?
I would say the logic used to arrive at certain conclusions.
Okay. And this is with Brendan Miller's report,
Correct.
the executive summary.
That's what each witness has said too. Each witness that has been asked about this had said, no, we don't have issues with the digital forensics. We have issues with the conclusions derived therefrom. Slightly different ways of saying it, but it's not the forensics that are the issue. It's what that was determined to mean. Okay. The thing that's confusing to me is, based on their opening, the defense is trying to argue that the forensics are the way that Miller says that they are. And so bringing in witness after witness after witness to say that the digital forensics, the devices say what they say, but the conclusions are wrong, is anathema to the defense's case. What? Okay.
That's one of them, yeah.
Okay. And did you ever talk to Brendan Miller and have him show his work?
Yes,
How many times did you do that?
several.
Okay. And when you were doing that, were you trying to get him to change?
Not the data, the analysis.
Okay.
And I wouldn't say change, I would say to understand what I was seeing.
No, we were just trying to understand.
This is actually, 90.
90,
It's
it is,
been
yeah.
introduced, yes.
Thank you.
And for those of you listening in the background, when it skips,
I'm
it's
not aware of this, you don't
'cause
know.
I have
Okay.
skipped it ahead because the defense takes
think it
so
might have been
long
the day
between
before.
questions.
Well, yes, I'm a bit, obviously, the one I sent, I'm aware of, the one at the top. I assume this is what you were speaking about. I'm not aware of that one.
Okay. And is it accurate in terms of how he characterizes it?
Judge,
Objection.
the witness just indicated he's not aware of the document.
He's aware of the bottom part, I think is what he said. So if you want to direct your questions to that.
Well, I think he can.
Well, since we're all here together and they're putting up on the screen one of Ames's emails that was marked and admitted with Ames that we didn't read, we're going to go ahead and read it together because why not? Do I have any idea what number exhibit it is? No. 88, 89, 90. Because the defense, sorry, my cats have glittered my desk. 88, 89, 90. Whatever. We didn't see this when Ames was up. It probably doesn't help this witness. Major Robinson and Captain Horn. I'm reading this verbatim, but it sounds like the beginning of Corey Richards' novel. Major Robinson and Captain Horn. I just stepped out of a meeting with Lieutenant Giaccio. He has asked that both Millers review the timeline he provided and the videos of the proffer that he provided. He would like both Millers to revisit their work products and why the fuck would you assign both Brendan Millers to the same case? It seems like a recipe for disaster, but whatever. He would like both Millers to revisit their work products in regards to this case in light to the proffer statements and provided a timeline. He said that he will provide me the list of interpretations that either B3 or B1 and B3 made that will need to be rectified, explained, or revisited prior to the next court date. He doesn't believe Pathfinder is proper at this time, but we'll discuss it with his team and let me know. Please let me know if you have any questions. Thank you, Ames. All right.
I can ask some questions, Judge, about whether the body.
It was just so hard to see, plus dyslexia, plus overhead projector.
Of it is accurate, whether it's being communicated properly.
What, if he recognized it? He said he didn't recognize it, so I'll sustain that objection.
Right.
Do you recognize the content of what's being sent?
Counsel's like, I'm trying. It's already in evidence. You should have asked Ames about it more. You didn't ask Ames about what he emailed. So what you did is you got it in evidence and you brought somebody up to say, is this accurate? I don't know. That's not my fucking email.
I'm not sure what you're asking.
The body of.
I mean, I can read it. If that's what you're, I can read it and
Does
understand
that
it.
sound like what you said to him?
Yeah, I think that's pretty accurate.
Okay. Sir, I'm going to ask you to identify what has been, or look at what has been identified as.
These direct examinations have been painful. Did you in fact tell Ames to have them reevaluate their digital forensics? Yes? Okay.
Defense Exhibit 90?
Nope.
Oh, sorry, 91.
This is 91, which is
Yes,
not in
91,
evidence.
Sorry. So I'd be most interested in you looking at this area down here. Is that something that you created?
I wrote that email, yes.
Okay. And you're going to move this in as Defense Exhibit 91?
Any objection?
I can have the court's indulgence for 1
Yes,
second.
ma'am.
No.
Or it goes away.
All right. No objection. 91's in evidence.
Now I'm going to go through
Also, it's fair that the prosecutor needs a minute because the defense organization has been challenging. So I'm not surprised she's like, wait, what are we talking about?
a series of communications where it's multiple people. And so what I'm going to ask you is whether or not you recognize the communication and whether you're involved in the communication.
Okay.
Okay. So this would be exhibit number 92. Do you see that?
Oh my God.
Yes.
And does that look like the communication that you were involved with?
Yes, I believe the
Did I?
blue bubbles are mine.
Damn, we're
and
we're still at 1.25. It looks like they're talking about texts. Olivia Foster Pups, thank you. It is my wild grain chocolate croissant. I love these things. It's yum. All right. Are we going to get into the text messages?
we still don't have the third person, so I'm just going to identify that, Judge.
That's still 92.
Nope. No, we're not.
Sir, do you recognize that text message, Shane?
I do.
And are you involved in that?
That's my in blue as well.
If we're going to do this all over again, I'm going to put this at 1.5 and zoom. If the entirety of this is going to be, did you write that? Great. We need the other person to come in. I'm going to speed through all of that.
Sorry, the blue.
The blue is my text, yes.
Thank you.
There is nothing we are going to learn from that. Let's see if we can skip past some of this. Do you recognize this? Yes. Do you recognize this? Yes. Sally Fayez? Yes. She's the director of, I think they said family services or victim services earlier.
Major Dan Spital and Deputy Chief Patrick Brusch.
Okay. Did you have any
This is
privilege
his
to
chain of
report directly
command.
to Patrick Brusch when he was Deputy Chief?
For the purpose of this case, he was my primary report.
Okay, so it would just be the two of you communicating, much like these messages?
I mean, the other commanders were part of it, but he was the primary person that I reported to.
All right.
Sir, I'm going to ask you to identify if you are involved in this.
Perfect. I'm going to skip that now that we are more clear on his chain of command. He was reporting more directly to Brusch, the last witness. We're going through 95, 96, 97 text messages between him and Brusch.
Defense Exhibit 96.
Any objection? No objection. 96 in evidence can be published.
And since they're going to publish it, maybe we'll get to see it.
And so you're in blue again, correct?
Maybe
Yes, sir.
not.
Okay, and Big Day, you're speaking of what you just said, which is the preliminary hearing?
Correct.
Okay.
All right, so they're talking about the preliminary hearing. I'm going to leave this at 1.5 for now.
And you reference Klingon? You
Yes.
talk about Eric Klingon, the prosecutor?
Yes, sir.
Okay, he was the prosecutor on this case back then, correct?
Yes, he was.
And what's the, what
Huzzah! We can see text messages. Huzzah! Huzzah! These are printouts of text messages. March 31st, 2024. All right, that's the preliminary hearing date. That would have been for Juliana. 3/3/24. Big day tomorrow, buddy. I know. You gonna come watch? I can't. They will kill me. Ha ha. Ha. Maybe. Are you nervous? I'm up and down, buddy. Klingon is scaring me. Apparently Klingon was the prosecutor. Why? Because he's having a meltdown today. He's been freaking out for 3 weeks, and he's just now realizing I'm right. So he's seeing catfish.
just describe for the ladies and gentlemen of the jury, what
I'm going to put this down at 1.25. This might actually get interesting.
what's the communication about?
Your Honor, if counsel is asking the witness to read it, I would object. It has not yet been moved into evidence.
He asked him what it's about.
It has been moved into evidence or it wouldn't be published.
So I'll overrule the objection.
You can go ahead and answer.
It's about being nervous for the preliminary hearing.
Okay, and that's between you and Deputy Chief Brusch?
Correct.
Okay, were you directly involved in the preliminary hearing that day?
No.
Okay. And was that the day of the hearing?
I believe it's the evening before, or the evening before.
Okay, the preliminary hearing was on April 1st?
Yes, sir.
Okay.
Really?
And were you involved in the preparation? Is that why you're privy to that?
Well, I was the supervisor. Oh, closer. Sorry, it sounds loud to me.
He sounds loud to me
I'm sorry, can you
too.
repeat the questions?
Were you directly involved with the preparation for the preliminary hearing?
Yeah, I mean, I was the supervisor of the homicide unit.
Okay, but you didn't have any investigatory role in this?
No, in this case, I didn't.
And yes, for those of you just tuning into this trial, every time they show exhibits on the screen in court, it is the camera in court recording the screen. And so it does have like ripples. It's not your internet. It's not your eyes. It's not your device. It's just the camera trying to record the screen. It's tough.
I wasn't involved in any interviews. I didn't collect any evidence. I simply oversaw the investigation starting in, I think, early March 2024, so about 13 months after the murder.
Okay. Is it customary for lieutenants not to be involved in any of those things?
At the time, I was a sergeant, but yeah, I think that's fairly normal. The detectives do the investigating. The supervisor oversees it.
Would there be any other reasons why you couldn't prepare for the hearing?
No.
It's not his hearing.
Were you on the Brady List at that time?
Objection as to relevance.
Overruled.
He's testifying.
I'm
It's relevant. Yeah, we want to know if he's on the Brady List. Sure.
Objection as to relevance.
Overruled.
I'm not aware that anybody keeps a Brady List, but the Commonwealth has told me that they make certain disclosures about an investigation where I allowed an employee who had a brain tumor to stay home on light duty at the direction of a commander.
Okay.
What? So they asked him if he was on the Brady List at the time of the preliminary hearing. And he is saying, I'm aware that the prosecution makes some disclosures, and I allowed an employee who had a brain tumor to stay home on light duty at the direction of a commander wouldn't normally land you on the Brady list. Huh. That's odd.
Had a brain tumor to stay home on light duty at the direction of a commander.
I guess it's odd unless there is a policy that on light duty you cannot stay home, you have to come in. If the policy is that on light duty you have to come in, then that could end you up on the Brady list. But okay. That's in I have more questions.
Anybody keeps a Brady list, but the Commonwealth has told me that they make certain disclosures about an investigation where I allowed an employee who had a brain tumor to stay home on light duty at the direction of a commander.
Okay. And so that was one instance when you were put on the Brady list. Have you been put on the Brady list on other occasions?
No.
Objection is to relevance.
Overruled. He answered no.
And the Brady list essentially, well, you tell me, what is the Brady list?
Well, like I said, I don't think there's a Brady list, but the Commonwealth makes disclosures based on opinions that they form about a case.
And the underlying finding is truthfulness, correct?
No.
So for those of you asking what is a Brady list, it is generally referring to the fact that when a certain officer who has Brady or potential Brady material regarding the officer is a witness on a case, the prosecutors disclose that information about that officer to the defense in that case. Potential Brady information. Officer Dever testifying in the Reed case that she created a false memory. That information would land her on a required Brady disclosure. They would have to then disclose to every attorney on any case where Dever was on the witness list that she testified in trial that she created a false memory, and they would probably have to disclose if there was any investigation into her after that. Sometimes IA investigations go into this depending on what the IA investigation findings are, and those get disclosed. Sometimes the existence of an investigation might not get disclosed. So if there is something with this, it would go to a potential truthfulness. Like, I imagine this situation probably had an internal investigation. There may or may not have been discipline. I have no idea. But if putting someone on light duty does not allow them to stay at home, then putting someone on light duty and allowing them to stay at home, if there's nothing more, could be a payroll issue because they're not supposed to be light duty at home. That could be a problem. So then you have to disclose it, and it gets disclosed. Does that make sense? That's why when Dever testified, I said, well, shit, she's done. Like, she's done. Like, this testimony is done. She is never going to be able to testify in another case again. I mean, ultimately, it seemed that she either left or I think she quit, but she was never going to be able to testify ever again. So, continuing on.
Okay.
Like, if there was an investigation and discipline, the defense would have that information and they should be able to ask about it. And I'm curious about it. Hi, George.
Now, there's comment in here about the catfishing.
Oh, and then they just moved on.
Was that a
Okay.
concern on March 30th, 2024 amongst you and Deputy Chief Brusch?
Was catfishing a
There's a
concern?
comment here. I'm just trying to get the context of that.
So based on the evidence, I think that after I reviewed it, just about a month in, I believe that it was overwhelming that this was a catfish. I think the term has been used kind of across the board now that was set up by the defendant.
A number of you have asked about the scenario here. We don't have all the information. We don't have all the information regarding what was considered Brady here. And policy violations, like department policy violations, can be something that has to be disclosed if it goes to truthfulness, even if it's a policy violation. Because if you don't disclose it and the defense is like, yeah, but you got in trouble for not being truthful about something, we don't have the rest of the facts on this. But if there was an aspect of, well, we let them stay home on light duty and we're saying that they were here, I'm not saying that happened. If that's the case, then the defense has a right to know that there was something there that goes to this witness's truthfulness or veracity and their conduct at work. And you bring it out before the jury, and then the jury gets to decide if this is a problem or not a problem. But the defense has to be told that information because there's no way for them to find out that information without the prosecution disclosing it. Each prosecutor's office decides based on their jurisdiction, their case law, what does get disclosed as Brady and what doesn't get disclosed as Brady. So, I mean, I don't know the rest of the facts of this situation, but what's interesting to me is that the defense didn't push it more. And if the defense didn't push it more, there might not be more to it than I let somebody stay home on light duty who shouldn't have been on light duty and maybe should have been on leave or what have you. But is that the thing that the jury is going to be like, well, this guy's the problem? Probably not. The jury gets to decide. All right. Continuing on.
Yes.
Hope that helps.
And after doing 1 month's worth of work as a lieutenant, you were able to arrive at that conclusion?
I was a sergeant at the time, but yes.
Okay. And describe for the ladies and gentlemen of the jury, what were your digital...
Okay. I'm going to back up because I answered that question a lot. I hope that answers the questions about the Brady list. Again, over disclosing on Brady, I think, is the better policy. Under disclosing, you end up in all kinds of other issues. So Brady, as it goes to information about officers, you disclose it, and then you can fight to keep it out or fight not to keep it out. So, all right, I'm going to back up because now they're just moving on. So the defense doesn't really have anything more on that, because if he was disciplined, the defense would have said, but you were disciplined. If he lied in payroll records, then the defense would have said, but you lied here. The defense didn't push him on it anymore at all, which leads me to believe there's nothing more there.
After I reviewed it, this is about a month in, I believe that it was overwhelming that this was a catfish. I think the term has been used kind of across the board now, that was set up by the defendant, yes.
Okay. And
Did the defense really elicit that? Did the defense really elicit that? I have to back up again.
Context of that.
So based on the evidence, I think that after I reviewed it, this is about a month in, I believe that it was overwhelming that this was a catfish. I think the term has been used kind of across the board now, that was set up by the defendant, yes.
Okay. And after doing...
Looking at the evidence, a month in, I believe that this was overwhelmingly a catfish set up by the defendant. Okay, are you going to ask him to explain what evidence he was basing that on? Because that's not going to... Okay.
1 month's worth of work as a lieutenant, you were able to arrive at that conclusion?
I was a sergeant at the time, but yes.
Okay. And describe for the ladies and gentlemen of the jury, what were your digital forensics qualifications in order to arrive at that conclusion?
Well, I reviewed sort of the evidence that was provided to me by the digital forensics people. You know, for instance, the accounts were created in January. They had never, they were brand new accounts. That was unusual to me. We reviewed Christine's history. I think it went back to the mid-2000s. She had never so much as visited a porn site that we could find. So I thought that was...
I guess my question was about the digital...
What did you just say? What did you just say? What did you just say? The FetLife accounts were brand new accounts in January, and that raised a red flag. And we had Christine's accounts going back how far? We had Christine's accounts going back, I need to hear it again. And she had never so much as even visited a porn site. So, and again, I have no shade. The reason it matters is because if the defense is going to try to get the jury to believe that an RN in the ICU who was working, it seems, both night shifts and sometimes swing and day shifts with a 4-year-old is on FetLife setting up not just a first-time encounter, but a first-time encounter with someone they hadn't met before that was incredibly specific and somewhat violent with bondage and more, who had a blood disorder that caused them to bruise quite a bit and bleed excessively. You want me to believe that all of this happened and she had never whatsoever even tippy-toed into this type of content on the internet? Because that's going to strain credulity for me. Okay. And that doesn't even get to her phone being downstairs.
Gentlemen of the jury, what were your digital?
And the defense thinks he's going to do something. You tell the ladies and gentlemen of the jury what led you to believe this. He thinks he's going to do something. The defense is being snotty. You tell the ladies and gentlemen of the jury, with your digital forensics expertise, why you came to that conclusion.
At that conclusion. Okay, and after doing 1 month's worth of work and as a lieutenant, you were able to arrive at that conclusion?
I was a sergeant at the time, but yes.
Okay, and describe for the ladies and gentlemen of the jury, what were your digital forensics qualifications in order to arrive at that conclusion?
Well, I reviewed sort of the evidence that was provided to me by the digital forensics people. For instance, the accounts were created in January. They had never, they were brand new accounts. That was unusual to me. We reviewed Christine's history. I think it went back to the mid-2000s. She had never so much as visited a porn site that we could find. So I thought that was...
I guess my question was about the digital forensics.
Well, I think reviewing her digital...
User footprint is part of the digital forensics. They reviewed her digital footprint back to the mid-2000s. And the defense says, I was asking about digital forensics. He's like, and I was telling you about digital forensics. Someone's pattern of life is their digital forensics.
Footprint, there was no evidence of that. There were 2 occasions where the co-defendants were out of town for 48 to 36 hours, and none of the accounts, the CB 920 at Gmail wasn't used. The FetLife account wasn't used. The Telegram account wasn't used. It seemed unusual to me that that wouldn't happen while they were out of the house.
Whoop, there it is. Whoop, there it is. The other stuff also. But that, the jury has heard no evidence of this. And during the period of time that the defendant and Juliana are on their little road trip together, or on the trip to New York together, during those periods of time, when Juliana and defendant are together, Christine's not on any of those sites. no conversations on FetLife, no using the email that's connected to FetLife. If you're trying to have the sexy time conversations to step out on your spouse, aren't you doing it when your spouse is gone? No, none at all. During the time that Juliana and defendant are playing house on vacation, there is no activity on FetLife and no activity on the email connected to it. Which 100% tracks with what Juliana said. Juliana said that Brendan told her that we need to only do these things when we're in the house, when Christine's in the house, because of the investigation. We can only do it when we're in the house. So what was Christine doing when they were all out of town? She was probably working. She was probably working. Especially in New York, because the daughter was in New York with them. What do? Husband's out of town visiting his family. You sleep or you work? Okay. That's making me wonder why the prosecution didn't bring in any of this. Maybe it's because they didn't want to deal with the rest of it, but that's either that or the prosecution was real confident that the defense was going to call these witnesses and knew that this was going to come out and was just like, did the prosecution look at the defense witness list, chuckle and go, bet? Holy shit. I'm going to back that up one more time. That's pretty powerful evidence against the defendant, elicited on direct examination by his attorney during the direct examination of one of the witnesses that he chose to call. Yeah. LHR said the husband is on vacation and had to take the nanny. One of the trips to New York, Juliana went with them and the daughter went, and it seemed that the defendant was visiting his mom or grandma. And then the other one, he had a work trip and Juliana had days off and went and met him. So it wasn't really vacation. She turned it into a vacation. It was a work trip plus because he had a hotel room that work paid for. He drove his work car there. And then she drove the car that the family provided for her to go meet up with him. Yeah. Yeah, that's wow.
There were two occasions where the co-defendants were out of town for 48 to 36 hours and none of the accounts, the CB 920 at Gmail wasn't used. The FetLife account wasn't used. The Telegram account wasn't used. It seemed unusual to me that that wouldn't happen while they were out of the house.
That is unusual.
If I can, let me just redirect you back to digital forensics.
Let me redirect you back to the digital forensics. He's telling you that the behavior of the accounts doesn't make sense. Sometimes it's not what the accounts are doing, it's what the accounts are not doing. And the fact that during both periods of time that the co-defendants were out of the house, there was zero activity on any of the Catfish accounts is pretty fucking telling. And that is the digital forensics. Oh, counsel.
Well, this is all part of the digital evidence, right? So
yeah,
not your opinion as to whether or not it's unusual if they're in or out of town.
Just want to you ask your next question.
Now the defense is arguing with the witness. Bro, you asked.
Yes. In terms of catfishing, that was a theory that you were pushing.
I'll lose my mind.
That I was
pushing.
It's what I believe the evidence overwhelmingly supported, yes.
And you then attempted to educate the homicide detectives. about that,
Objection,
correct?
leading.
All right, I'll stay in this lead.
What, if anything, did you do with the homicide?
So catfishing, it's what I believe the evidence overwhelmingly supported. Counsel, keep digging. Just keep digging.
Detectives in order to convince them of your theory?
We reviewed the evidence many times between March and September. However, it wasn't until the co-defendant came into proffer that everybody was in agreement that the catfish was the actual correct.
Okay, so once again, it was the co-defendant, not the digital forensics, that caused that conclusion, correct?
That's not what he said.
That's not my opinion, no.
Okay. Okay. I don't have any further questions on that.
I bet you don't. So, counsel, the picture that you're painting for me, chat, let me know where you're at. The picture that you're painting for me is that the digital forensic examiner took the extra step to say, no, Christine was the one on her accounts. And then numerous people in command pointed out, this doesn't make any sense that Christine is the one who is on the FetLife account and doing these things. And these are some of the reasons why. And they were correct. It was supported when Juliana came in. And the people who were like, nah, that's not what it shows, they're the ones that were transferred. Is that what you're telling me? Counsel definitely wants to move on. I mean, he read that situation correctly. We're going back to 1.25. Holy shit. That's all new information. I was wondering why the state didn't have a digital forensics examiner, and they're like, don't worry. The defense will just implode it in their case in chief. Okay.
Sir, I'm going to have you.
Sir, I'm going to try to fix this.
What will be marked as 98? Defense Exhibit 97?
Good luck with that.
No.
It's 97.
97?
It's 97, correct.
I now have more
You
questions.
see that, sir?
Yes.
I now have a lot more
And-
questions for the people who are like, no, the husband totally didn't set her up with this. Like, they had the digital forensics that showed that Christine was apparently doing nothing involved with FetLife or anything even connected to it in her entire internet history. And remember, she didn't know that the day that she died was any different than any other day. And they had all of her devices to look at. And there was nothing that indicated that that was something she was going to partake in. And there were still some that were like, no, that doesn't make any sense. Okay.
That, this is between you and Deputy Chief Brusch, is that right?
It is.
Okay. And there's some concern about losing.
All right. I'm going to answer this question because derangement, this is great. How would she even know about FetLife, right? Where are the Google searches for, looking for someone to engage consensually? Where are the Googles to try to find somebody? Where are the forms? Where are the books? Where's the reading material? What's on her Kindle and or Audible? Because I have questions. It's a great question. How would she even know that existed as an option? Right, chat? Where's the AO3? Right.
Probable cause hearing, correct?
Yes.
Okay. So question for, Your Honor, I'd move that into evidence.
All right, any objection, 97?
Yes, Judge. our previous witness did not identify that as his information, so it stands as hearsay.
It's kind of a follow-on of 96, it just keeps going down, so I'll
I can-
rule the objection on
Thank you.
97 in evidence.
Is this communication with Patrick Brusch?
It is.
Okay. And in here, there's discussion about the prosecutor's plan, correct?
Yes.
And are you in the blue or the gray?
Blue.
Okay. And there's
That's a
something
wild
about
reveal.
a
I'm
fail-safe
stuck.
that's been put in place. What's that?
Look, I'm not saying we're basing it off of Kindles, because look, God knows what's on the separate EDB only Audible account. Look, no judging. I'm just saying the fact that they found nothing is telling. It's telling. The nothingness speaks very loudly.
We had evidence that the co-defendant may have misrepresented things on her visa application. And I think Customs and Border Protection had planned to investigate that and potentially arrest her for it.
Okay, so if the preliminary hearing didn't go well, you wanted to get a hold of her immediately afterwards.
Correct.
So if the preliminary hearing hadn't gone well, just for the ladies and gentlemen of the jury, the case would have been dismissed.
Correct.
And then she would have been released.
Judge, counsel's testifying.
He's leading.
States the leading.
The court says leading. Right, it's leading. The objection to that is leading. I think the prosecutor's doing it on purpose this time to point it out to the jury, but the interesting quirk to that is they were concerned about the prelim, and they were concerned about not having Juliana. However, if a case is dismissed, it can be immediately refiled.
So what would have happened if the preliminary hearing had been dismissed?
The co-defendant would be released.
And so the fail-safe was to have Customs and Border Patrol there to grab her?
Correct.
Okay, so come to the jail before she's released.
I think they were planning on getting arrest warrants. I'm not fully read into what their plan was.
And was this a plan between you and then Deputy Chief Brusch, or was this a plan amongst everyone involved?
It was the detectives on the task force that was created set it up.
Okay, and so who else would have known about the fail-safe?
Detective Bryant, Detective Goodell, and Detective Smith, I think, was still pretty well involved at that point.
Was Detective Bryant the chief detective at that time?
He was the lead detective, yes.
Okay, and Detective Goodell was another co-lead detective?
Correct.
And was Detective Smith a lead detective, or she?
Yeah, so essentially when I arrived, Detective Bryant had been the lead for the first year or so. I think at some point prior to my arrival, Detective Smith had been assigned to help him. And then once I got there, I assigned Detective Goodell. So there was
Bryant, the one who got transferred because he was in over his head, and then they brought in Smith, who we saw testify earlier with the navy blue suit and the green shirt. They brought her in because Bryant was over his head. No wonder her attitude was, "Come at me, bro." So she was brought in to fix somebody else's investigation. Right. That tracks. That tracks.
3 detectives plus myself that were reviewing all the evidence.
Okay. Okay, did you say in a prior statement that as a lieutenant, you wouldn't review all the evidence?
No, I would absolutely review the evidence. I wouldn't take part directly in the investigation. I didn't interview witness, collect evidence, or have any real direct involvement, just in reviewing and advocating for investigative leads.
And Your Honor, I'm sorry, 97 was moved into evidence?
97 is in
Okay,
evidence.
and that's, the jury has, it's been published. Okay, thank you.
Oh boy.
Sir, can you see that communication?
Yes.
Is that the communication with Patrick Brusch?
Yes.
And this is
Are we
from
back to
November
texts?
8th? Correct?
Yes,
Okay, do you recognize this?
I do.
And you're in blue?
Correct.
You're going to move this in as Counsel's Exhibit number 98?
Judge, I'll renew the objection that former Deputy Chief Brusch could not identify this item.
On this one, he could not identify.
Former. The defense is now trying to bring in this, whatever text message communication it is, and didn't seem to mark which ones Brusch said were his and which ones Brusch said, I don't know who that is. Because now he's trying to enter in one of the ones that Brusch said, I don't know what that is. And the prosecution has clearly kept notes, because she has to. The prosecution has clearly kept notes, and they're like, no, Brusch said this one wasn't him. Oh, boy. And the court agrees.
I think the witness just identified him.
Correct, but the witness indicates based on the document
I'm
itself.
sustaining the objection since he testified that he did not recall it. So sustain the objection.
Okay. Sir,
Wow.
in the blue box,
No,
you
counsel.
indicate that you did something.
No, counsel. No, counsel. That's not an evidence. In the blue box, it indicates that you did something. Counsel, that's not an evidence. Are you going to use it to refresh his recollection? He didn't say he wasn't refreshed. Oh, God.
What is that?
I used the words markup. Or took a red pen. What I did was highlight in red on a document.
And did you actually take a pen?
No, it was the red. I changed the font to red rather than black.
Okay. And the
In what?
document that you were referring to there, what
Is?
document was that?
It was the executive summary prepared by Detective Miller.
Okay.
Great. The executive summary from Miller, where Miller said that Christine was the one that was on FetLife. Okay.
On 98?
Sure.
This has not gone well for the defense. If you're listening in the background because you have lots of things to do, I know you do. Come on back real quick. Put your eyeballs on the screen and take a look at Judge A's face at this sidebar, because Judge A is over it. Look at Judge A's face, and I'm still at 1.25, but I didn't think Judge A's eyebrows could get any higher than yesterday, and alas, here we are. Judge A's eyebrows are speaking to us more than anyone could know, because what she handed him a Post-it. Here, counsel, just so you can keep it straight. Handed him a fucking Post-it. Counsel, these are the ones that you're not getting in. Here you go. Here you go. Good Lord.
Also had 106.
Oh. Do you know what we didn't hear anyone say? We didn't hear anyone say no further questions. And now we're on cross? What?
Your Honor, if I may, I also had 106.
I had 106. I put that on his.
Okay, and 107. Yes.
Yes.
Thank you.
I'm guessing we're on cross because the prosecutor's speaking. If they had stayed on the zoomed out pan of the courtroom, we could tell better. But are we on?
Sir,
No. Okay. They were just
you identify
false
what's been
alarm.
marked as
I hate not being able to see what's happening. False alarm. They were still trying to figure out the exhibitties. All right. Damn it. I thought we were done.
Defense Exhibit 100.
Yes, it's a text message.
And that's between you and Patrick Brusch?
It is.
Did we accidentally slip back down from 1.25? No, we
Are
didn't.
you in the blue box or the gray box?
Blue.
Okay, Your Honor, I'd move that into evidence. as
No objection.
Comments
100 in
Exhibit
evidence.
100.
And we'll publish.
Oh, good. They're going to publish it.
So what, if anything, did you do when you were told to hold off on bringing Klingon and Kelsey into the loop?
Oh,
I don't remember specifically, but I would imagine I held off on giving them a call.
Okay. And who, for the ladies and gentlemen of the jury, who's Klingon and who's Kelsey?
They were the prosecutors assigned at the time.
Okay. And do you recall when it was that you put them in the loop after this?
all right. I'm going to read what's on the screen. For those of you that are just tuning in and haven't seen this trial yet, Fairfax County was still closed today. We are catching up on a slow roll of day 6. These are texts between the last witness and this witness. And it looks like this is June 12th, 2024, 10:03. Christine's blood inside Juliana's shoes and on Brendan's pants. Game over. Heart. And then thumbs up emoji to meeting with task force. So far in the text that we've seen, I haven't seen anyone calling anyone any names. I've seen them talking about the case. But I haven't. Okay. Christine's blood inside Juliana's shoes and on Brendan's pants. So the blood's coming back.
Statement?
I'm sure within 24 hours. I don't recall exactly.
And then it says meeting with task force after Celebrate. Will bring Klingon and Gil up to speed after. And then it says hold off on bringing Klingon and Kelsey into the loop.
Have any recollection?
No, I don't recall, but it was definitely not for any extended period of time.
Okay, and this looks like it was something that might jog your memory.
Okay, I'm going to pause again and make sure your people are direct, please. And let's talk before your task force meeting, please. I'm not sitting in on it. Don't worry. And then the answer to the questions that I kept pausing, so it was probably impossible to hear, was how long did you hold off? And he said 24, 48 hours. Okay.
It was relating to Celebrate Task Force. Do you have any recollection when it was that you would have told the prosecutors in this case, whatever the conclusion was?
Judge, I think that's a mischaracterization of the evidence.
If you want to rephrase your question.
So leading?
Was the information that you're holding off on relating to the task force meeting at Celebrate?
I believe it was the blood inside Juliana's shoes and on Brendan's pants.
Okay, and so how long did it take for you to communicate that to the prosecution team?
Like I said, I don't remember exactly, but it would be something that I would bring them up to speed on within a short period.
Okay, but you don't remember if you did?
I'm sorry?
But you don't remember if you did?
He would have had to.
I certainly remember that they're aware of it. I just don't know exactly what that time frame was, but I would guess within 24 hours.
Thank you.
Mr. Carroll, would this be a good time to go ahead and take our lunch break?
Yes, thank you.
All right, ladies and gentlemen, we'll go ahead and take our
So they waited a day to tell the prosecutors what the results were on the blood. I mean, was there a court date pending? This was before the arrest of Brendan, and this was before the proffer. This was in June. Okay. It sounds like they're going to the lunch break. So we're going to...
lunch break for an hour. Please do not discuss the case with anybody. Don't do any outside research, okay? Thank you.
We're going to zoom right past the lunch break. I will probably take a break at some point beyond that to use the restroom, but I am probably at the end of this witness, but I would love to finish this witness before I take a quick break. Hopefully that's good for you, chat. It looks like they come back from lunch and go, oh, I should summarize where we are because my brain is just. So we are at the lunch break of day 6. And we have learned some interesting new information from the witness on the stand. It is defense witness 11, whose name I spelled wrong the entire time. Giaccio, I think is how he pronounced it properly. But as Giaccio is on the stand, Giaccio was asked about being on the Brady List. He gave the explanation that he had, at a supervisor's direction, which really makes me wonder if the witness before was in fact that direct supervisor, at a supervisor's direction, allowed a officer to stay home on light duty when the officer had a brain tumor. The defense did not follow up on that anymore. So I don't know if there was an investigation. I don't know if there was discipline. I don't know if anything happened or it was just information that the prosecution turned over to the defense. We don't know anymore. The defense didn't follow up on it at this point beyond that. And then the defense was asking, in almost a little bit of a gotcha kind of way, hey, so based on your digital forensic experience, implying lack of experience, tell the ladies and the gentlemen of the jury what in the digital forensics made you believe that Miller's conclusions were wrong. And that's when the floodgates of this witness just kind of went whoop. And the witness is like, well, we had Christine Banfield's devices and we went back in her device usage, internet history, etc., into the mid 2000s. And we saw that she had looked at no pornography of any type at all. And so that seemed odd given the FetLife account. It was a red flag to this witness that the FetLife account was started brand new in January. And then beyond the internet usage of victim Christine Banfield was the very interesting forensic tidbit that there were 2 periods of time during the investigation where Brendan Banfield and Juliana were out of town together. We heard Juliana testify about these. One, Brandon had like a work trip and drove his work car and had a hotel for the work trip. And she drove up to meet him at his hotel that he had for the work trip. The other one was that trip to New York. And it sounded like they were visiting his family in New York. Like it might've been a work trip combined with visiting family. And Juliana was up there and Valerie, the daughter, was up there too. And do you know what they said in digital forensics? That during those 2 trips, when Brandon and Juliana were out of town, there was no activity on the FetLife account that had been created. There was no activity on the email address, and there was no activity on the Telegram account. So he said there were 2 points in time where he would expect there to be activity on those accounts, and there wasn't. Interesting that that was something that stood out to this lieutenant. All right. I'm interested to see what the rest of direct examination is. I'm interested to see what cross-examination is. But the defense also brought forward and is starting to bring out text messages and group text messages. It seems from those initial text messages that the prosecution and law enforcement weren't of the same mind on this case ahead of Juliana's preliminary hearing. And it seems that the law enforcement officers had backup plans in case the case against Juliana didn't make it past preliminary hearing. So it seems that they were concerned. And in a previous witness, they did bring up that part of the reason or part of the consideration in arresting Juliana was perhaps once there was a change of circumstance, once she was in custody, perhaps she would start focusing on her own self-interest and best interest instead of protecting other parties, which I think I failed to mention earlier because it's such a obviously to me that it is obviously to me. It might not be obviously to the jury. And if the jury thinks that law enforcement was coercing this out of Juliana, they are not going to like to hear that, yeah, we wanted to get her in custody so she would talk to us to save her own butt, which is exactly what she did. But how would she know some of the things that she disclosed if they were just feeding this information to her? I'm very curious to see how the rest of this not prosecution. See, that's how bad these witnesses are for the defense, that I still consider them in my brain prosecution witnesses, because all the information that's come out has been, oh my, okay. Interesting. So let's continue. Let's continue. And as Chad is pointing out, she was in custody for a year. She was in custody for a year before she spoke. Yes, she was. All right. Let's zoom. Really?
So we ready for the jury? Sure.
Are we ready for the jury? Can we approach? All right. So they've approached. I don't know what they're talking about. After lunch, they've approached before the jury comes in. Stop it. Show us the sidebar. Stop showing. We've seen enough of the defendant's face. Camera, how are you not sick of the defendant's face? Show us Judge A face at this sidebar. That's what I want to see. I want to see. No! I want to see what they're doing at sidebar. It's much more interesting, even when we can't hear it. Judge A's face is just so much confusion. She looks so hopeful. She's like, what are we doing? I'm going to zoom past them just showing the defendant. Okay. Bringing the jury back in.
Bless you.
Okay. Now the jury's sneezing.
Yes, sir, Mr. Giaccio.
Well, it's okay. Thank you.
All right. After the lunch break, resuming the direct examination of defense witness 11, Lieutenant Giaccio.
All right, your next question.
Yes, sir, Mr. Giaccio.
Could you move the microphone back towards yourself there?
Wait, what? Oh, sorry.
There you go.
Can you hear me now?
Yes. Very good.
Mm-hmm.
Lieutenant Giaccio, I'm going to ask you to look at what has been identified as
We're still at
Defense Exhibit
1.25
102.
speed.
Do you recall that conversation and who it was with?
Yes, and it was with Deputy Chief Brusch.
Okay. And, Your Honor, if I'd move that into evidence.
Thank you. Any objection?
No, ma'am.
All right, 102 in evidence.
Now, the date is significant for what reason?
I believe that's the date of the proffer.
Okay. And was the proffer occurring at that time?
It was later that evening.
Okay. And what time did the proffer start, do you know, in the evening?
I believe somewhere around 4 or 5 is when we met.
And we see the text on the screen. The text says in blue, tentatively scheduled for 3 p.m., nothing more yet. Wow. Big day. You think it's going to happen? I think so. Okay.
Began. I don't recall exactly though. It was in the evening hours though.
Were you in the room where the proffer was occurring or the room next door?
Next door.
Okay.
Excuse
and how
me?
were you linked?
Counsel, the correct question is only, were you in the room where it happened? That objection to form. All right. The next text is Friday, October 25th at 12:17. It said offer will be manslaughter with time served after BB trial. Did somebody lose their mind?
Up to the proffer.
By phone.
There it is. All right. As they're scrolling down, the next text is, that's absolute dog shit. Ding, 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 ding. Oh, look. We have not seen these officers talk about anyone, and now they're mad at the prosecutor. Shocking. Shock me that they think that the offer for manslaughter time served is dog shit. I am so surprised that these cops are mad at the prosecutor's office, aren't you? Any of you shocked? Who's shocked? Who agrees with the text? Right. And then in blue, it says still no more details. On call with...
a phone was just left open and you could just listen to it?
Correct.
Okay.
On call with Ryan family now. So they're on the phone with the victim's family. On call with Ryan family now. Agreed. Let's hear what she has to say. Is the last text from Brusch. Okay. So they're not calling the defendant a see you next Tuesday. You chose to introduce the texts where law enforcement thought that the co-defendant was more complicit and deserved more time because they were that convinced of her guilt and her behavior, and they didn't think she should get a lighter offer. How does that help? Like, what's the strategy of this message? Why is the defense entering this into evidence? How does this help them? Okay.
Was there not enough room in the area where the proffer was occurring?
It's a relatively small conference room, but it was a decision of the Commonwealth attorney who was in there.
Okay, who was the Commonwealth attorney?
That was Mr. Klingon at the time.
Okay, and was the decision that you would be out?
Yes.
Or there wasn't enough room?
I can't speak to what his mindset was. I mean,
I told you you're out.
Correct.
Okay. Now.
So, and then the prosecutor didn't want law enforcement in the room where it happened. I'm seeing some tension between the prosecutor's office and law enforcement. The tension isn't that they don't think Juliana's guilty. That's not the tension here. Okay, counsel.
I think we have a previous exhibit where it was requested that you hold back information from Klingon and Kelsey Gill. Do you recall that?
Yes.
Was that around the same time frame as this?
No, it was in June.
I don't know if you could show me the exhibit. I can tell you. Yeah.
It was in June. All right.
June 12th.
Okay.
Was that around the same time? Absolutely not.
Did it ever come to light that you were holding back information from the Commonwealth attorney?
We weren't holding back information. It was simply to allow time for, I think, Deputy Chief Brusch to notify up the chain of command.
Oh, okay. So is that reflected here in this message?
No, but that wasn't unusual.
Okay. Was there some reason that Deputy Chief Brusch or you, if you can answer, didn't want to include the prosecutors in this case?
We always included the prosecutors.
Because we think they're dog shit, counsel. We thought that was a bitch ass offer and that they should put on their big lawyer pants and do big lawyer things. But you know what they didn't do? They didn't call them any names in these texts either.
But there was a major piece or a major change, then I would notify Deputy Chief Brusch and he would notify it up the chain to the Chief of Police. And we wanted to allow time for him to be aware of it on our side so that he would hear from it from us rather than from the Commonwealth Attorney's office.
Okay, so looking at this.
You're telling me that on a high-profile case, you wanted to make sure that the chief of police had the information before the prosecutor's office did? Honestly, fair.
Exhibit that's been introduced into evidence. Was the meeting with Cellbright a major change?
I think that what he's referring to is the blood evidence, not the meeting with Cellbright.
Okay, because Cellbright doesn't have anything to do with blood, correct?
No, that's digital evidence.
Okay, I'm just following my questions up on your statement saying whenever there are major changes, we might delay so he can go up the command staff chain before telling anyone else. So what I'm asking about is in this one,
1.25.
is Cellbright a major change?
It is.
Judge, I'm going to object. I think
Oh, counsel. No, his questions are terrible. Just let him keep asking terrible questions. Your Honor, I'm going to object. What?
objection is to form. Mr. Carroll is
Leave that.
misreading the information. There was no meeting with Cellbright. The statement is meeting with task force after Cellbright.
Hey, Judge A, can you just yell at the prosecutor? Because the speaking objections are getting to be a bit much. Can we just not?
All right, I'll sustain
Fair
the
enough.
form.
You testified that traditionally Deputy Chief Brusch would say, hold off, so he could send it up the flagpole, essentially, correct?
Correct.
Okay.
But I think you're confusing what information. The information is the blood. Information that he's asking me to hold off on is the way I understand it.
Well, yeah,
The
that's.
Cellbright has nothing to do with the later statement.
And where does it say that?
Well, I'm saying that.
Okay. And so,
Where does it say that? The witness is like, it's my text message. So I'm telling you what I'm saying in the text message because it's my text message. I don't blame the witness laughing.
that would be, what you've just testified to was that this would happen when there were major changes so that everyone and staff could know and be able to answer questions by the press and things like that. Is that correct?
Correct.
Okay. And in this case, what I'm saying is, what is the major change in the case that would cause
He told
there to
you.
be some delay in talking to the prosecutors?
He just told you. Whose blood it was came back in the blood evidence. He already said that. Counsel, this isn't a deposition. This is not where you should be figuring out this information for the first time at the expense of the jury's patience. And this was last Thursday, their ability to go buy snow snacks. You are delaying everything. He answered this. There aren't going to be any Ruffles left at the store by the time they get there, counsel.
The blood evidence. So Christine's blood inside Juliana's shoes and on Brendan's
Or
pants.
milk.
Okay.
That was new information. So that was something that I considered significant.
Okay, you sent that on. And then, so you remember that moment?
So you didn't hear the gunshots because you were in the shower. So because you were in the shower, you didn't hear the gunshots. Yeah, I was in the shower washing my hair. See, the thing about Legally Blonde is that Elle tapped into trial and had never been in trial before because she was a 1L law student, if we're suspending belief for a moment, and was trying to figure it out on the fly. This attorney is A, not tapping in for the first time, B, should not be figuring it out on the fly, and C, Elle Woods actually got there within like 10 questions.
Well, yeah, I mean, I remember sending the text, yes.
But do you remember as you're reading this text, you know, what the context of it was?
Yes, we got a lab sheet back that contained new blood information. And I notified my chain of command.
Her blood.
And so what about that would not directly relate to information the prosecutors need?
He didn't say that.
I'm not really following what you're trying to ask.
Okay, I'm trying to understand why they're.
Neither is he. He's also not following what he's trying to ask you.
there's any need to hold back evidence from the prosecutors.
She just
There was no holding back evidence. It was merely giving time for it to get up our chain before the notification was made to the prosecutor's office.
Okay, and you don't know specifically what that time was?
I think I testified earlier, it was no longer than 24 hours. It was either later that evening or the following day.
Okay, but we're now talking about this major event of the blood evidence that's referenced here, and that doesn't tell you any different?
Objection leading, counsel's testifying.
Christina's leading.
Now that we're identifying what it is that was the major evidence break,
because it
do
was
you
the blood.
remember why you were holding back and when you ultimately gave them the information?
Asked and
Again,
answered.
Judge asked and answered. He
Did you see how quickly the witness blinked? If you all just blinked in disbelief, the witness also blinked in disbelief. And then the prosecution was like, yes, now we're at asked and answered.
And when you ultimately gave them the information?
Again, Judge asked and answered. He has testified that he does not recall specifically when he shared the information, but he knows that it would have been within 24 hours.
I think that was previously, Judge, when we weren't talking about the major event, which is what he just testified to.
Oh no, counsel, everyone else was talking about the same thing. It's just you were not on the same train, counsel. You boarded the wrong car. I don't know how that happened, but that's on you. Everybody else was on the same train.
All right, I'll overrule. Go ahead.
I'm sorry, can you repeat them?
So
Oh my God.
what was it about this major event with, I guess, a lab sheet coming back that caused you to hold it back from the prosecutors? And then my question is, if it's a major event, wouldn't you have an idea of how long you're holding it back from the prosecutors?
I wouldn't say major. It's a significant thing that we get a lab sheet in that shows blood evidence. There's no holding back. The evidence was all provided to the Commonwealth Attorney's Office, but we allow time when we get some kind of information for it to go up the chain of command so that they're all aware of it, so that they can, if the Commonwealth Attorney's Office calls over to somebody higher ranking, that they can speak educated about it.
So is that a policy?
I mean, it's just how we do business. There's not a policy.
But I mean,
Yeah, counsel, you don't want your chief of police caught unaware by the prosecution in a high profile case. Imagine how that would go. Imagine how that would go. The elected DA calls up the police chief, assuming the elected DA is involved in high profile cases, which is incredibly common. The elected DA calls up the chief of police and is like, Chief, we got some new evidence in this case. This. And the chief of police is like, I'm going to have to call you back. I have no idea what the fuck you're talking about. Can you imagine? Can you imagine how that would go? When the chief of police looks at the chain of command and is like, how do I not know things on this high profile case? Can you imagine? You make sure that the people who might get a call about it know. Shocking. I'm shocked. No, counsel, that's just common sense, because I would like my boss to not actually, transfer me, scream at me, or be embarrassed. I would like my boss to look good. It tends to go better. Counsel, that's just all workplaces.
somebody has to determine it's major, and somebody has to then make the decision whether it gets held up.
I think it would go to my discretion whether it's something I'm going to notify my chain of command, and they're going to tell me sometimes they're not, it's not significant enough that they would hold it back. Or perhaps, if it was a phone call and the deputy chief was with the chief or the assistant chief, they could relay it immediately. In this case, I'm assuming that the deputy chief didn't have immediate access and was waiting for some reasonable amount of time so that he could make that notification prior to bringing the Commonwealth Attorney into the loop.
How many times in this case did you find yourself speaking to Deputy Chief Brusch at the time about holding back evidence from the prosecutors?
Again, we're not holding.
The thing is, we just watched the Reed case. And so in the Reed case, every time Yuri Buchanan was like, this was an investigation that was carried out with ethics and integrity and whatever, I hurt my head rolling my eyes. This explanation makes perfect sense in the real world. All of this makes sense. Does any of this seem shady? Hey, hold back on his explanation makes perfect sense.
putting anything back. We're making notifications and then notifying the Commonwealth Attorney.
Well, couldn't it also be done as telling them, hey, we haven't made notifications, keep this under your...
Objection leading.
Sustained.
Weren't there other ways to do that with involving the Commonwealth Attorney's Office?
Well, they were involved.
Not if it was being held back.
Objection argumentative.
I sustain the objection.
You just testified that they weren't involved because you were holding back.
Objection leading.
Sustain the objection.
The witness's blink rate. He's just like, he's blinking in disbelief. Honestly, same.
Let's go back to...
Also, hold off on telling the prosecution. So we hold off till telling them later that day or the next morning. Sir, this is not the scandal you're looking for. Don't tell them yet. Has this never happened in anyone else's workplace? No, it's happened in everybody's workplace. Hey, hold off on moving forward with that information. Anyone who's had a job knows exactly what he's talking about. And the defense is just going around and around and around on a point that is not fetch. Just
exhibit number 102. This was, it looks like the entire chain was October 25th, which is the, I think you had previously said was the day that Juliana Perez Magalhães recanted.
Yes.
Okay. And it looks as though, and Your Honor, I'm sorry, have I moved this into evidence yet?
Yes, that's already been.
Okay, okay. And you're the blue bubbles there, correct?
Correct.
And I guess the offer hasn't been made yet, but you have the offer there, or has it already been accepted?
I don't know. I'm aware of the offer. I don't know if it had been accepted yet, I guess is what I don't know the answer to
And
that.
who would have been involved?
please ask about these texts. These texts are back on the screen for those of you listening in the background. The dog shit text is in this chain of text. Please ask about the dog shit text. Please.
With that process?
The Commonwealth Attorney's Office.
And do you know who made the offer?
I believe it was Mr. Klingon.
Okay, did you talk to him before that
I talked to him.
about the offer?
Yeah, there was discussions throughout the case about a potential offer.
Okay, when was the first time that an offer was made in your recollection?
I don't know.
Could it have been around January 1st? of
Objection
2001?
leading.
How long were offers going on as far as you knew?
I don't know.
What's end? I think that the code we have for this is code. I think we're at code Brown. I think that's where we're at.
Were you privy to all offers that were made?
I don't know.
Do you know of any other offers other than this one being made to her?
I believe there were others. I don't know the ins and outs of them.
Okay. And would that be because of your capacity as a lieutenant in homicide?
No, it's because
Well,
that's what
the
the
police
DAs
department
do.
investigates and the prosecutor's office prosecutes, so they make those prosecutorial decisions, and I'm not always privy to them.
Okay. How
There's a lot of subtext in that answer. I'm not always privy to them. I don't always agree with them. Sometimes I, in fact, fucking hate them, but there's nothing I can do. Lawyers, am I right?
many offers were you privy to?
I know that there were other offers made. I couldn't tell you if it was more than one. I just know that there was discussion that there were previous offers.
Okay. And in the context of the calendar year and the big events of that calendar year of 24, were there offers made before Brendan was arrested?
I believe so, but I wouldn't know the details of that.
Okay. Were there offers made before the preliminary hearing that was a cause for concern for the fail-safe?
I believe so, but I don't know for sure.
Okay. That was a pretty big event though, wasn't it?
The preliminary hearing?
Mm-hmm.
Yes.
And that was something that really stood out in your mind?
Objection leading.
We've moved
Is
on.
that something that stood out in your mind?
Code Grumpy is very funny. Emily's Life on Wheels. Code Grumpy is very funny. We might have to figure out what our Code Brown is. Code Code Grumpy is very funny.
I mean, it was the first, with my involvement in the case, it was the first sort of major milestone, I would say.
Okay. At any point, did you hear of an offer of a misdemeanor for her testimony?
Not that I'm aware of. Or not that I remember, I guess would be the more appropriate answer.
And I was just going to follow up. There may have been, but you don't know.
Yeah, I just don't know.
Okay. Now, were you involved in any way?
Was that offer of a misdemeanor made before the victim's blood came back on Juliana's socks?
In your capacity, either directing or performing review of jail calls?
I listen to them regularly, yes.
Okay, and you were listening to them.
Objection leading.
Were you listening to them
At least he didn't use one, if anything.
when Juliana had been arrested and was in jail and Brendan was out?
You don't have jail calls if someone's not in jail. So there's that. Counsel, can you ask just for us, since time is a construct, can you just ask if the sum and substance of those jail calls were, baby, I love you, because I really want to know. Thanks.
I don't recall when I started, but I believe it was before. I at least listened to some. I listened to more after.
Okay, but you were the command staff person. Was there someone assigned to listen to calls all the time?
Yes.
And what was the reason
Really?
for that?
Well, part of it was that with Juliana, she spoke in Portuguese, so we had a Portuguese-speaking police officer that
That's fair.
listened.
Okay, was that who was assigned?
Yes.
Okay, and
You guys, look at the reasonableness of the explanations. Well, yes, because when Juliana was on the phone, she mostly spoke in Portuguese, and we had an officer that spoke Portuguese. I'll figure out tomorrow how to say, baby, I love you in Portuguese. I'll figure it out. Baby, I love you. Okay. Right.
and what
Fair.
was the goal of listening to her jail calls?
To gather evidence.
Okay. And was
Right.
there ever any discussion amongst your group about the pressure that was applied to her relating to her being incarcerated?
Yes.
Okay. And was that something that was favorable for what your goals were?
That she had pressure because she was incarcerated?
Yes.
I mean, potentially.
Okay. Were there, in listening to all those calls and having them translated, when you listened to the ones in English, were you concerned about her mental health?
There were times where the officer who was listening had concerns, and we relayed those to the sheriff's department.
Okay. Were there times?
Also fair. Also fair. I don't know if every agency would. I hope that they would. I don't know that I could comfortably state that. But also fair. At times, when listening to her jail calls, when we had concerns for her well-being, we let the sheriff's office know that we had concerns for her well-being. Fair. Okay. His answers are reasonable.
That you were concerned about?
I wonder if that's around the time
talking about
that
the meetings that
they
she
then
been
had
with
her on
with the police
medication.
in the counsel's office?
I don't recall any concerns about that, no.
Okay, so you didn't hear any calls where he was telling somebody what's going on?
Objection leading.
Sustained.
Did you hear any calls like that?
Like what?
Recounting what the offers were or talking about the case after talking to the police?
Not that I recall specifically.
Okay. And so how often did you find yourself as a supervisor listening to those calls?
If I had free time, I tried to listen.
Was the Portuguese officer that was monitoring them, was it just on the Portuguese calls?
I think he checked all the calls and he summarized them. So from time to time, he would
Flag ones to listen to.
send a note if he thought something might be worthy of the detective or somebody on the task force giving it a listen to see what context it had.
And what kind of things
Fair.
were said?
I couldn't specifically tell you. I would have to go through emails.
To be fair to the defendant, though, I am also sick of his face. I do not think he is intentionally staring at the camera. I think the camera happens to be in the direction of the witness and the jury, because this is a fairly large courtroom. And I think the camera is over at the end of the jury box by the witness stand. And so every time he looks over at like the witness and the jury, the camera's that direction. It seems, based on all the days of watching this. But yeah, also it's disconcerting. I'd rather see the people talking. And I much prefer when they show the broader section of the attorneys, the courtroom, and the witness. It's just much easier.
So it would be something that would be beneficial to the case.
Objection leading.
Working.
Would it be something that would be beneficial to your case?
Good. I don't like it either,
Yeah.
Chad.
Yeah, I mean, anything that he thought was unusual or stood out to him, he would pass on. He wasn't directly involved in the investigation, and hadn't reviewed the whole investigation. So sometimes he didn't really know what something might mean. He would forward on.
In assigning him, did you or anyone give him parameters on what you're interested in?
He was assigned before I got there.
Okay. Did you ever educate him when you got in there what you wanted?
No, I don't think there was, like I said, he was there and had been doing that for some time before I arrived.
Now, when you arrived, what were you told to do when you arrived?
My job was to be the homicide supervisor. Also, I was asked to review this case and other open cases.
And were you told to close this case?
Well, of course, that's the goal for any open case.
Specifically this case?
Yes.
Okay. Were you told to clean house in homicide?
If necessary.
Did you ever say, or what, if anything, did you say about cleaning house of the existing homicide detectives?
I think I told all of them when I first got there that was not my goal. I hope to keep everybody who was there.
Okay. And did people leave?
Yes.
Okay. And how many people left the homicide squad?
During my time there, 5 were promoted to sergeant. I think they're all back in the Major Crimes Bureau now. And
did people leave? Yes. 5 were promoted. Is that 5 of the 8? Because counsel said 8 people are no longer in homicide. Oh, so they got promoted into the bureau that oversees homicide? Okay. Promoted doesn't count, counsel, when you present it as everybody fucked up. They fucked up so much that 8 of them were removed from the unit. Getting promoted doesn't count. Oh my God.
One was transferred out.
One transferred out.
And who was that one?
That was Detective Bryant. Or I'm sorry, 2. The Detective Bryant and Detective Hanging were transferred out.
Okay. Now, did you have any control over Detective Miller being transferred?
No.
Were you aware of Deputy Chief Brusch at the time saying that he was no longer working on any major crime bureau cases?
Yes.
And were you aware of any?
I'm sorry.
Okay. Were you aware of any proceedings for transfer for Detective Miller?
No.
Okay. So you had no say in that?
No.
Okay. Or were your discussions with Deputy Chief Brusch informing him as to his decision to transfer?
I mean, we discussed it, but that wouldn't be, it's not even our bureau at that point, so I would have no real input.
Okay. Now, Detective Bryant, he was transferred.
He was.
And that was, I guess, was the decision around the time of October 25th? Which is,
I think he was transferred in January.
Okay, but the decision, when was that made?
Shortly, I mean, probably in January, maybe late December.
Was the reason for his transfer the October 25th?
Objection leading.
What, if anything, did the October 25th recant and the time?
Based on everything we've seen in this case, Bryant was the one that was, as the other witness said, in over his head, who Smith was brought in to save. Smith seemed great. So what you're saying is, if the investigation got off the rails, they brought in someone to fix it, and that person said, we're keeping an open mind and we're following the evidence. I mean, isn't that what you want to happen? We don't expect everyone's going to get it right, but we want to know when they don't, and we want them to fucking fix it. Okay.
Leading up to it, what, if anything, did that do to hasten his transfer?
I think once Juliana came in proffered and provided more context to the evidence, everybody agreed that the evidence was overwhelming and that they had missed the mark, and he was the lead. So that's what ultimately was what caused him to be transferred.
So he was transferred because he didn't get it done. You needed Juliana.
Objection leading.
Sustained deleting?
So am I to
Also
understand
argumentative.
it was because of
Judge,
Juliana?
that's still leading.
I don't know what the question is, but okay.
Judge A is so patient.
Were there any other factors?
He missed the mark in believing that the victim was communicating on FetLife despite all of the other evidence. Okay.
That were considered?
I'm going to back that up to not step on the defense attorney's question. Maybe this will be the one that's going somewhere.
Question is, but okay.
Were there any other factors that were considered other than what you just testified to as to Detective Bryant's transfer?
When he became aware of the proffer, it was 5 days before he passed that information up the chain of command. So that also played in.
Okay.
What? Bryant became aware that the proffer was going to happen with the DAs and did not pass that up the chain of command for 5 days? Ooh, bitch. Yeah, that's going to piss some people off. That's really going to piss some people off. Uh-huh. You don't say. 5 days is a real long time. So, counsel, let me get this straight. You think this witness was withholding information from the DA's office for 24 hours. How are we going to handle Bryant sitting on this for 5 days? How are we going to handle that? What are we going to do with that? Okay.
And his leaving, was that, how was that characterized?
It was a transfer.
Okay. Was it related to discipline because he didn't notify command staff?
No, it was a lateral transfer.
Was that the circumstance of performance management that was talked about last summer?
Yeah, I would say that's the term used.
What is performance management?
Well, if somebody isn't performing at a level that you would expect for the position they're in, you might move them to another unit to gain further experience. And that's what happened in this case.
And he's now in digital forensics. Is that correct?
That's my understanding.
Was that where he was transferred from homicide to digital forensics?
No, he went to sex crimes, also in the Major Crimes Bureau.
Okay, so sex crimes and then now digital forensics?
That's my understanding. I don't have any knowledge of that transfer.
Okay, I
wasn't involved in it. No.
Anything like that. Now, he was the lead detective on this case from the beginning, correct?
Yes.
From that day on February 24th.
That's my.
I think this is the first time we've heard clearly that the lead detective on this case was transferred. Okay.
I understand, yes.
And Brendan Miller was the lead digital forensics person from the beginning of the case, correct?
Yes.
And he was the only one that worked on extracting the 60 devices and things like that. Is that right?
I believe so.
I'm still stuck on how the fuck there were 60 devices. We've definitely not identified 60 devices in this case. We've heard about vaguely the victim's phone, the victim's laptop. I assumed defendant's phone, Juliana's phone. But that's all we've really heard about. Like, is it really 60? Some of you were saying you heard 16. Fair. That's a lot of devices. I just have questions how many devices. But those are devices, not accounts. So physical extractions of physical devices. It's just, it keeps sounding like he's saying 60. Maybe it is. Let's hope it's 16.
Extracting the 60 devices and things like that. Is that right?
I believe so. There's two Brendan Millers. I think they may have helped each other out at points, but so I'm not 100% on that. But I believe the Brendan Miller you're speaking of was the lead.
Is that the one that is sitting in the court right now?
Yes.
Okay. And so that we're talking about the same person.
Yeah.
Miller's still sitting in court? Are you going to call him again?
Yes. And
Okay.
he was also transferred during that time, correct? Within a month, couple months.
I don't recall the exact time he was transferred.
Okay, but it was soon after the proffer and
Yes.
and the back and forth in terms of the emails with Sergeant Ames.
Correct. It was right around that time. So if you put that exhibit up, I can give you a better ballpark.
If I said November 7th, November 8th, would
So defense, what you're getting at is that the two people who thought that Christine Banfield was on her devices setting up a FetLife encounter, knowing the other things on her devices and knowing the nature of the encounter that she was setting up and knowing everything else about the digital forensics and the pattern of life, knowing all of that, the two people who thought that Christine Banfield was the one setting up the encounter with Joseph Ryan were the two that were transferred? Is that the point that you're making? That out of everybody involved, the two people that thought that Christine was operating the FetLife account were the ones that were transferred because they got it wrong. Is that what you brought all these witnesses in to say? Okay.
would you believe me?
If you're representing that that's what it says, then I will accept that.
Yes.
That sounds about right.
And so now I know you weren't in homicide for long, right?
About 11 months.
11 months. And that was before you were transferred.
Correct.
And prior to that, were you ever in homicide as an investigator?
I was not in homicide, but I've been an investigator for most of my career.
Okay.
Or supervised investigations.
And your career as an investigator was in narcotics, correct?
Primarily before I came to the police department, I did fraud investigations as well.
Okay. With another police department?
That was the feed, not y'all. So you're telling me you have a background in fraud investigations? So lots of digital forensics then?
With a private insurance company or insurance agency.
Oh, okay. But
insurance fraud. Interesting.
In terms of your experience, police experience, you hadn't had any homicide experience up until you got there on March 2024.
Only peripherally. A lot of homicides relate to narcotics, so from time to time we would be involved in that aspect.
But you're never the lead detective or anything like that?
No.
Now, in your experience, does it seem odd?
Thank you, chat, for reminding me that I lost the
Objection
caption
meeting.
with the stream glitch. That was so odd.
I don't know what the question is, so if you want to continue your question. I can't remember
Does it
yet.
seem odd that the chief detective of this homicide case and the chief digital forensic examiner were transferred around the same time?
Warning, warning, danger, 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 defense, danger, danger. You don't want to ask this question. Does it seem odd that they were both transferred? No, they both got it really fucking wrong. Nope, I don't. Oh dear. Nope. Back up. Counsel, back right up out of this question. Boop, boop, boop. Back it up. Back it up. You don't want to, I don't think you want to do that.
I don't know what the question is.
But we really want to watch it happen. So we're going to rewind it and just watch it happen. That seems like a bad plan.
Mention it all.
So if you want to continue your question. I can't remember
Does it
yet.
seem odd that the chief detective of this homicide case and the chief digital forensic examiner were transferred around the same time?
No.
Have you ever seen a case where the lead investigator is transferred and another lead investigator is transferred prior to it coming to court?
The lead investigator transferred? Yeah, I mean, that happens all the time, I think.
In homicide?
In any case, I think there's
Yeah.
plenty of homicide cases where they've come to trial and the homicide detective has moved on through promotion or to another unit prior to the trial. That's pretty normal.
Well, there's a distinction in the way you said that. I'm talking.
Objection, counsel's testifying.
Let me ask you a different question.
Leading. It's actually kind of argumentative more than leading, but
If the case is getting to the point where it hasn't gone to trial and a homicide detective is moving, that's different than what you just testified to.
no,
right?
it's not.
Objection, leading.
Overruled, hold on.
I think that's exactly what I just testified to. Sometimes there's an arrest, there's a transfer, and then there's a trial.
Okay. I think, I mean, I don't want to quibble with you about it, but I think you had said once
That
the
would be
case has
argumentative.
gone to trial, then the person transferred.
No, that's not, if that's what came out, that's not what I intended. I don't
Perhaps I
think.
misunderstood.
Yeah, I think it's relatively
Yeah, counsel, it's
normal
probably
for
you.
a homicide detective to leave the unit, whether it be for transfer or promotion, and then still see the case through to trial.
Okay. And when you were transferred, did you have any additional duties with regard to this case
No,
beyond what you had as a watch commander?
By transferred.
not
they
really.
mean
I mean, I
promoted.
provided what I had and moved on to my new assignment
You gave your OneDrive and then moved on?
for the most part. Obviously, I've been here to testify a couple times here with you.
So other than being subpoenaed, you're,
No, I didn't have any more investigative responsibility with the case.
are you aware of whether or not Deputy Chief Brusch, then Deputy Chief Brusch, now Mr. Brusch, has played any role in this investigation since he was transferred to the Administrative Support Bureau up until he left the?
I'm not aware.
Okay. Are you aware of any duties that Kyle Bryant, who was the chief homicide detective, what duties he's had since he was transferred?
My understanding is he remains the lead. He remained the lead when I left, to put it that way.
Okay, so he was actually still involved in certain things, is that correct?
I believe so, yes.
Was that while you were still there, or did that happen after you left?
Well, he was transferred when I was still.
Counsel? Not legal advice, just practical advice. I'm sure you've been practicing a lot longer than I have. I mean, I'll stack my 20 years up against a lot of people, but I'm you have a few more gray hairs than I do. The one day I hope mine are equally as glorious. However, one of the key components to questioning a witness, especially when you don't have a direct examination seemingly prepared at all, is to listen to the answer. You have to listen to the answer. You have to listen to the answer. That's it. You have to listen to the answer.
Still there, but my understanding is he's remained the lead, and if that changed, that would be news to me.
Was that in talking to him?
In talking about.
Is that how you learned that? You spoke to?
Well, I was still the supervisor, and I told him that he will remain the lead.
Okay. And he carried out his duties as he was supposed to, as far as you know?
To the best of my knowledge, yes.
Okay. And then with regard to Brendan Miller, do you know whether or not he had any responsibilities or obligations with this case?
I don't
After
know.
he was transferred?
That I don't know. I would assume so since he was the lead, but I don't know the answer.
Okay. And in any of the communications about transfer, you weren't privy to that?
So right when he was transferred, there was a couple of weeks where we talked about reviewing and he was going through the evidence. Beyond that, I don't know.
Okay. You didn't keep track of it?
No.
There probably wasn't any reason to keep track of it, right?
Right. I moved to a new command.
Okay. Here, I'm sorry, 102.
You should
has been
be.
moved into evidence?
102 is in evidence.
Okay.
You shouldn't just apologize to the court. You should apologize to the jury. You should apologize to the jury.
Now, were you when you were speaking to the victim's family, you indicate that you're on a call with Joseph Ryan's family?
Judge, can we identify the exhibit?
Which exhibit?
I don't know what we're looking at.
Is it still 102, correct?
Yes.
Okay, thank you.
I think it's written on the bottom right corner.
I can't do that.
So were you the main contact for the Ryan family and the Banfield family?
No.
Okay. What was the phone call about?
I think that was filling them in. Well, I don't know. It may have been to fill them in that the proffer was coming, but I don't recall. Looks like it was right before, so I would imagine, but it wasn't a phone call that I set up or led.
Okay, would that be under your umbrella, I guess, or would that be victim services?
I think that was in concert with victim services.
Okay, and so in concert meaning you were on the phone with someone from victim services?
Yes, I wouldn't have made that call without victim services, but to the best of my recollection, I believe I was just a silent observer in that call.
Who else was on there?
I don't know. I believe that, I don't want to misspeak, I'm not sure.
Okay, I mean, how many times did you talk to the victim's family with someone from victim services?
At each of the hearings, I mean, they were in town, we always tried to be in the room, or if there was an update, we would update them.
Well, I understand that, but I
Good.
mean, was this a phone call?
Counsel, he answered.
I believe it's a phone call.
Okay, and so would you oftentimes call the Ryan family or the Banfield family?
He just answered.
Primarily, it would be in-person meetings when they were in town.
Okay. And this call would stand out as not being the usual contact?
No, it's just in a text.
I don't remember specifically the call.
This call would stand out? No, it's in the text message you're asking me about. It doesn't stand out. It's just there. It's just in the text that I'm on the phone with them. Right.
Based on the date, I would imagine that it was to notify them of the proffer.
Right. Keeping them up to date on changes in the case or the movement of the case. Right. You also don't want them to hear about it
Sir,
in the
can
media.
you see what's on your screen?
You want them to know what's happening in a case. You want them
Yes.
to know how
And
it's
have you
moving
reviewed
forward.
What number is that?
Sorry, Defense Exhibit 103.
103, thank you.
Okay. Moving on to 103.
Yes.
Do you know when that text occurred?
I believe that was during the proffer.
Okay, so you were in the adjacent room,
Correct.
and you were well, you tell me, who are you texting with?
Deputy Chief Brusch.
Okay, and you're going to move that in as
All right, any objection 103?
No, ma'am.
103
Defense Exhibit
evidence
103.
Published.
so.
Yay, it's going to be
let's-
published.
let's
Maybe
go
we'll get to
through
see
this.
it. This
It's
attorney
tough to see
managed to
what's
take
under the
text
banner.
messages and make them painful to go through.
There. Do you know what you wrote?
Do you know what you wrote? He's fucking looking at it in front of him. I can't do this at 1.25 anymore without actually crashing out. We're just going to just put this at 1.5 and just hold on for dear life to try to get through the most painful direct examination of, do we have a point? This could have been half the time, if not less. It's just not organized. And that's why counsel keeps asking the same question 7 times, because it's just not organized.
I think it says no real response yet. I did let Klingon know.
Okay, and you think, and you said this is
And we're at
while it's
1.5.
going on?
I hope we'll get to see the text on the
Correct.
screen.
So were you communicating via text with Klingon at the same time you were communicating with Patrick Brusch?
So we had a
Yay! In the text messages, the very top says no response yet. I didn't let Klingon know. Ha 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 ha. What did Klingon say to you? Klingon being the former prosecutor. I told him I would accept his humble apology in writing. He said, you, Patrick, were right all along. Well, at least he gave me that. Yup. If it hadn't been for me, you, and Sally, this never happens. Confirmed call. So the original prosecutor didn't seem to agree with the catfishing theory, which honestly is just baffling to me. But it seems like the original prosecutor didn't agree, and the defense attorney, let's just process this for a second. The defense attorney has chosen to put the text messages where law enforcement is gloating that they were correct based on the theory that the prosecution's presenting in this case that he is trying to disprove? And saying that the other lawyer originally wasn't on board and came around. The other lawyer who was not on board with the theory that the prosecution's in court now came around and said, I'm sorry, y'all were right. My bad, y'all were correct. Kind of like the case we're in now. Aren't you trying to prove that this is not the correct theory, counsel? Because I've heard counsel, you've said the whole time, there's no catfishing. There's no catfishing. There's no catfish theory. There's not even catfish on the menu for dinner. There's no catfish. And alas, I told the prosecutor he could apologize to us for being fucking wrong. No wonder they weren't getting along with the prosecutor. Oy, oy, oy. What's the strategy here?
Group thread for questions, and then I was communicating with Deputy Chief Brusch as well.
Okay. Who was on the group thread that you're talking about?
I believe it was Mr. Klingon, Detective Goodell, Detective Bryant, and Ms. Bristler.
Was Detective Miller on there?
No.
Was there anybody on there that had expertise in digital forensics when those questions were being asked? Was he still in his position at the time this took place?
Yes.
And was there any reason why he would have been excluded as the expert?
So for the investigative and interview stuff like that, it would be the homicide unit, and then we shared that video later with him.
Okay.
Sorry, I didn't read that fast enough. Let's see. If it hadn't been for me, you, and Sally, this never happens. Confirmed call. Ha. She was the one on the phone, you mean? Yes, this is actually making me angry. So they're texting about what's happening in Juliana's proffer, and he is saying to Brusch, who just testified, confirmed call. Juliana's the one that called Joseph Ryan. She was the one on the phone. Juliana was the one on the phone with Joseph Ryan, which is it sounds like what they thought all along, which is why the other one is saying, this is actually making me angry. Well, right. Because he already knows about the dog shit plea deal that's been offered. Of course he's getting angry. He's like, I was so correct that I'm actually pissed. Where are the text messages that undermine the investigation? I'm struggling.
For the investigative and interview stuff like that, it would be the homicide unit, and then we shared that video later with him.
Okay, but
them going back and forth. Oh my God, we were so right. This actually hurts my brain. Okay.
Was there any benefit to having his perspective, like it would any other part of the agency that did some investigation?
I mean, I think there's a number of people you can have, that are present. So we made it the task force and provided that recording to everybody else afterwards.
Okay, but there would have been room because there was an ante room that you were in.
Counsel, that's the prosecutor's call. The prosecutor gets to decide who's in the proffer.
Sure, there would have been room.
Okay, and so who made the decision to exclude Detective Miller?
Mr. Klingon determined who was going to be there.
Okay, that's different from my question.
That's exactly an answer to your question. The prosecutor gets to decide who's in the room where it happens. And counsel, everybody wants to be in the room where it happens. But the thing is, you're not always there when the sausage gets made, counsel.
You just answered my question by saying he determined who was going to be there. Was there anybody who excluded Detective Miller?
Mr. Klingon, I guess. I mean, he determined who was going to be invited.
And okay,
so I imagine the converse would be true.
So because he wasn't there, it had to have been Eric Klingon.
Objection, counsel's testifying, and I think that would be a mischaracterization of the defendant's witness statement.
Sustain the objection. Next question.
I don't want to mischaracterize. Tell me what you were just saying about who was invited and who wasn't.
Mr. Klingon, I believe in concert with Ms. Bristler from the prosecution team, determined who and where this would occur and who would be invited or excluded.
Now, it looks like there's additional back and forth chat. What's that about?
No, you didn't. There's additional back and forth chat. What's that about? Counsel, you really want him to explain why they're gloating that they're right? Seriously? However, counsel, you know what? We're learning more than we did yesterday. I don't know how it helps your case. I'm really struggling to figure that out, but we're learning more than we learned yesterday. So have at it. It's a bold strategy.
It's about the, has been characterized the catfish theory.
Right.
And does that highlight the dispute as to who believed in it and who didn't?
I think that's fair, yeah.
And is that why you said you were looking for an apology?
Wow.
Yes, I think we had back and forth. I advocated strongly that I didn't believe that Christine had set up or sent any of those messages. That wasn't the theory that went forward until Juliana came in and told the truth.
So this is a celebration of you being right.
I don't know if I would call it a celebration, but it's a...
Chad, how would you characterize the text? I mean, celebration or just a, we're right? Obviously, we're right. Some of you are saying validation. Right. I told you so. Wouldn't it have been nice if you listened to us? Some of you are saying vindication, gloating. A lot of you are saying affirmation, validation, vindication. Right. Boom, we were right. I mean, they're listening to Juliana and texting. She's saying exactly what we thought. She's telling us it's going down the way we thought it went down. So confirmation. Uh-huh.
Yeah, a realization. Confirmation.
And then it looks as though
Chat, you took the words right out of his mouth.
everybody's telling everybody how great they were. Is that?
Objection leading.
Sustained leading.
What's the rest of it about?
I think it's just acknowledging that we had gotten it right, and that now everybody was on the same page, and that nobody believed that we were not right.
Okay. And so you arrived at the determination.
Counsel, keep asking the witness how correct they were in their investigation of this case. We were right. Everyone agrees that we're right. And now we're here looking at your client.
That you were right because Juliana Perez Magalhaes told the story.
Yeah, I think she filled in the blanks, but by and large, what she said was consistent with what I believe the evidence showed pretty much within my first 30 days of being involved in the case.
Wow.
Okay, so were you aware that it was 2 weeks before trial when this proffer occurred?
Yes.
Okay. And was it your position that you needed her to testify against Brendan in this case?
I thought it would be helpful,
not his call.
but I don't think it was necessary based on the evidence.
Wow.
And your opposition to Detective Miller's executive summary was based on her testimony, correct?
No, I opposed it from pretty early on, but I think it was confirmation and gave context to a lot of things that were in there.
Okay. And it was at that point that you worked through his chain of command, Sergeant Ames, to get him to change the executive summary, correct?
I never asked him to change anything. I asked him to review it, be able to explain why he arrived at the conclusions that he had, and to be able to explain.
He asked their expert to defend his work. Okay. Please come here and explain your conclusions. Okay.
Why he doesn't believe that to be the case anymore. And my understanding is that's what he did.
Not with you?
Not with me, no.
Okay. Did you ever go and ask him what his original position was?
I think it's well documented in his summaries. I mean, we discussed it.
That was an inartful question. Did you ever ask him to go through like a math problem and show your work as to how he arrived at those conclusions?
Yeah, we looked at it time and time again.
Okay. But I mean, I'm talking about a comprehensive explanation based on his expertise that arrives at his. Did you ever do that?
Judge, I'm going to object to ask and answer, not just now, but earlier prior to the break.
Sustained. Next question.
When you say you talked about it from time to time, is
Thank
that
God.
a comprehensive review of his work?
Counsel, can we please keep up with the asked and answered objections? Counsel, thanks. That would be great.
I mean, we spent a lot of hours in his lab, yes.
Okay, and
Lab. They
were
said
you
lab.
questioning him?
I mean, we discussed all the things. There was something in the digital side that I didn't understand. I would ask him to explain to me what he felt that it meant.
Okay, so at least one aspect of whatever you didn't understand, you would ask for his explanations. I guess what I'm asking is, did there ever come a time when you had him explain his entire report?
Probably not all at once. Obviously, it was, there was extensive evidence, but we went through the significant chunk of it in his lab, yes.
Now, just specifically with regard to the executive summary, when did you recall, when did he complete it, and when?
You guys, it's almost like when you're reviewing a lot of work, sometimes you review the work in parts and then those things just build on each other and you don't keep repeating it. You just keep reviewing the new things. Right.
When did you see it?
He completed it prior to my arrival. So I saw it, sometime probably in that first 30 days in March of 24.
Okay. And at any point, did you agree with it?
I think in the first bit, I just took it all in. I tried to take in all the evidence. I spoke with a number of detectives and sort of got their impressions, and then I reviewed it. And then I had questions about the analysis. I think
I have questions too.
The issue is it was not the data that I had issue with. It was the interpretation.
Right.
Okay.
Kind of like what everybody said.
Surrounding the data.
For instance, he attributes things to people rather than devices.
Okay. And is that
right
something in your digital forensic experience that's not best practices?
I think it's difficult to say who's holding a device if you don't have a lot of context.
I think that's, isn't that why digital forensics is what it is?
Well, they extract data and look and tell you what's going on. And I think probably some of his analysis went outside the bounds of what he would normally do.
And
the defense is literally asking, isn't the point of digital forensics to tell us who's holding the device? No. It's to tell you what the device is doing and then try to gather as much context as you can to see if you can figure out who's holding the device. But it's never going to tell you who's holding the device without context and generally the person saying, I was or was not holding the device. No. The jury can make those conclusions, and sometimes those conclusions are easier to make, and sometimes you can't. Isn't that what digital forensics is for? That's exactly not the fuck what digital forensics is for, counsel.
Did you ever directly address him about that statement you just made?
Yeah, we discussed it, and I think he agrees.
You think he agrees?
That it was beyond what he normally does, yes.
Okay.
He testified to that yesterday.
Were you aware of the peer review of his executive summary and files?
So there was stuff sent down to University of Alabama, I believe. My understanding was that they were trying to do a deeper dive into certain devices and see if they could pull more information than perhaps Fairfax County has the ability to pull.
Were they able to do that? Do you know?
I don't think they really got much further than he did.
Were you aware that they concurred in his findings?
My understanding is that they concurred that he extracted things properly and that the data was correct.
Did that peer review change anything in terms of?
It's almost like that's exactly what the last witness said. That the peer review was that the extraction was proper. It's almost like that's what the Miller B3 said. Because B3 said that he stands by the extraction, that the ones and zeros don't change, but that he has changed his mind on his conclusions. He said that yesterday.
Your position as to the executive summary.
I'm sorry, I lost you. Can you speak into the microphone?
Sorry. I'm sorry. Did the peer review change your thought process as to the executive summary that he had created?
I think it gave me confidence in the data, but it didn't affect the analysis part of it.
Okay. And so perhaps I've asked you this. What was your experience in the analysis
Probably.
of digital forensics?
Well, you're looking at what the data is. I've been an investigator for almost 2 decades. So I've looked at lots of data and developed theories or trends, stuff like that.
He didn't do the
Can't anyone
extraction.
do that?
Objection, argumentative.
Sustained. Next question.
But can't anyone do that? Yeah, counsel. People can read the extractions once they're done. He didn't do the extractions.
Would that be difficult for anyone else to do?
I don't think so. I mean, I've spent a lot of time in investigations and putting things together, and you look at, patterns of life and how people act and how humans behave. And this is just more data points to look into.
Now, and that's what, is that what differentiates experts to investigators?
Well, I think the expert,
Objection, relevance. I'm not sure where we're going with this. He's not an expert. He's testifying as his recollection of the events.
Well, I think the discussion is about Brendan Miller's work.
I'm going to sustain the objection. Next question.
Counsel, I don't know if you know what the discussion's about. It's like 3 witnesses have stood up there and said the extraction was fine. The data was sound. The conclusions derived from the data were improper and wrong.
So I'm going to ask you to look at.
Also, I think what's going to be easier for the jury, let me know what you think, chat. I think it's going to be easier for the jury to look at all of them saying, yeah, the information extracted is what it is. The conclusions that were made are wrong. And I think when the jury looks at what makes the most sense, I think they're going to, at this point, come to that conclusion too. The data is what it is. But to conclude that Christine was the one on the devices doing those things defies, quite a lot of logic given everything that we've seen. I actually think the prosecution's case has somehow gotten better with the last 2 witnesses. Wild. It's not what you want to do in the defense
Number
case.
104. Is that yours?
yes,
And that's with Deputy Chief Brusch?
yes.
You're going to move that in as Defense Exhibit 104?
Any objection?
No objection. We also would not object to 105 as it appears to be page 3 of this same conversation.
Okay, 104 and 105 in evidence.
Shut the fuck up. Shut the fuck up. This man was marking individual pages as their own exhibits.
Sir, you're
What?
in the blue, correct?
Yes.
And so your first statement there, what does that mean?
Which
The first statement in blue.
I'm sorry, without the microphone, it's very difficult to hear you and understand.
The first statement in blue?
I don't
B
blame
guided her
the,
through was
I
B was
don't blame
Brendan.
the witness.
Oh, so you're recounting her story?
Correct. This is during the proffer.
And is this in the ancillary or
Correct.
the ante room of
Yes.
Okay, gotcha.
Ooh, more texts. Oh, this is the continuation of the last text that we saw. We got to, this is actually making me angry. And then B guided her through. And then, because 90% of people we work with are absolute morons. Okay, somebody got name called. There we go. 90% of people we work with are absolute morons. The response to that is the 2 exclamation points. And then it says, so the only thing we may have gotten wrong is you and I believed Christine was dead before Joe got there. So the timing. Now, when we saw all the texts in the Karen Reed case, I couldn't have clutched anything harder. I was stunned at some of the messages that we saw. I'm yet to find any shock in these messages, other than maybe they could have used stronger language about the offer being dog shit. But why is the defense doing this again? Maybe the defense wants to say that I don't know who B is. B guided her through. Maybe this is the point. The point of the whole thing is that Juliana was force-fed the information? Maybe? Is that where we're going?
And this is Detective Brusch's statement?
That's Deputy Chief Brusch speaking, yes.
Deputy Chief Brusch, sorry.
Okay, so continuing on as this is scrolling. So the only thing we may have gotten wrong is you and I believe Christine was dead before Joe got there so far, which all intensive purposes made total sense considering what we knew. The plan was not for her to shoot unless things went wrong. Juliana. Interesting. Joe was writhing, so she shot. Had gun on her the whole, I imagine that says time.
And did you have any?
Also, chat, yes. I also, it's not intensive purposes. I don't know if that is all intents and purposes. Yes, I don't know if that's an autocorrect or just misuse of phrase, but yes.
In your
That's
text
what was in the
group, did you have
text.
any say in any of the questions that were being asked?
Yeah, so we, in the text group, if there was something we wanted to explore, we would put a question in there, and then Mr. Klingon would either ask the question or not, depending on, his expertise, I guess, as a prosecutor.
Okay.
So what you're telling me is that if law enforcement had some questions, they just texted it to the prosecutor while this was going on? Okay.
Sir, it looks as though 105 has been admitted to evidence.
Yes, that's correct.
Do you recognize that?
Why didn't
Yes.
we just admit
Okay,
these
and is
all as
this
one
part of the
exhibit?
chain of text messages back and forth?
Right, it's a continuation of the previous exhibit.
And
Why are we doing this?
the discussions in, I guess, the gray is then Deputy Chief Brusch, correct?
Yes, sir.
And then you're in the blue responses?
Yes.
And so these are what you guys are in this, well, tell me what you're talking about there.
So we're recounting some of the stuff that's coming on from the proffer and talking about some of the days leading up to the proffer. And then sort of, the response of people that became aware of it.
And the discussions about specific situations, those were your theories going in, correct?
Well, confirming the account that Brennan and Giuliani created the account is, yes, part of our theory. And then the revenge rape or was she dead was a question as part of that theory as well.
And it looks as though Klingon is a prosecutor, correct?
Yes.
And there was comments about him?
Yes.
And what about Kyle and Tommy? Who were they?
That's Detective Bryant and Detective Goodell.
Okay, and those were the two head detectives at the time?
Correct.
And is that just banter between the two of you?
Yeah, it's a text thread between the two of us.
Okay.
So I'm going to ask you to look at defense
How?
number 108.
It's interesting that that the defense is bringing in some of these texts. Also, I saw just one or two chats about him fidgeting a lot. Just please keep in mind, I have this sped up to 1.5. I know that that's really hard to believe based on how they're speaking, but I have this sped up to 1.5, which is going to really change the way people are moving because I have it sped up so much. And I know that hurts your brain because of how slow they're talking, but this is at 1.5 speed. I'm very confused that they are bringing in all of these
Is that your
messages.
communication?
Yes.
And who are you communicating with?
Deputy Chief Brusch.
Trying to move that in as defense exhibit 108.
Any objection?
No,
Want to wait in evidence and publish?
So it looks like, well, tell me what you're saying here.
Which part?
This part.
Tell me what you're saying in the texts.
I think you just pointed at Deputy Chief Brusch's comment.
Okay, were you part of that?
Oh, God.
Yes, I think what it's referring to
Tell me what you're saying right here. Proceeds to point to a text sent by not him.
is where I say this is good. She confirmed that he would send her home a little early from the gym so she could post when he was not in the house.
All right, I'm going to read this text in too. It starts with, are you alone or no? Yes, listening now. This is good. She just confirmed that he would send her home a little early from the gym so she could post when he was not in the house.
Which was confirmation of some of the digital forensics, where you could see that Giuliana's device and Brendan's device were at the Lifetime Fitness in Reston.
And then it looks like Brusch says, so it's okay to tell Chief and Brooke it's 100% a catfish. It's interesting that they're choosing to put these in.
And then Giuliana would leave, and as her device would leave, as she arrived at the Stablebrook address.
I don't think this is responsive to my question.
Are you going to ask your question again?
Yes.
It's finally happened in this case. So I'm going to back up. I'm going to put this at 1.25 out of pure pettiness because the defense has finally objected to the answer to a question that he answered or asked. I don't think this is responsive. Your Honor, help. He's saying shit that hurts our case.
Comment.
I just wanted to hear it again.
Were you part of that?
Yes, I think what it's referring to is where I say this is good. She confirmed that he would send her home a little early from the gym so she could post when he was not in the house. Which was confirmation of some of the digital forensics, where you could see that Giuliana's device and Brendan's device were at the Lifetime Fitness in Reston, and then Giuliana would leave, and as her device would leave, as she arrived at the Stablebrook address.
I don't think this is responsive to my question.
Are you going to ask your question again?
Yes.
Yep.
This area up here, does that indicate that you were still in the room?
Yes.
Okay, so this is while this is going on?
Mm-hmm.
And the things that you're reporting to Deputy Chief Brusch at the time, are those some of the questions that you were sending in or some of the things that you were trying to get the au pair to say?
I'm going to read the text next because I don't think they're going to read them all in. But after we got to, so I can tell them it's 100% a catfish, it says yes. Then the last witness texts, anything else juicy? Not this witness text, nothing too crazy so far. She is ice cold. Then, but she confirmed they created the account. Yes. And then they go on from there because it seems that law enforcement might have thought that the defendant wanted Christine to be assaulted, which is rough.
I wasn't trying to get her to say anything. We were trying to ask questions to get to the truth.
Okay. And were you asking questions regarding that particular incident you just started wanting to talk about?
So that's something I think that came up.
I don't know why the defense would want that. I don't know why the defense would want that in, that police thought that he wanted his wife to be assaulted. Okay.
Juliana put that out there without being prompted. But like I said, we confirm it with the digital evidence, and it was, corroborating what she was saying.
Now, when she confirmed that she created the account, did she tell you what the email address was?
I don't recall.
Did she tell you what the password was?
I don't think so, but I also don't think she specifically said that she created the account. I think that she said Brendan created the account.
Okay. Did she say that she was there when Brendan?
Objection. Calling for hearsay.
All right, I'll sustain the objection.
Okay. Was there anyone in the text group asking her or suggesting questions to Mr. Klingon regarding the account platform?
I don't recall.
Was there anybody suggesting questions in what you saw?
I mean, you could have asked her. She was on the stand.
Regarding the passwords?
I don't recall. I do remember that Mr. Klingon had a list of, I think, over 100 questions that he hoped to get to. So a lot of that was covered in there.
Do you know what the origin of those questions were?
I think his review of the case. I don't know, though.
Okay. What, if any?
Counsel, lawyers generally like to prepare when they do things. In fact, they tend to lean a little bit more perfection-y and maybe don't get stuff done if they don't feel fully prepared. But no, lawyers like to prepare things. So no, I imagine that the lawyer going into the proffer prepared exactly what he wanted to ask. That might be news, but
anything did you know about any meetings that Juliana Perez Magalhaes and her attorney had with Mr. Klingon prior to that?
I'm not aware of any, but if it happened outside of my knowledge, I couldn't tell you.
Okay, so it was your impression that she walked in there and...
Objection. Counsel's testifying, leading.
What was your impression of the interview?
She appeared truthful, and we were able to corroborate a lot of what she said.
Oh, okay.
Defense, your whole theory of the case is that Juliana's a liar. Why would you ask this witness? We knew what he was going to say because we've been listening. We knew what this witness was going to say. Everyone saw that from a million miles away. And yet the defense is like, what was your impression of her interview? Oh, that she was truthful. Yeah. Truthful, credible. And all of the evidence that we have before her, yeah, it all lined up. This is a choice. This is a choice. I'm gonna just watch it again because that's funny. That's funny.
I'm not aware of any, but if it happened outside of my knowledge, I couldn't tell you.
That's funny.
Okay, so it was your impression that she walked in there and
Objection, counsel's testifying, leading.
what was your impression of the interview?
She appeared truthful, and we were able to corroborate a lot of what she said.
Oh, okay. I mean, is that the measure of the truthfulness for you?
I think when you see interviews and conduct interviews over a course of a career, you start to kind of get a feel if somebody's being truthful or not. And one of the ways we do that is corroborate through other evidence.
Okay.
Why would you ask that? Sir, how did you assess her truthfulness? Well, counsel, I watch and take part in a lot of interviews. I do this, in fact, professionally. I've been an investigator for a really long time now, and it seems that the thing on my record is that I was involved somehow in helping an employee that had a brain tumor. So, no, you get a sense for whether or not people are being truthful, and then we had independent evidence that corroborated it. So you called this witness, and now you're letting this witness tell the jury that they absolutely believe Juliana. And in fact, the independent evidence corroborates with her as well. The prosecution couldn't have asked that question. The prosecution could not have asked that question of any of their witnesses. And so here we are with the defense asking, how did you assess that interview? I found her to be incredibly credible. Mm-hmm. Interesting.
With regard to your digital forensics that you did, and
He didn't do
forgive me
digital
if I've asked you
forensics.
this, but it's something that I want to make sure we cover.
Counsel,
Did you ever extract
Counsel, you're now pulling the dirt back in on yourself. You've covered quite a lot.
anything from any of the phones or devices, or I think there were 60 of them?
No.
Okay. And I think you'd said that you don't have any problems with the data that was generated from those.
No, as far as I can tell, the data appears to be extracted, in compliance with the industry standards. And as you said, University of Alabama confirmed that.
Okay. So what did you do to determine what the industry standards were and what he did?
I just took what the Detective Miller represented to me and the University of Alabama report.
Okay. So he says this was industry standards and you accepted it?
Yes.
Okay. Nope. So there wasn't any real, to inform your
That's not what I meant.
conclusions, there wasn't any real
That's what I meant.
investigation.
Objection, leading.
Was there any investigation relating to digital forensics that informed the conclusions that you were working from?
I reviewed the data. I don't think I did any quote unquote digital forensics work. He provides data. In this case, he provided some other reports and summaries, but the data is the data. You can look at it and sort of figure out what it means. And if there was something I didn't understand, I would ask him for help. But it was the analysis, I think, of that data that.
Counsel, he's saying it was obvious.
Okay.
To him.
Court's indulgence.
All right, yes, sir.
No, no indulgence. You guys, I know you're with me in, the fact that we end up seeing the defendant's face way too much. How do you think the defendant is feeling that this testimony is going? Because I can't imagine how frustrating it would be to sit there and watch your attorney do this. It looks like the defendant has some questions that he wants his attorney to ask. And he got a Post-it note from his associate. Oh, boy. All right, defense is back at the podium with a handful of papers. I'm still at 1.5, by the way.
Sir, this is Defense Exhibit 104. I think you've previously looked at it. This particular statement right here on the October 25th, that was when you were still in the anteroom where the recant was happening, correct?
Correct.
And that's a statement that you wrote. Is that what was said?
I mean, that's my understanding of what was said. I don't recall the specific wording.
Okay, but you were in the moment and you said that.
Yes, that would be what I understood it to mean.
Okay. Now, did you, I know it was a goal, or I won't say it that way.
It's an own goal, counsel.
One of the
this whole witness is an own goal.
things, what if any,
Chat, yeah, I know. It defies belief that we're at 1.5. We're at 1.5.
I'm sorry, Judge, strike that.
That's right.
I want to make sure. Was there anything that occurred in the recant when you were in the anteroom that challenged any of the questions that she was asked, or any of the answers that she gave?
I'm not sure what you're trying to ask me. I'm sorry.
Was she challenged on any
Neither does
points in this recant?
You mean, did Mr. Klingon ask her clarifying questions? Yeah, I think so.
Okay. Do you remember any of those?
Not offhand, no.
Did, so the people that were in the room,
Where it happened, room where it happened.
and I can name Detective Bryant?
Detective Bryant, Detective Goodell, Miss Sprisler, Mr. Klingon, I think Mr. Campbell and his co-counsel may have been in there as well, and Juliana.
Okay, and that was it.
It's a lot of people in a room.
I believe so.
Did anyone
Like a
else,
conference room.
other than Mr. Klingon, ask questions of Juliana Perez Magalhaes?
I don't think so.
Did anybody?
Did I slow it down to 1. Oh,
if you
my
had a
apologies,
vantage
Chad. I
point to see
did.
that-
I slowed it down to 1.25 and forgot to go back. No, it's my apologies, Chad. I was at 1.25. That's on me. I owe you an apology, my deepest apologies for the pain.
Did anybody
We're going back to 1.5. It's so bad.
interrupt them to try to get a
It's
point
so
across
slow.
before he asked the question?
I didn't have the ability to monitor the room. I could only video monitor. I could see it on the phone, or got me crossed up there. It was just an open phone line, so I couldn't see anything
I'm
until
sorry.
afterwards.
So there was no video.
He could only hear what was happening. He couldn't see a video feed of the interview. Fine.
No, I couldn't see into the room.
Did you hear anyone challenging like a detective would to what she was saying?
Objection leading.
Dana speaking.
It's also an argument.
What if anything?
Not a cure-all.
What if anything did any of the detectives or the prosecutor do relating to issues that came up in the questioning?
I don't remember specifically. I think the plan was for Mr. Klingon to do all the talking from the prosecution side. I don't know that any detectives actually spoke during that proffer. And there were definitely times when he asked clarifying questions, but as to specifics, I'd have to watch the video. It's been quite some time.
Okay, and I guess that brings up another point. Is it unusual in your investigations to have the prosecutor question the cooperating co-defendant versus a detective?
No.
To me, it was a little unusual in a state case. In a federal case, that was standard.
Right, but in federal cases,
Objection, counsel testifying.
there's a little more.
It's not weird that the prosecutor would want the proffer if they're offering a deal for a witness that they're going to call. That's not weird to me. But okay. Does it matter?
He's still testifying.
Next question.
And did you know whether those people in the room could say something, or were they told not to say something?
My recollection is that the plan was for Mr. Klingon to do all the talking. I don't recall there was a, specific statement that nobody else should talk, but that was the plan going in.
Were you involved in any sort of a breakout session between the groups, between the recants?
I'm not sure what you're asking me.
Well, there's, and I think it was on your email, there were two proffers. And so there was a break between 1 and 2. Do you recall that?
Yeah, I wasn't present for the second one. I had been transferred by then.
Well, no, sorry. There were 2 separate recorded proffers on October 25th. Were you aware of that?
No, there weren't.
Yes.
Okay. And
He said earlier there were 2 different body cameras that recorded it. So there were 2 recordings of the same thing, is what he testified to earlier.
And then I think on February 7th, there was another proffer. That's probably what you're thinking of.
Yeah. So in the first proffer, between the 2 sessions, we had food. We had taken Juliana out of the jail prior to her receiving a meal, so we provided her some pizza.
Okay. And
Oh,
then were you there for the second?
they took a lunch break. They gave her pizza, counsel?
Portion?
Yeah, I was in the room next door listening.
And-
Same through the whole time. There was just a break in between.
Okay, so and the break occurred where everybody could join together?
Yes.
Okay, and in that, was there any sort of a discussion amongst the potential questioners that were in the room?
Not that I recall. We kind of scarfed down some food and got back in there. It was starting to get late.
And so it sounds to me like, so Eric Klingon basically controlled the whole process.
Yes.
Was he willing to take input from you?
Yes.
He did. Did he take input?
Yes. Like I said, we had a text group where we, provided questions and, and I kind of remember in some cases we would send a question, but by the time, he kind of finished the thought, he already got to that question. And then there were some times where he asked the question. I don't remember the specifics. I just kind of remember that flow.
Was it ever suggested that she take some sort of a lie detector or anything like that before she would be offered that plea?
Judge objection. It's not relevant.
State objection.
Was there any discussion as to how to confirm her veracity by whatever means?
Was there a discussion on how to confirm her veracity? Hasn't this witness said like 15 times that what she said was supported by the digital evidence? So, what?
Yeah. So like I said before, we try to corroborate a lot of what she said through evidence, whether it be digital or documentary. Like for instance, the windows, we were able to, that was something we had no idea about. And then once the proffer had been completed, we were able.
He's going to give specific examples. The defense tried to insinuate when Juliana was testifying that Juliana just looked at the discovery and then made a story from the discovery. And now he's invited this witness to highlight instances where there was something that law enforcement didn't know that Juliana said that turned out to be true. Really? I want to hear that again.
Objection.
I slowed it down and everything.
Discussion as to how to confirm her veracity by whatever means?
Yeah. So like I said before, we try to corroborate a lot of what she said through evidence, whether it be digital or documentary. Like for instance, the windows, we were able to, that was something we had no idea about. And then once the proffer had been completed, we were able to kind of run that down and confirm it.
Now,
wow.
Did you ever say to any of the
through this testimony, has it made the testimony of Juliana more credible or less credible? Because the defense has spent a lot of time bolstering Juliana's testimony.
investigators
The windows?
that they arrested an innocent woman,
To the
talking about Juliana?
walls.
No.
What did he just ask? I got stuck onto from the windows to the walls. What did he ask?
Did you ever say to any of the investigators that they arrested an innocent woman, talking about Juliana?
No.
That was never said by you to anyone.
About me?
By you to anyone.
No. I think what you're probably referring to is I expressed concerns about the articulation of how, the reasons they charged. But I think the charge was solid.
And who was that with that you expressed those concerns?
Detective Bryant.
Okay. Your Honor, I don't have any further questions.
Oh,
All right,
thank God.
cross-examination.
I have never seen anything quite like that. We're not even done with this testimony, and I'm stunned at the things the defense elicited. Truly. We're going to summarize this witness once the cross is done. So, for those of you just coming in, no, we're in the defense case in chief. The defense called this witness. This was from last Thursday. Oh, man. Donna in the chat asked if they'd had the afternoon break. They already went to lunch. They haven't had the afternoon break
Okay,
yet.
so let's talk about
I'm gonna have to take a
this
break in a
case,
minute.
and how the Fairfax County Police Department Homicide Division got involved. Do you all have a rotation for call-outs when there is
For all of you who are like, no cross needed. Oh, she's going to take a victory lap. This detective has bolstered their main witness.
a crime committed?
Yeah, so there's what we call a homicide list. And there's, generally about 12 detectives on the squad, give or take, and there's an order, and it kind of rotates through that list so that nobody's overwhelmed with work at any one time.
Okay, so when the call came out for the murder at the Banfield's home, was Detective Bryant essentially on
I
call?
believe he was up for murder. Again, that was prior to my time there. So
Okay. And so his assignment, you indicated that it's not uncommon for cases to be handled by multiple detectives over the course of the case's life. Is that correct?
yes,
Okay. And in this situation, this case has been pending for 1 month shy of 3 years. Is that correct?
yes,
Okay. So there's nothing really out of the ordinary about multiple detectives having been involved in this case.
not at all.
Okay. Likewise, this was a really big case for Fairfax County Homicide, correct?
It created a lot of attention, media attention, so there was a lot of eyes on it.
And there was a huge volume of evidence to go through, correct?
Yes,
Okay. And as such, your leadership was very involved in this matter, making sure that they were up to date on how the case was progressing, correct?
yes.
Okay. So was there anything, again, intended to be hidden from the Commonwealth by making sure your leadership was aware of developments in the case as they arose?
Oh, I don't even think you
Absolutely
need to
not.
clean up that point. I think it's really clear they wanted
Turning
their
to
bosses to be in the know. I think
Ms.
that was
Perez
very
Magalhaes'
clear.
proffer. You all were working as a team in developing the questions for Ms. Perez Magalhaes, correct?
Yes,
Okay. And it was simply determined that Mr. Klingon would be the mouthpiece in the room, nothing more, correct?
That's not what he said earlier, though. I don't know why you would ask this, but this is not what he said earlier. Earlier, he said, I don't know how those questions were created. The prosecutor must have done it. And now we're getting to y'all work together to make the questions. That is 100% not what he said.
correct.
Okay.
And now he's like, oh, no, yeah, we worked all together. That's a different answer.
Ms. Frissler was present as she sits here at the table today. This is Ms. Frissler, correct?
Yes,
Okay. And Ms. Perez Magalhaes' attorney was present, correct?
correct,
Detectives Goodell and Bryant were present.
correct.
All right. And you were all smushed in a room. Is that accurate?
Well, they
good
were
for you.
smushed.
They were
I
smushed
was
in your
comfortable in
own
Ms. Bristler's office.
space. Okay. Was there room for anyone else in that particular room at the time?
It's a small room, as you know.
Okay. Thank you. Her proffer was 2 weeks before her trial. Is that correct, Ms.
Yes.
Perez Magalhaes? And that was more than a month after Mr. Banfield had been charged, correct?
Correct. He was charged September 16th. I believe the proffer was October 25th, about 6 weeks.
So the proffer was not the determining factor in whether or not to charge Brendan Banfield with the
That's good
murder of his
follow-up.
wife and of Joe Ryan, correct?
Correct.
That's good follow-up.
What was it about Ms. Perez Magalhaes' proffer that you believed made her to appear truthful?
Well, like, so we were
The defense really just stepped into allowing the cross to get into this, allowing the prosecution to get into this on cross, because he asked about it so much. So tell me more about why you think she's telling the truth.
able to corroborate through digital evidence that she left the gym. She basically said that
I'm sorry, could you put your microphone on? What's your objection?
Objection to, it's outside the scope of what I've asked.
It sure the fuck is not. It sure the fuck is not. How do you even say that with a straight face? First of all, Judge A had to come in with counsel your mic. And then the first thing he says when he's unfucking muted is, that's outside the scope. Shit.
that she left the gym. She basically said that
I'm going to back this up even more because it was delightful.
Correct.
What was it about Ms. Perez Magalhaes' proffer that you believed made her to appear truthful?
Well, like, so we were able to corroborate through digital evidence that she left the gym. She basically said that
I'm sorry, could you put your microphone on? What's your objection?
Objection to, it's outside the scope of what I've asked. It's an open-ended question as to the investigation. And
Your Honor, they're on cross. They can't ask open-ended questions. Yeah, they can. Your Honor, this is bad. It's real bad.
it's an open-ended question as to the investigation. And it's
the legal.
I'll overrule the objection.
The legal
Please
grounds.
continue.
Overruled. The legal grounds. Sir, the legal grounds. We're getting close to I'm trying, Your Honor. We're not there yet, though.
So she essentially kind of confirmed the sequence of events that I believed occurred. Part of the way we did that was looking at the digital evidence. There were things along the way, for instance, going to the gun range, we were able to see pictures of that. She talked about leaving the gym, that Brendan told her to leave the gym early to go home so that he wouldn't be in the house while the FetLife or Telegram account were active. And we were able to see that on the geolocation of her device and Brendan's device, and then we could see her log or see a log on the Telegram shortly after that device arrived in the area. The windows was something we hadn't had any idea about once she...
When you say the windows, do you mean the replacement of the windows in the Banfield?
Right, so she said that there was a time where Brendan had the windows replaced.
Listen to how fast he's answering now. The defense put the prosecution in a position where they got to wind up one of their detectives and say, tell us why our main witness is credible, believable, and essentially why this jury should just believe her. Go. And he's off to the races at 1,000,000 miles a minute. So I'm speeding this down to normal speed because all the jury's going to hear is, these are all the reasons you should believe Juliana.
Then we could see her log or see a log on the Telegram shortly after that device arrived in the area. The windows was something we hadn't had any idea about once she...
When you said the windows, do you mean the replacement of the windows in the Banfield?
Right. So she said that there was a time where Brendan had the windows replaced with windows that were like soundproof, and he asked her to go stand in the driveway, or actually he asked her to stand in the bedroom and scream while he stood in the driveway to see if screams would be able to be heard. She said that she did not want to do that. And so he screamed and she went outside. We were then able to track down a receipt and some emails, I believe, about the windows, and ultimately find the company and speak with the salesman who spoke to Brendan. And there was just a lot of...
When the prosecution called the guy from the window company, which I summarized and we skipped over as we were trying to zoom through this case, I wonder if they had an inkling that they were going to call this, that the defense was going to call this witness. Because the jury's already seen the testimony about the windows. And they're like, yeah, we didn't know that. And then we went and sure as fuck, we found emails and we found a receipt and then we found the company. And then the guy came in here and testified, yeah, I spoke to that guy sitting over there. That's the guy I spoke to. And originally, it went beyond that. Originally, in July, the defendant just wanted double paned, more energy efficient windows. But then he changed his mind and then wanted the triple paned windows. And that was an order that was changed. And then he wanted the triple paned windows. The more soundproof ones. Right.
A lot of things that over the course of August until February, in the digital evidence that she was able to corroborate for us in that, or that we were able to corroborate her statement after.
All right, thank you. And just a final question from me. I'm sure counsel will have more.
Just a final question from me. So how guilty is he? I mean, what are we doing?
Did you change, distort, or hide any evidence in this case?
No, ma'am.
Okay. Did you direct anyone to change, distort, or hide any evidence in this case?
No, ma'am.
All right. Thank you. Nothing further, Judge.
All right, redirect.
Really? All right. He's got his paper out and I've got 1.25 speed.
Lieutenant Giaccio, you were ordered by the court to turn over evidence that should have been turned over months before.
Outside the scope. That's immediately outside the scope. That's immediately outside the scope of cross. Let's see if there's going to be a objection.
You were ordered by the court to turn over evidence that should have been turned over months before during the summer. Isn't that correct?
No, I gave everything that I
No
had.
objection. And he said no.
The text messages and the emails that you were seeing here were turned over in July when we had a discovery order in November. Isn't that true?
Yes, and that's something that we have never turned over in any other case that I'm aware of. So as soon as the court ordered it.
I'm surprised she didn't object to outside the scope. So the text messages were ordered to be turned over when?
Here were turned over in July when we had a discovery order in November. Isn't that true?
Yes, and that's something that we have never turned over in any other case that I'm aware of. So as soon as the court ordered it, we complied.
Okay, and when you say we, who are you talking about?
Fairfax County Police.
Okay, and so the issue.
He said the discovery order was in December. Was the discovery order in July or in December?
Issues relating to the conflict in the case were exculpatory evidence. Wasn't that correct?
Objection calls for legal conclusion.
Sustained. Next question.
Did that ever occur to you that that was something that should have been turned over?
Objection is to the form.
Sustained is the form.
He already said we've never turned them over in any other case ever. Right.
Did the emails and the text messages that you have just witnessed, were they, did that ever occur to you that that was something that should have been turned over on the discovery order?
An objection, Judge. I think we're still on the legal conclusion. He indicated that it was turned over once he received a court order.
I'll sustain the objection. Next question.
Who in your division is in charge of looking to see whether something's exculpatory?
Objection is to relevance.
How's it relevant?
I think the question, this is in response to her question that.
I'll sustain the objection. Next question.
Have we gotten to the exculpatory stuff? Have we gotten to the emails and text messages that were exculpatory? Where's that part? And this had nothing to do with her cross.
In terms of the transfers of Brendan Miller, or actually, I think you were involved with the transfer of Kyle Bryant.
Outside the scope.
What was your reasoning behind that?
Outside the scope.
Well, I gave input, and my input was that I thought he should stay.
And in fact, he was.
Why did you transfer him? Actually, I thought he should stay. Oh. Oops.
Then removed?
Yes, he was ultimately transferred.
Okay. And what was the reason, the October 25th situation?
Objection calls for speculation.
Overruled if you answer.
I think it was a combination of the withholding the proffer for 5 days and, and just being wrong about with the analysis in this case.
And you're talking about being wrong after the Juliana Perez Magalhaes proffered.
Well, I think that's when he realized it. I think after that, there was nobody on the police department that I'm aware of that doesn't believe the current theory of events.
Wow. We're going to just, I advocated for him to stay, and you're going to end your redirect on there's no one in the police department that disagrees with this case today. You're the defense.
Magalhaes proffered.
Well, I think that's when he realized it. I think after that, there was nobody on the police department that I'm aware of that doesn't believe the current theory of events.
I have no further questions, Your Honor.
All right, is this witness subject to recall?
No.
Oh, no?
No, ma'am. Thank
Okay,
you.
you're free to go, sir.
Thank you, Your Honor.
All right, ladies and
Counsel, at some point you have to stop hitting yourself.
gentlemen, let's go ahead and take our afternoon recess of 15 minutes. Don't do any outside research and not talk to anybody about the case. Thank you. And just a reminder, our next, we were going to 5:30, so keep that in mind on your break, okay?
The jurors are like, do we have to? Are we in trouble? Oh boy. So at the afternoon break, chat has decided that we definitely need to add a code brown to our code bruh and our code WTF, because the defense has definitely stepped in that today. And at the end of defense witness 11, Lieutenant Giaccio, I forgot how he pronounced it at the beginning. The defense elicited multiple times that law enforcement thought they were correct on the catfishing theory, that during the proffer of co-defendant Juliana, they were texting about, we got this right, that they confirmed in those texts that at one point they thought that perhaps Christine had been killed before Joe got to the house, and that the timing of that was clarified. And the defense asked so many questions that allowed the lieutenant to come in and say, this is why we believe Juliana. This is why Juliana is credible. This is how Juliana was corroborated by the digital evidence. This is how Juliana was corroborated by evidence we didn't know. And gave an example saying, we didn't know about the window thing. We didn't know that the windows were replaced. And once Juliana told us that, we then went back, found receipts and emails, and then found the window salesman that testified during the case in chief for the prosecution. We didn't know that before Juliana told us, but Juliana told us and we corroborated it. And when Juliana said that she would leave the gym early and then go get onto the Telegram account, we saw her phone leave the gym. We saw the defendant still at the gym, and then we saw her get back to the house and then log on to the Telegram account. So the things that she was telling us happened that way in the digital evidence. The phones were doing the same things. And then when the prosecution tried to ask in cross-examination, so tell us, why do you think Juliana was credible? Just do that again. The defense objected. The objection was outside the scope. And the court allowed it. And the witness just teed it all up again and said, okay, well, this is the digital forensics that that confirmed what Juliana said. And this is what the thing that we learned new. This is an example of what we learned new that we were then able to confirm. So we looked at all these things and we were able to confirm that Juliana was being truthful and was credible. And then in redirect, the final question from the defense was a wild choice on, okay, but did everybody in the department agree? And the answer was, after Juliana's proffer, there wasn't anyone left that doesn't believe her. Unbelievable. The evidence as it's come in today is that at one point, law enforcement didn't agree with the prosecution. They thought that the prosecution offering Juliana a manslaughter and time served was dog shit. They thought that their theory that the defendant had set up a catfishing scenario to lure Joseph Ryan to the house was correct. They think that the conclusions of their own digital forensic examiner were incorrect and improper, but that the data was collected properly and accurately. And that at the end of the day, of everyone that was transferred, most of them were promotions, and 2 individuals were laterally transferred. And those 2 individuals were B3 Miller, who was laterally transferred to no longer do digital forensics, and the lead homicide detective who they said they thought was in over his head. Wow. What else we learned is that law enforcement believes Juliana. Law enforcement believes that her testimony is supported by all the digital forensics, that the clean house on the homicide unit meant that most of them got promoted, and that the text messages show that they thought that Juliana was being truthful during her proffer. I'm interested to see where this continues to go. So I guess we'll see. But because we have been streaming now for almost 6 hours, I do need to take a brief break. They are at the afternoon break. We are going to do our best to zoom through the afternoon break and see what the defense continues to do. And then it does look like court will be in session tomorrow. So my plan will be to see what happens. And if we need to skip day 7, we will. If we need to summarize day 7, we will. But if the defendant is going to testify tomorrow, we will jump to it in mostly real time. And I'm going to regret it. And we're going to do it anyway. We're all going to regret it. Because if we have to listen to this dude and his attorney talk to each other in real time, it's going to be a little bit painful. But we can summarize day 7 if we need to and just skip into close to live, because we're going to need some time. We're going to need some Zoom room. So Law Nerds, if you don't have the Law Nerd app, if you haven't done the YouTube-y things, I always forget to ask, do the likey things, the subscribe-y things. If you don't have the Law Nerd app, get the Law Nerd app. I will let you know what time I'm going live. I will send you a notification when the defendant takes the stand, and we will go from there. I will also send you a notification when I'm back from break. I'm going to run to the restroom, check in with the kiddos, grab some food. Hoping to be faster than yesterday, but we will see. So Law Nerds, get the Law Nerd app. I will be right back. Don't forget, you will hear this sound when I've got to change the soundboard. You will hear this sound when we're coming back. Don't forget to hydrate. Don't forget to go change your laundry and do the things you need to know. I know we've been locked in watching this happen. So now's a good time for you to take a break and go do the things you need to do real quick. I'll let you know when we're back. All right. Ready? Sounds good. I will see you in a minute. Mods, don't forget to hydrate. All right. Quick break, everybody. See you in a few. All right, chat, are we ready? I hope so. I'm ready. Kind of ready to be done, honestly, with the day. All right, I'm gonna lift my my desk just a little bit more. Oh, I put a new light bulb in that. I put a new light bulb in that light, and it is flickering. So I'm going to get us back to court, and then I am going to turn that off. I have not transformed into stand-up mode since I changed that light bulb, but that's gonna annoy me. So all right, now that we're in standing mode, everybody stretch. It's been a lot of sitting, but I'm gonna go turn off that light. All right, let's go back to court after the afternoon break. The judge reminded them that they were having actually, when I'm in this mode, it's better. The judge reminded them that they were going to have a bit of a longer day today because the defense ended an hour early yesterday on day 5. And the court was like, we're making up this time. I'm fighting a snowstorm. Let's go. Let's go. All right. So back to court we go. I just need to make sure that I have the volume on. The defense is calling their next witness. Let's see who witness, I think number 12 is. I mean, the defense has called quite a few witnesses. So for everyone that's asking, and it is many of you, for everyone that's asking about IAC, the defense has called quite a few witnesses. The defense has not fallen asleep. The defense has asked questions. The defense has not failed to object. The defense has not failed to make necessary procedural motions. So we're not going to get there. You have the right to choose your attorney. Nothing guarantees that that attorney is going to be great. And he's communicating with his client quite a lot. He and his client are chatting over there. His client's engaged in the process. Not much more you can do. Lindsay, it's a selenite lamp. So, yeah. That's where we're at. The bar for IAC is very, very high in that the attorney has to basically do nothing. But it's hard.
Come back at 3:50 then?
Yes, ma'am.
Mr. Kira?
I thought I had zoomed. Apologies, chat. That's on me. Again, I can only imagine how frustrating this much. Whatever you think of the defendant, everybody deserves a good defense. And honestly, I would much rather see defendants have a great defense and a great defense attorney, because then when you get to the end of it, you know that everything's been done. All the I's have been dotted, all the T's have been crossed, and you know that somebody is convicted because the evidence against them is beyond a reasonable doubt. That is the bar I would like to see. This one is tough stylistically with the defense. I don't think it changes the evidence against him. Oh, wait, we're going to get to peruse I didn't know we were perusing the portraits more. I didn't know we were perusing the paintings. They were like, we have moved on from the seal of the Commonwealth of Virginia to peruse the paintings. I am amused. All right, let's go back to court. I can only imagine how frustrating it is for a defendant. You just don't know. How do you know how your lawyer is going to do?
Fayez.
How do you know how the lawyer is going to do in court? I don't know. It's like picking a dentist. How do you know? You meet them, you think they're great. It's hard. It's hard to choose. And I imagine that I imagine the defendant must be frustrated. I mean, he's not unintelligent. He has to be seeing what's happening in court. But how do you know? Like, how do Ron's clients know? I mean, I think there's a record now, but how would Ron's clients know that it was going to be like that? Because
All right, your next witness,
Sally Fayez.
Sally Fayez.
this has got to be hard. I also like that the court corrected his pronunciation of Sally Fayez's last name. So Sally's also in the command structure. Okay. We heard about Sally in a number of those text conversations. Oh, Queen's back. Hey, Queen. I'm very excited. Emily, your ADHD is ADHDing. We're grasping at delightful little straws today. We learned more in witness testimony today than we learned yesterday. So there's that. Let's make sure we're starting off at 1.25
You swear or affirm to testify truthfully in this case under penalty of law. Thank you.
because we need to do that. So we're in the defense case in chief, defense witness number 12.
Got it. Thank you. Hi.
All right.
Good afternoon, Ms. Fayez.
Good afternoon.
I'm going to show you some text messages.
Judge, I would object. The witness has not yet.
The witness has not yet identified herself for the record. I'm
going to show you some text messages.
Judge, I would object. The witness has not yet been identified.
Could you just have her?
Sorry. Can you please say your name and spell it for the court reporter?
Sure. Sally Fayez, S-A-L-Y,
Fayez.
F-A-Y-E-Z.
And if I ask you any questions that don't come out right or you don't understand, just please tell me and I'll repeat the question.
Absolutely.
Girl, you don't want to do it. You don't want to do it. If you're going to correct every question that doesn't come out right, it's going to be tough.
Now, you're the head of the victim services for Fairfax County. Is that
Correct. For the Fairfax County Police Department.
Thank you for the work you do.
In that role, do you fall within their command staff, I guess, map?
I do.
Okay, and so who, can you describe for the ladies and gentlemen of the jury of your organization and how it fits within the police department?
Sure. So we are a civilian unit within the police department.
I very much appreciate the command structure of how victim services plays into all this. Love that they have victim services. Do we need to know the command structure? No.
17, plus we have interns, but 17 employed.
Okay, and
17 employees is a really big unit. All right. They go out when it's needed.
Juliana, we're headed to headquarters, and did I have an advocate to sit with them?
I'm glad we've already gotten to the day of the murders. Let's continue there.
Quarters. And so I either received a phone call or a message, I'm not sure, letting me know that Valerie and Juliana were headed to headquarters, and did I have an advocate to sit with them?
I'm sorry, I didn't understand.
Did I have a victim advocate that could go sit with them?
Okay, and did you arrange for that?
Correct.
Okay. At that point, is that victim advocate the victim advocate for them for the remainder of the case, or how does your organization work?
Yes, on homicides, the advocate that responds, usually respond to a scene, but in this instance, we responded to headquarters, so they would keep the case. There's two different families, so I assigned one advocate to one family and another advocate later on to Joe Ryan's family.
Okay.
Okay.
And, how long have you been doing that?
Doing
Your job?
that, I've been with the department for 23 years, so I was an advocate for 7 years, and I've been the director for 16.
Of course, she's confused because his question didn't follow sequentially with what she was talking about. That the day of the murder is when they heard that Valerie, the 4-year-old, and the au pair were headed to the station, that they got a victim advocate to go sit with them. Correct.
So in terms of your interaction with the police department, what's your interaction on a daily basis if you're not otherwise responding to things?
I'm in command meetings, I'm in supervisor meetings.
Ma'am, I'm sure your day is full of meetings and emails. We're going to get back to when we get to this case because you are an executive in your position. So I imagine there's a lot of meetings that could also be emails. And we heard who she worked with. He asked all the other witnesses. So we're skipping forward to the text messages.
And ask you if you can identify them.
Okay.
This is marked as Defense Exhibit 92.
So that command structure we've already heard in this case.
Okay.
Do you have any recollection of that?
From looking at it, but no.
Okay, no, nothing on the page stands out for you?
No. I mean, I see that was from 2024, but otherwise, no.
Okay. Is it common to have jail call recordings in your communications with Deputy Chief Brusch, and who would be the other person? Was that Lieutenant Giaccio?
I only see myself and Deputy Chief Brusch on here.
Okay. Would that be a common occurrence, the jail calls from a case?
Yes. I mean, it's not that it's every day, but if you're asking, is that okay that a text message included a jail call? Yes.
Oh, no, I mean, I'm sure it's okay. I just was curious if that's just something that would be naturally flowing from your position and his position?
Yes.
Okay. And is that something that are you ever involved in listening to jail calls, or just when it's sent to you in this kind of format?
I have in the past, yes.
Okay. And in this case, have you done any listening of jail calls?
No.
Other than this?
No.
Okay. And so,
And
it appears there's a conversation going on. What's the nature of that conversation?
in these texts, it appears there's a conversation.
Conversations going on, which one are you referring to?
Actually, let me just, if I can just pause for 1 second.
No.
This in is defense exhibit number 92.
Any objection?
Judge, I think the witness testified that she doesn't recognize it.
Are you on the
Yes.
foundation?
In terms of your
She said she didn't
communications
recognize
with
it.
Deputy Chief
I'm trying to move my
Brusch,
in-ears.
would text messages be a common way that you would communicate?
Absolutely. I think that's the common way to communicate with most people.
And so,
Just-
other than personal
The
communications,
mic,
would
ma'am, is just
text
in your
messages,
face.
including jail calls or other discussions about perhaps defendants, would that be something that you would talk about?
Yes.
Okay. And in this case, is that what that looks like?
Without knowing what that call was, no, I wouldn't
What
know.
about the next statements regarding that?
Again, unfortunately, since it was 2024, there's not a lot of context of what this is for me to know.
And so you're based upon what you know right there.
She knows
you're saying
nothing.
You're not certain that this was a communication that you had made?
Well, I obviously made it because my name is in there, but I really don't remember that specific text message.
And I think that's
But I'm not saying I
understandable.
did not do it.
That's certainly understandable with text messages. Your Honor, I'd move that in as defense exhibit 92.
Judge, I wouldn't object to its admission at this point, but obviously the witness's
Foundation.
testimony would be limited by her
Well, I
recollection.
understand that, but as far as admissibility, 92 is an evidence, not published.
I mean, if it's going to get published, it's going to get published.
Now,
Okay.
down the page of this message, I'll point to this. What are you saying there? And does that indicate that somebody else is in that message?
Huh?
Giaccio, Lieutenant Giaccio.
Okay. Does that help you remember any of this?
Yeah.
Would it be common for you, Deputy Chief Brusch and Lieutenant Giaccio, be on a three-way text?
Yes, I've been on text messages with deputy chiefs and supervisors in the past.
Okay.
So
And,
yes, she's been on text in the past. Oh, good.
And these are the kind
All right. So we are getting to a group text. I don't know whose phone this is from. I assume it was from Giaccio's phone, but I'm not sure. And it has Patrick Brusch and Sally Fayez. And it says from a jail call last week. Patrick Brusch says arresting him will pull him over. Sally says he sounds like a big baby. Patrick says he's going to fold. Okay, so there we go. We got to, I think, the text that the defense wanted to bring in to show that they called his client a big baby. Okay.
of things that you discuss when you're talking to those two?
Well, if I'm reminding Lieutenant Giaccio to ask people to do something, yes.
Okay. And how about talking about things like arresting him will put him over?
Again, I'm sure we have in the past. I just don't know the context.
Oh, we'll put him over. I read that as we'll pull him over. Like, oh, I'm going to just go pull him over in the car to arrest him. I misread that. We'll put him over. You know what? That solidifies my theory a little bit that the second he got arrested, that Juliana was like, shit, it's either him or me. Because I think that's truly how she felt when he got arrested.
Text of this.
Okay.
Patrick Brusch says he's going to fold. Next text is from this witness. One last favor, GI, can you remind everyone to do the evaluation for class by scanning QR code in the folders? Yes. Okay, so right back to work talk.
Ma'am, I'm going to ask you to...
Ma'am, I would like to know why you think he's a big baby.
Defense exhibit number 94.
No, go ask her why she thinks your client's a big baby. I want to know.
Do you remember that?
Let her explain.
I do.
Okay, and what's the significance of the date in remembering that?
Friday, October 25th,
Good God, that audio.
the arrest of Brendan Banfield.
October 25th is not, in fact, the arrest of the defendant Banfield. It is not, in fact, that is incorrect.
Is that what you're asking me?
No, I don't think, well, let me just do this and then we can talk about it. Your Honor,
Sure.
I'd like to enter this as Defense Exhibit 94.
Any objection?
No, Judge.
94.
And the jury knows
It
it's not
appears
that
a-
date
a
either.
conversation with Deputy Chief Brusch, and it's relating to some message that the
That's
chief
Breathing on
had
the
written.
microphone.
Yes.
And do you know what the significance of that is?
I believe after Juliana's proper.
And
She said after Juliana's proffer, the witness is very close to the mic. I don't think she can hear fully how close she is to the mic, so it's just going to be, unless it moves, it's just going to be like this. That's why we have closed captioning.
you knew that to be October 25th, correct?
I only see it at the top of a text message.
But did you know that to be October 25th?
Not that I would have recalled, no.
Okay.
All right, I'm going to read the text message. This is Patrick Brusch. It looks, gosh, that's hard to see. It looks like the very cut off portion of the top of the text. The tippy top says Friday, October 25th at 7:42 p.m. Patrick Brusch says to both of you, that's a pretty powerful message from the chief of one of the most respected law enforcement agencies in the country. This is an important moment for what was an exhausting process. Nobody but the two of you truly know what this entailed. Sally, wow, thank you. GI, with all you've been through, what a full, and then I guess we'll continue to see. I'm going to pause it and read the rest of it when we get there.
And in this text message, you're talking about not taking no for an answer, correct?
Correct.
And what's that relating to?
It appears to say not taking up an answer, so we're all grabbing a drink next week.
Okay, and do you know the context of that?
Probably just saying we're all going to grab a drink next week.
Okay, not anything with regard to the case?
No, not that I would read from that.
Okay.
No, counsel, damn it. Come back. Okay. Nobody knew what nobody but the two of you know what this entailed. Sally, wow, thank you. GI, with all you've been through, what a full circle moment.
I would read from that.
Okay.
There's a lot of people that will claim to be on the right side of, damn it. That's all we saw. I imagine the case, but yeah. Oh, look, are they texting saying, well, now everybody's going to bandwagon that they were all on board all along?
I'm going to have you look at what has been marked as Defense Exhibit 98. Do you recognize that?
I don't recognize the text message, no.
Okay. Are you involved in that text message?
By looking at it, I can't say yes or
No, I went to pause it and it jumped. I love that the text message came up and Judge A was like, all right, give me a second. Because I absolutely, that's one of the negative things when I am at the standing desk is I can't always see where the cursor is. And I absolutely did that myself. All right. Though I fixed it. I'm going to turn this off. All right. I fixed it. So at least there's that. But that was 100% on me because stand desk, it makes it harder to see the third monitor. All right.
What has been marked as Defense Exhibit 98.
I was just giggling at Judge A's face. I was just like,
Do you recognize that?
I don't recognize the text message, no.
Okay. Are you involved in that text message?
By looking at it, I can't say yes or no.
Okay. You don't see. Okay. I'll withdraw that.
all right, chat, I'm going to turn off the light real quick. I'm still here, but
Ma'am, I'm going to have you look at
You know.
what's been identified as Exhibit 99. Do you recognize that?
No, I don't.
Are you not part of that?
It doesn't appear so, so I would know if I was.
And you don't have any independent memory of it?
No, I don't.
Okay, I'll withdraw that. Ma'am, this is Defendant's Exhibit 106. Do you recognize that?
I do.
Okay. Is that a text that you were involved with?
Yes.
I
And
see
just
all
for
of you
the
saying the
sake of
judge's face is facing.
Identifying
It
people,
is.
which color were you on that? Gray or blue?
Gray.
Okay, Your Honor, I move that in as almost Exhibit 106.
And I'm not going to speed this
Judge
up.
objected to, that was not identified by whoever the other party is in the email.
That's correct. The other witness said they didn't recall, so I have to sustain the objection to 106.
I'm not going to speed this up because she is so hard to hear based on the microphone. Okay, so that email's not coming in.
I'm going to ask you to review what has been marked as Defense Exhibit 107. Do you recall that text message? Or can you identify that text message?
Identify it as in,
As a message you sent or as a message you were part of?
She said, I don't recall.
my name is up top, so I would say that it was for me.
Okay, do you know who you were communicating with?
She's like, I don't know what this
Not just
is.
by looking at it, no.
And Judge
Your
A's
Honor, I
like,
move that in as Defense Exhibit 107.
Judge Reed objects.
the judge looks in disbelief that the defense continues to try to move things into evidence that he can't move into evidence.
The objection.
Again, it calls for hearsay.
Right.
Lack of
Ms. Fayez is
foundation.
the person who was the recipient. She cannot identify who the communicator was.
And I believe the other witness said it wasn't him. So I have to sustain the objection to 107.
She's like, I have no idea what these are. For those of you asking, did the defense prep these witnesses? I imagine not. I imagine the defense subpoenaed them and had them come in, and seems like he's asking them cold. That's at least what it seems like. I could be wrong, but it does not seem like there's a lot of prep with these witnesses, and it is an interesting choice.
Your Honor.
And maybe the defense continues to try to move them into evidence to be like, see, the prosecution doesn't want you to see this. See, the prosecution is blocking me from bringing in the truth. See, the prosecution's hiding something. Let me know how you feel about those objections.
Now, ma'am, when you're in the command staff meetings, what kind of role do you have in those meetings?
My role really is to make sure that the victims and the survivors are a part of the conversation.
Okay, and so are you giving updates on things, or how do you engage with the command staff, the police command staff?
I think it really just depends. Are you talking about in this instant, or are you just talking about in general?
Generally.
I think it just depends on what the case is about. Sometimes if we have a case where a case went to court, then we would update the command staff on what happened with the verdict. If there's a case where we believe the family needed some awareness when there comes to a public affairs bureau release, we work directly with our public affairs bureau command staff to make sure that families are notified in a dignified way that something's going to be released.
Good.
Now,
That does not happen in all departments. That does not happen in all jurisdictions. It should. It doesn't. Not everyone has a bureau with as much staffing. I'm glad they do. It's nice to hear that she, in command staff meetings, makes sure that the victims and survivors are part of the conversation, makes sure that they know what's happening, makes sure they're not caught off guard by things that are released in the media or next steps in the case. Good. I'm glad. I'm glad to hear it.
specifically with regard to this case, were you ever involved in the theory of catfishing?
Yes.
Did you suggest catfishing?
I did not suggest catfishing. I suggested that
I'm
it be
curious.
proven that it's not catfishing.
And when in time was that in relation to?
I did not suggest catfishing. I suggested that it was not catfishing. I'm very curious about that.
It be proven that it's not catfishing.
in the theory of catfishing?
Yes.
Did you suggest catfishing?
I did not suggest catfishing. I suggested that it be proven that it's not catfishing.
And when in time was that?
I suggested it be proven that it was not catfishing.
I think as time went on, it became apparent that that was a possibility. And so are you asking when I started to think it, or?
Well, where did this theory come from? Were you the one who started it?
Did I start the theory? No.
Okay. When did the theory become?
I mean, fair enough. I guess prove it's not. If you guys think it's not catfishing, prove it's not. Don't prove it is, prove it's not. Okay.
A discussion topic in context of the time that the...
I think throughout the investigation, depending on what meeting you were in.
How soon after the killing of Christine Banfield did that come up is what I'm asking.
I think it came up once they were in a hotel and our intel detectives heard her call, ask if she could call her mommy.
What?
I'm sorry.
I'm sorry. What? Okay. We're going back to normal speed. I am so lost at the moment. So the microphone is painful, but she said I didn't suggest the catfishing. I suggested that they prove that it's not catfishing. Okay, fine. Show me that it's not. And then he asked, how soon after the killing of Christine did this come up?
Throughout the investigation, depending on what meeting you were in.
How soon after the killing of Christine Banfield did that come up is what I'm asking.
I think it came up once they were in a hotel and our intel detectives heard her call, ask if she could call her mommy.
What?
I'm sorry.
I think there were things that came out a couple of days after the murder that made people question whether this was a catfish or not.
Okay, so within days after the murder,
Correct.
did you believe that it was a catfish?
I didn't believe that it wasn't one, but it was on the table that it could have been, absolutely.
Okay, and was that something that you discussed in command staff meetings?
I think that evidence and investigative avenues were discussed, but the actual word catfish, no.
Okay.
Until later.
So was it discussed in terms of assuming someone's identity, or how would it have been discussed in those meetings before saying catfish?
I think it would have been discussed as, has everything been done to prove one way or the other? Was this a setup or was it not?
And I think that's
something you were bringing to the...
I think it makes a lot of sense that the words that they would have been using are setup. Was this a setup or not? That makes a lot of sense that that's the language that they would use. I'm going to let this unfold. I'm very curious if we hear more about this.
Table, or is this something that...
I think it was a group discussion.
A group discussion? Mm-hmm. Okay. And so within days, the discussion turned to catfishing. And that's
not within days, no.
Oh, I'm sorry.
My view within probably a few days was a question of what really went on.
So in your mind, within a few days, catfishing was a possibility?
A possibility.
Within her mind, within a few days, what your client said didn't make sense. That's what was in her mind.
Yes.
And did you communicate that possibility to the people that were in the command staff meetings?
I'm sure we all were having the same conversations because I wasn't the only one that thought that.
I mean, is that something that you would oftentimes talk about in these cases?
Yes. Well, I don't think we've had a case like this, but I would have a conversation about the case that's being presented. Absolutely.
Okay. Well, I guess for purposes of your memory, would there be other times? I mean, if this is a pretty big case and if you had suggested catfishing, that would be memorable.
I think you're confused as to part of what I did, whether I thought it was or not. It's not that I suggested it. There were meetings where plenty of people above me that believed the same thing. It wasn't just a Sally catfish, if that's what you're asking.
No, I'm not. I'm trying to get an idea.
It would be much easier if they used the word setup. It really would be much easier if they used the word setup.
When you started talking about it as catfish, and I think you'd said you thought about it within a few days, but when did it become a viable theory to talk about in the command staff meetings?
I think you're confusing command staff meetings. What meetings are you referring to?
He's confused,
The ones
period.
that you just described where you're with command staff.
Those are different meetings than just a normal meeting talking about cases
Yeah,
in the
that's what
Major
I'm
Crimes
asking.
Bureau.
We'll talk about the normal meetings. In the command staff meetings, when was it that you started talking about catfishing?
Well, it was never discussed in an actual command staff meeting because that's the entire command staff. So it wasn't discussed then.
Okay. Were there breakouts?
I'm sorry.
Were there breakouts?
I think somebody came and told her to move back from the mic. Is that the bailiff? But she's also like, counsel, how the fuck do you not know what you're talking about right now? But I think somebody asked her to move back.
Meetings of the
Thank
people
goodness.
that were involved. I'm just trying to understand where we're going.
A counsel, be prepared, and then maybe you can understand where we're going.
And I'm trying to understand where you're going. I'm sorry. I really don't know what you're asking me.
So
Neither
the
does
only
he.
meetings that we've talked about at this point were command staff meetings that you said that you're involved with as one of the command staff personnel, correct?
No.
Correct.
Okay. And what I'm trying to get to is when was it that
I'm going to put this back to 1.25 now that her mic's clearer. She said we had meetings with command staff, but those are not the titled command staff meetings. Fair enough. Going back to 1.25 now that she backed up a little from the mic.
catfishing was a theory amongst the meetings that you were attending, whether they're command staff or other meetings, whatever meetings you're attending?
Again, I think they're ongoing. There's meetings on that floor between the supervisors and the commanders on that floor. That's a different meeting than a command staff meeting.
It's not so important in my question as to what kind of a meeting it is. What my question's really directed to is when did you start adopting that and talking about this in meetings?
I don't have an actual date for you.
When was it in comparison to the returns on DNA, digital forensics, fingerprints, anything like that?
I think what happened is every single time some piece of evidence came forward that made you question what really happened, then that theory would come back up.
Okay, and do you know the time frame on that?
No, I don't.
Would it be a year?
Again, I think when you have an investigation like this, there's constantly meetings, there's constant conversations about it. So there were times where, hey, could it have been this? Are you looking at this versus talking about some other angle?
Okay, would have been
Anybody else wondering why he wants the victim advocate to testify? Why he's having the victim advocate testify about the investigation? It just seems like a prime example of ask whose job it's not. Absolutely wild. Absolutely wild. But okay.
a month after the incident?
Judge asked and answered.
Sustained. If you can move the microphone a little
Thank
closer.
God. No! Don't tell anyone to move the mic closer.
So you don't remember when you would have talked about catfishing in a meeting?
The actual word catfish, no, I wouldn't remember that. I can remember when questions would come up about what happened that day.
Okay,
Yes.
and maybe it's my terminology that's the problem. When was it?
It's more than your terminology, counsel. See, what they're saying is that your client's story didn't make sense. And every time there was more investigation in the case, your client's story made less sense.
In meetings that you talked about the theory of what happened that day in the meetings?
It wasn't necessarily me starting those meetings saying that. It would be a meeting for an update on the case or what was going on with the case. And so everybody was having that kind of conversation. It was kind of a give and take.
Okay.
Which is normal in these kind of situations.
Sure. I'm just trying to understand. And so
It doesn't seem that
catfishing
way.
wasn't a comment or wasn't a name that it was given, but there were issues regarding the investigation. Is that what you're saying?
Correct.
Okay. And and I understand you're saying it evolves into something. When was it that catfishing was brought up as the?
Objection asked and answered.
Sustained.
You don't know?
Next question.
Okay. On the day.
Counsel sustained means that you've asked and answered it, and she's answered it. So you don't know is not a question.
Of the incident, were you involved with Brendan and Christine's daughter being brought to The safe spot
What do you mean?
to be, it was in a place where an interview took place?
No,
Okay. Were you involved with, were you involved with any sort of discussion about trying to detain my client?
I'm sorry, repeat the question.
Were you involved on the day of the killing? Were you involved with anyone trying to detain my client at that point?
No,
Were you involved, were you at the headquarters during the
I was, yes.
And were you in presence of Juliana or Valerie?
Juliana and Valerie were in one of our waiting areas where we have a victim waiting room with the advocate, not me.
Okay. And did you have any say in any sort of interviews of Juliana or the child
No.
that were waiting there? Did those occur?
Not that I remember, but I wasn't there for that.
Okay. Was there any concern from you and the people that you work with about my client being released at that
Judge,
time?
objection calls for speculation. She can speak as to what was in her mind, but asking about others.
Rephrase the question.
What, if anything,
Oh, boy.
what, if anything, were you worried about with my client being released that day?
Valerie safety.
And did you do anything?
Okay, this is the defense attorney asking a victim, the head of victim services, if you had concerns about releasing the defendant. And her answer is yes, I was worried about the 4-year-old's safety. I was worried about Valerie's safety. Why? Why are we asking this? How does this help? She's like, yeah, I'm worried about the 4-year-old's safety. Counsel, she does not think much of you.
What, if anything, were you worried about with my client being released that day?
Valerie safety.
And did you do anything to further that worry that you've just told for the ladies and gentlemen of the jury?
Yes, I had received a call from Captain Brusch and Lieutenant Weeks, who was the homicide supervisor, and they were on scene. And the concern was
Okay.
that he
Your
did
Honor,
not.
that's not responsive to my question, but
Yes, it was. What did you do? Well, I received a call. She was backing up to tell you what she did.
You asked her what she did.
when she talked about a phone call.
Okay, all right. Wait.
What did you do?
I ended up getting a hotel for everybody, so they would all be in one hotel together.
Okay. And including my client?
Correct. And Juliana.
And at any point in that process, did you discuss detaining my client?
No, I have no authority to ask anyone to detain.
I understand, but you have the ability to discuss.
Objection argumentative.
Do you have the ability to discuss that with the police?
No.
So in terms of where you're concerned,
She's like, sir, my job is not probable cause.
you can't communicate to the police your concerns?
I absolutely can.
Okay. And in this case, did you?
Oh, God. She's buffering in real time. Did you voice your concerns? Why, counsel? Why? I get the feeling that she thinks your client is a murderer. Hey, counsel, she's not an investigator. She's a victim advocate. Oh. Yeah, chat, that question is 100% a code red. Hey, sir, can you not read the room? Okay, well, since counsel cannot read the room and is not clearly looking at the witness that he's asking questions to, we're just we're beyond bra. I think we're just at code red. Chat, it's granted. Any of you that are new to the chat, code red is a little flashy. If you are flash sensitive, the flashing ends when the music ends. We're going to go to code red because I can't believe he asked this question. I really can't. It's truly just shocking. So motion granted, chat. Code red. In 3, 2, 1. That really is surprising. That really is surprising.
Where you're concerned, you can't communicate to the police your concerns?
I absolutely can.
Okay, and in this case, did you?
I don't understand the question.
Did you discuss your concerns with the police on the day of the incident?
But what concerns are you talking about?
About my client being left out?
Again, I don't understand the question. I want to answer, I just don't understand it.
Okay, and that's...
Ma'am, you really don't understand what he's asking? Because I'm clear as can be on what he's asking.
That's the case with some of my questions, so let me see if I can get it straight.
Stop there.
The question of
Stop
my client
there.
being detained
Stop
or
digging.
being released, was that a worry for you?
At the time, your client wasn't even in headquarters.
So you didn't have anything to judge that by?
No,
Okay. Did there come a time where you were concerned and you wanted him to be detained?
no.
So there's no communications between you and the police about that?
If I can go back to my conversation with Captain Brusch and Lieutenant Weeks, was where I was going with that.
Well, let's just stay with what we're doing right now. I'm talking about your concern about my client being detained, and I think you've answered that you had no concern at that time, correct?
No, it just wasn't an issue at the time.
Okay, when did it become an issue for you?
It never became an issue.
Okay, so it never really came up in terms of trying to detain him?
No, not that day, no,
Okay,
if that's what you're asking.
Yeah, that day.
Okay, no.
Ma'am, just tell him what he wants to know.
Do you know how long it was
Kind of disappointed.
before he was reunited with his daughter Valerie that day?
I don't know. I know when I went to get everybody a hotel and they were together then.
Okay, and how long after the incident was that?
I didn't know the time.
Was it the same day?
It was the same day.
Okay. And were you, so you arranged the hotel so the family could stay outside of the home?
Correct.
And is that normal for your position when there's a crime scene, an active crime scene?
Yes.
Okay. And
That's helpful.
Is it normal for there to be surveillance going on in a hotel like that?
I can't answer that. That's not my wheelhouse.
Okay, so you didn't have anything to do with
No.
surveillance?
There was surveillance? Oh boy. I agree she's being very cautious. I think she is being cautious. I think she's also buffering that the defense would actually ask her, what concerns did you have about my client? I do think she is being cautious, and I think she is buffering that that's what he is asking. Oh boy.
Court's indulgence.
Yes, sir.
For all of you coming in on the code red, the head of victim services advocate division is being asked repeatedly by the defense what concerns she had about the defendant and if she was concerned about him being out of custody and if she wanted him to be
Your Honor, I don't have any
detained.
further questions.
Cross-examination?
Thank you.
Yes, ma'am.
I think defense pulling the ripcord was the best ever for him. That was the best strategy we've seen from the defense this far, was stopping this line of questioning. But now we have heard that there is surveillance at the hotel. And now we're into cross.
Good afternoon.
Good afternoon.
I feel like he
Um,
opened a big old
Just
can
briefly,
of worms.
Can you explain what it was that raised the question of Christine Banfield having been set up?
Repeat the question. I'm sorry.
Sure. What was it? So Mr. Carroll went through with you repeatedly about when did catfishing become a topic of conversation. My question was when you were asked, but we're not able to finish answering. What was it that happened that raised in your mind the question of Christine having been set up?
At the hotel. So from my understanding, we had an intel detective in the lobby of the hotel that we had everybody in, and she had asked Juliana, can I call you mommy now?
When you say she, who are we
I'm
talking
sorry,
about?
Valerie. Said, can I-
Valerie, Christine's daughter?
Yes, said, can I call you mommy now? Juliana, again, I don't remember her answer. She said yes.
In the lobby of the hotel. In the lobby of the hotel? We're going back to normal speed. What was it that raised a red flag for you? The 4-year-old asking the au pair, can I call you mommy now? Y'all, this is the same day. This is the same day. This is the day of the crime. Oh, boy.
The question of Christine having been set up.
At the hotel. So from my understanding, we had an intel detective in the lobby of the hotel that we had everybody in. And she had asked Juliana, can I call you mommy now?
When you say she, who are we
I'm
talking
sorry,
about?
Valerie. Said,
Valerie, Christine's daughter?
Yes. Said, can I call you mommy now? Juliana, again, I don't remember her answer. She said yes. And then she said, are you going to marry my daddy? And Juliana said, I wish.
Okay.
More things the prosecution never would have gotten into if the defense hadn't stepped directly into it. So the thing that changed her mind and was like, was that the day of the murder, the 4-year-old Valerie is asking Juliana, can I call you mommy now? Are you going to marry daddy? Juliana's response is, I wish. What the fuck had they been talking about to the 4-year-old before all of this? Cause that's a real strange question on this very traumatic day. Oh, boy.
Juliana, again, I don't remember her answer. She said yes. And then she said, are you going to marry my daddy? And Juliana said, I wish.
Okay. Thank you. I don't have any other questions, Judge.
All right, redirect. Or is this witness subject to recall? All right, you're free to go, ma'am. Thank you. Your next witness?
Well, in a shocking awareness of self-preservation, defense counsel had no redirect. Holy shit. Can someone please help me find the point? Why did defense call this witness? Why was this the witness you chose? Why did you pick this witness? What was the point of this for the defense? What was the point? That's shocking. Okay, next witness, I guess. But that's quite a reveal that the day of the murder, the 4-year-old is asking Juliana, can I call you mommy now? Are you going to marry my daddy? And Juliana was like, yes, you can call me mommy. And I wish. That is a very, very, very strange thing for the defense to know this witness knows and call this witness. Okay. That's, the errors continue. We're gonna reset from code red. We can't get code any redder. I'm code baffled at this point. What are you doing? I don't know what you've done to help your client.
Detective Miller?
Yet.
Detective Miller again?
Yes.
All right.
Again? Detective Miller again?
Detective Miller?
Okay.
He's already under us.
I think counsel's adjusting his pants because he might have found the code brown. Emily, that's way too snarky. I don't know if it is. I don't know if it is. I don't know if it's too snarky after what he's done today. I don't think I've seen anything quite like this. I don't think I have. I don't think I have. I don't think I have. Again with what, B3? All the microphones are muted. It wasn't me. Did they approach?
Bear with me, Detective Miller.
No. Bear with me. No. We're going to zoom past the
Witnesses
sniffling
today,
as
specifically,
best we can.
Lieutenant Giaccio.
Yeah, so Miller sat in the courtroom and was listening to the testimony and is now back. So witness 4 recalled for Miller. What a fucking wild day.
Giaccio, correct?
Yes.
Okay. And he indicated that he reviewed the digital forensics in this case, correct?
I believe he said not in its entirety.
Okay. In his testimony, what did you hear him say?
You called this witness to ask him what another witness testified to, like, before lunch? Huh?
That he reviewed things with me.
Okay. And the things that he reviewed, do you have any idea what those were?
Off the top of my head, no, there was a large amount of data in this case.
Okay. And in fact, you
Miller looks like he has just been
nearly
yelled
60
at.
devices, correct?
It was a large number of devices, yes.
You don't remember whether it was 60 or not?
It was in that neighborhood.
So we have confirmation. It was 60 fucking devices. From where? Oh my goodness.
Okay. And so whatever data that you had extracted that you chose to share with him, would that have been the raw data that you extracted?
I believe everything provided was in report form.
Okay. So he didn't get into the level of detail that you get into in your analysis?
Chat, that's my bad.
I would
Sorry.
not imagine so. I don't recall.
My phone's been blowing up all day. There are serious happenings afoot today. I forgot to put this back at 1.25. I apologize for the trauma that has caused. We're back at 1.25 and we'll go back to 1.5 if we need to. Emily, you're being vague about serious business afoot. Yet the Dave Matthews Band tour schedule is just kind of a clusterfuck today. So yeah, we'll discuss later.
On data specifically.
I don't have room to process
Well,
yet.
let me ask you this. You heard him testify. Did he ever sit down with you and ask you to go through your work?
Judge, at this point in time, I would object. I believe counsel is trying to impeach his own witness, Detective Giaccio, with this witness.
I'm not sure, but I'll overrule the objection.
Judge, I'm not sure what's happening. I'm not sure what's happening. Also, the objection, it's improper impeachment because the witness has to be confronted with the error and allowed to answer. So you can't impeach someone if you don't confront them with it. So improper impeachment was the objection, and the judge is like, I don't know.
For now.
Okay.
See where we go.
I was like, let's see.
Could
what's
you ask the
happening.
question again, please?
Did you ever sit down with Detective Giaccio and explain your work that resulted in the executive summary?
He said numerous times he did.
I don't recall if I did it in its entirety.
Okay. Can you tell the ladies and gentlemen of the jury of the times that you did it? What were you telling him?
Why?
And showing him, and how he arrived at conclusions?
Well, again, it's a summary, and I believe at the top of it, it qualifies that it's not every artifact involved in this case.
Okay.
So there would be times we would go over aspects that there were questions about.
Okay. And did you ever agree with the things that he was saying about it?
Your Honor, objection, it's vague.
All right, you want to rephrase it?
Yes. Did you ever agree with his conclusions relating to your work?
Objection again, Judge, still vague. There were so many conclusions we've heard testified to.
Give more
Okay.
specifics.
Say, for example, on January 9th of 2023, the analysis of the opening of the email account. You know what I'm talking about?
Yes, sir.
Okay. And did you go into your conclusions and how you arrived there with him in any of those meetings?
Yes, I went through the devices that were involved based on the data extractions and the warrant returns, et cetera.
Okay. And I know you did because you made the decisions, but I'm asking, did you go through that with Lieutenant Giaccio on that specific day?
I believe that was one of the items we went over.
Okay. And was that something that he agreed with you on?
There was heavy discussion about being able to attribute activity to a particular person. And I believe I stated that in this field, barring external corroboration, it is difficult to attribute activity to a person. But given that devices
your
were
ass
known
did it
to
anyway.
travel with somebody, it's logical to look for aspects where dominion and control may have been lost.
Okay. And in discussing that with him, did you find that
There it is.
at that time?
There it is. That's where the defense attorney is pulling that language from. The defense keeps saying, did Christine Banfield ever lose dominion and control over her devices? Did she ever lose dominion and control over his devices? That language obviously came from his report, as he's saying, we were looking to see if someone lost dominion or control over their devices. Okay, well, if I'm at home asleep and my husband or one of my kids opens my phone because they need to access the lights or something, I haven't lost dominion and control over my phone. I am, in fact, home. I'm also not the person using my phone. Okay, but at least we now know where that came from.
Objection as to form, Judge, find what?
That the devices, I'm sorry, did you find what you just described, that the devices were separate from the person during the January 9th?
Again, without external corroboration, I can't determine the actual person behind the device.
Okay, I understand that. But your findings were that there's no evidence.
Objection asked and answered. He just indicated that he could not. Fine.
Objection, next question.
In terms of that specific day,
Oh, the prosecutor's so fucking done. Here's the thing that's so difficult. This witness testified yesterday that his conclusions were wrong and that he does not stand by them. And the defense keeps trying to make fetch happen and being like, but your conclusions were this, your conclusions were this. He's already said, I don't stand by my conclusions and I was wrong. The data extraction was correct. My conclusions from it was wrong. So why are we doing this a third time? Are we just trying to like solidify the L or, yeah,
did Lieutenant Giaccio end up agreeing with your conclusions?
no dog. He did not.
I would say that there was disagreement over the way I had phrased the document.
The way you phrased it. Okay.
Yes, I'm sorry.
Yes, I'm sorry.
And so not relating to your analysis of the data, am I to understand that?
Can you clarify your question? I'm a little confused.
I'm just following up on your previous answer, and I'm
We're
trying
all
to
confused.
clarify the meeting between you and Lieutenant Giaccio relating to the January 9th, 2003 artifacts.
Judge, that's not a question. Objection.
You phrase it as a question.
Objection, Your Honor, WTF. Chad, I'm sua sponte making my own motion to move us to 1.5. Counsel seems to be trying to come up with a constructive line of questioning in real time, and it's not going well. So 1.25. Also, we heard what the other witnesses said. This witness's perception of what the other witnesses were thinking is also all speculative.
Yes. Just what I said. Did he agree with you as to those artifacts on that day?
An
Calls
objection
for
asked and answered.
speculation.
The witness testified that there was a disagreement over the way document.
You can answer this one.
I would have the same answer. There were disagreements over the way that I had written that document.
Okay, so on that particular portion of that document, there were disagreements. And my question, I think, that started this all was that relating to the data that you extracted and interpreted, or the characterization of it?
Chat, what's the answer? What's the answer? Were the disagreements over the extracted data or over the conclusions and interpretation of it?
Again, I would say the disagreement was over what was on the paper.
Okay. And so when, in terms of that specific section,
It is so
was there
asked and
agreement
answered.
between the two of you?
There were a lot of things on that document, even on that day, as far as what the devices were doing, I think we were all in agreement the devices were doing what the devices were doing.
Right. But he wasn't in agreement with your conclusions.
Judge asked and answered.
Next question, please.
I appreciate, Judge. I'm not sure that it was.
Ask and answer.
Okay.
Counsel, just because you're not listening doesn't mean it didn't happen. Also, Queen, I'm so sorry that the closed captioning was over your face. Apologies. Counsel, you not processing the information is not the same.
So let's move on to another day that was a crucial day in this catfishing, January 23rd.
Objection to counsel's testifying.
Okay.
Form of the
How
question.
about January 23rd? Did you do an
Counsel, what?
analysis of the devices on that day?
I'm trying to recall the specific devices done on that day. Again, there were a lot of devices processed on a large number of days.
Do you have your reports with you?
I believe they're...
Is it all right, Judge, if he can retrieve that?
Oh, God.
I think it's on the front. They're on the front.
No. For all of you that are jumping in because of the code red and other things, Queen is the bailiff that's sitting behind defendant. So Emily is saying Queen. It is the sheriff's last name. His name is Queen. Last name Queen. And all of us are looking for a silver lining to the defense case, and Queen is one of the silver linings that we have grasped with both hands, and we will not let go at this point. So, yep. Last
What
name.
year, sir?
Deputy Queen. Alex O'Shore asked, are these hostile witnesses? They are not hostile witnesses. They are called by the defense, and they are testifying. They are responding to questions. They are being asked by supposedly open-ended questions. The leading objections are being sustained. None of them have been hostile to the defense. I think all of these witnesses have been a bit befuddled by the defense, but they've been answering the questions. They're not thrilled, but they've answered. We are at 1.5, and he is just flipping through reports to answer what date things were processed on.
I'm sorry, was the question a device that I processed on that date?
Yes.
Yeah, no, that's not what the question was at all. Counsel's already forgotten.
January 2023.
No, I'm sorry. It would have been the artifacts relating to that date.
Do you know which device in particular? I mean, there are a lot of devices.
So I guess as a guide, I was trying.
Let me clear this up for you, Miller. Counsel's not prepared. Counsel is trying to have you answer something. He doesn't know what he's looking for because he is not prepared. So he's just kind of going with it to see what happens. He's just kind of see what shakes out. So that's why it feels like there's no order and you have no idea what the fuck that you're trying to answer because he has no idea what the fuck he's trying to ask. The disorganization and the lack of being prepared is boggling. And we've seen that with frustration with all of the witnesses.
To break it down as to specific days, but we can use your executive summary if you'd like to and then go through it that way. Do you have that available to you?
It's not up for the witness to decide,
Yes,
counsel. It's for you to decide. Counsel, you have to decide what you want to ask him. And then you ask him the question. We're on 1.5 and I'm still zooming. And the jury is sitting there going, huh? I feel so bad for the jury.
Detective Miller?
I have one in front of me, yes.
Okay, so let me ask you this. In terms of all the devices in this investigation, did you image all of those?
I extracted data from all the devices, yes.
Okay, and is that essentially imaging, or am I using the wrong term?
You're the tech
Imaging
guy.
would imply depending on the circumstance, a bit for big copy.
Okay, and in your extraction, did you extract all of the devices in what you deem a forensically sound manner, consistent with your training and best practices?
Yes.
Asked and answered yesterday.
Did you process the extraction?
Chad, I figured it out. I figured it out. I figured it out. I figured it out. We're being catfished by defense counsel. That we've been catfished by defense counsel. That's the catfishing. That's where it is. Us. We have been catfished. The defense was going to come in here and put on a case in chief, like a lawyer and like a defense attorney. And now he has come in here and asked questions that are more helpful to the prosecution. I think we've just been catfished. I think we've been catfished. I think that's what it is. That's where the catfishing comes in. It's the defense attorney.
Extracted data using forensically approved and verified tools?
Yeah.
Yes.
Yep. That's what,
Listening to the testimony before, Lieutenant Giaccio testified that he received data extractions from you. Is that correct?
I don't recall his exact phrasing.
I'm sorry, I didn't hear what you asked.
I don't recall the exact phrasing of his answer.
Okay. Did you ever give him data extractions that came from you?
Data was provided, portable cases and Cellbrite reader reports. A lot of data was provided to a lot of people in this case.
there's
Okay,
8
specifically,
terabytes of data in
based
this
on what
case.
Detective or Lieutenant Giaccio said. Do you remember what you had given him?
Not specifically.
And I think in previous
The limit does
testimony, you
not
had
exist.
testified that you'd given your data extractions to the lead homicide detective, correct?
Yes.
And is that just part of the routine of making sure he has a full case?
Yes, it's important to pass the data on.
And did you provide data to Lieutenant Giaccio and the detectives in the form of a magnet portable case
Yes.
and or Cellbrite reader formats?
Yes.
Okay. Did those productions contain the same data you extracted from the respective devices and reviewed during your analysis in this case?
I believe so.
Did you provide the investigators with the evidence? Yes. For those of you that ask how I take notes of things I either want to remember or that stand out or that are dates that I need to put in a timeline. There are no notes that I've gleaned from this witness.
So I'm going to try to show you something here.
I'm going to try to show you something. Good luck, counsel. Did you lay foundation for it yet or not?
Sir, do you see something on your screen?
I do.
Okay. Are those examples of the data that you provided to Lieutenant Giaccio?
There's screen captures and what appear to be a Word document that appear to have come from those guys.
Okay. And
Judge, I apologize. It's probably just me, but is there any way we can zoom? I can't read a single word on the page.
Can you zoom that a little?
let me see if I can do that.
Objection, Your Honor. WTF is
Much
this?
better. Thank
A little
you.
better?
Yes, thank you.
Okay. Sir, what is this?
Huh?
This appears to be a screen capture from a portable case in a Word document.
Okay. Are these the things that you provided to the lead detective and Lieutenant Giaccio,
These screen captures?
or what these screen captures contain?
All portable cases and reports generated in this case were provided to Detective Bryant and others.
Okay. And do you know, were these same items provided in discovery? I'm just scrolling down.
I
No,
believe they were.
no, counsel. They weren't provided in discovery. No, the things you have in your hot little hands were never provided to you, in fact. Where do they counsel? You have them. So where did they come from? Seeing that you have them.
I'm just going to continue scrolling down so you see them. All of those items.
Well, at least I stood up and we're not just sitting through this. I mean, we're working with the stand desk. We're gonna stretch the legs so we're not sitting for 7 hours on a row. But oh my God, this is painful.
These are all the devices that you went through?
I don't believe it's all of them, but these are devices I went through, yes.
Okay, and are those devices that you provided in to Detective Bryant and I guess based on his testimony, Lieutenant Giaccio?
Yes, these were provided to Detective Bryant.
Okay, but were these the things that you gave to Lieutenant Giaccio?
I believe he had access to all of them.
Okay, so you didn't actually give them to him, he just had access as supervisor?
I don't recall what I provided him directly.
Okay. Okay, so he had access. You don't know if you provided it.
Judge asked and answered.
Sustain.
I have no idea why he's recalled this witness other than to maybe try to lay the foundation for the report. I don't know.
You're on court's indulgence for a moment?
No.
Do you have the portable cases for these with you?
I do not.
Where do they reside now?
Evidence locker?
Right now, I believe they're on hard drives back at headquarters.
Okay. And would you have access to those in order to move them into evidence
No.
Right now, no.
or in the future?
Bro, what?
Bruh.
I have access.
Objection. I'm not sure.
The witness is so confused. What?
Everyone approach.
I appreciate that the judge is trying to help counsel not get yelled at in front of the jury. What do you think Judge A said? Counsel? What are we trying to do with this? What are we doing? What are we trying to do? Counsel, what are you attempting to do here? Because we're not admitting 8 terabytes of Celebrite extractions into evidence. That's not gonna happen. Counsel, that's not how this works. Normally I would fast forward through the sidebars, but Judge A's face has been expressive and I find it very funny. So I'm going to watch as long as it stays. No, I was going to say as long as it stays not on the defendant's face. I want to watch the sidebar. I don't need to see the defendant's face continues to face. Did we get to see the end of the sidebar? No. Judge A is just like, oh my. Also, you get a sense for how large this courtroom is. I also am beginning to wonder, this looks like a remote cam that is set up on the corner of the judge's bench near where the witness is. I wonder if this is the camera angle where we keep ending up with looking like the defendant is staring at us. This is a massive courtroom, but I wonder if that is the camera that it looks like the defendant's looking at when he's looking over at like witnesses in the jury. Because I think that's probably what that is. That wouldn't be there all the time, but oh my goodness. This is much. This is much. Oh, we're not asking questions? We're back from sidebar and we're not asking questions. No, I unpaused this. We're unpaused. Good. Okay. We're all just sitting here. I'm zooming. The witness
Karen,
looks
can you see that on the
confused.
screen?
Oh boy.
Sir, can you identify those? Or can you see them?
You might have like a little bigger. Or maybe you can identify it as it is. I'm not sure.
This appears to be a screen capture of messages from one of the reports.
Okay. And are you familiar with the the data that went into this screen capture?
Is in the data extracted from the device? Yes.
Okay. And what, if anything,
Nope.
do you see in this series of communications?
I see the item number titled Christine phone, and then I see messages below that.
Okay, and this is what date? Sorry. What day is identified in this?
January 9th,
Okay.
2023.
And is that one of the important days in this case?
Yes.
Okay. What's the significance of January 9th?
Go ahead and
That
answer
was the
along.
day the Gmail account was created.
Okay. And
Answer along at home, because now there are some dates that we definitely know.
what can you conclude by looking at this screenshot?
The messages were sent using this device.
And can you identify who the other device is?
I see a phone number.
Do you know that from your analysis of this case?
Not off the top of my head.
Do you know who was on WhatsApp of the people that were using devices in this case?
Multiple people were using WhatsApp.
Do you know who? Other than Christine, who else communicated with WhatsApp with her?
Juliana.
Okay. In this situation, do you have any conclusions as to who Christine is communicating with?
Objection asked and answered. He indicated he doesn't remember the phone.
Overruled.
In context, it would appear to be Juliana.
Okay.
And?
Just for the record, I believe you marked that prior to as defendant's 86.
86. Okay. Thank you, Her.
Thanks for the assist, Your Honor. Thanks for the assist. I'm zooming.
If you'd like your expert to help you.
Did the court just say if you'd like your expert to help you? Huh. Since we don't want to do an ASMR of defense counsel sniffling, I'm going to just zoom.
Can you identify the communication that you see there?
It appears to be Facebook messages.
And what, have you seen these in your own independent investigation?
I would imagine at some point in the last almost 3 years.
Okay. And when you were looking at these, specifically these, what,
Yes, chat, we're still at 1.5 speed.
let me have you look at,
We're still at 1.5.
what is that?
It looks like a screen capture of details and artifact information.
And how would you extract an artifact like that?
A single artifact?
This particular artifact?
Well, the device would have had data extracted from it, and then that would have been put into a tool.
And this particular artifact, what can you gain from that?
Just what's on the page right now.
That, so can you go through that?
Objection. He's asking for the witness to testify to the document if he wishes to admit it.
Yeah, we're at 1.5.
That would be the first step.
Your Honor, I'd move to admit this
You have a number for me?
as, I do have a number.
The 109, I guess, if that's what you want to do.
109.
Any objection to 109?
Yes, Judge, relevance.
Overruled. I'll allow 109 in evidence.
And Judge, if I may, it's a document from 2021 and we don't know who it's purported to be between.
All right, overruled the objection. 109 in evidence.
Thank you.
Vote now. Okay, no. So what number is this one then?
The court overruled the objection. 109 is coming in. I think foundation would have been better. Counsel tried to indicate, but Your Honor, it's old. Who's this between? Okay.
I had this one as 86.
I just want to make sure I get the record clear.
Yeah, why don't we do this? If we can, Judge, can we make this one 109?
Okay.
And the other one 110?
All right, so 110 subtraction. This is 109. Any objection to 109?
Same objection.
All right, overruled 109 in evidence. Okay. I think we're on the same page now.
Sir, do you see the connection between the communications here and the extractions? And I can go to the next page.
Huh?
again, these are screen captures from what I would assume would be a portable case, but I don't have the whole thing here.
Okay. And that's 110?
110.
And what do you see there?
Look at that, y'all. We get to see it. It says details, artifact information, estimate 10 a.m. windows, start date time 12/23/2021, 8 a.m., end time 12/23/2021, 9 a.m., C, Banfield RN at Gmail, time zone, New York, type calendar events, and then an item ID. So, yeah, I imagine on the East Coast that everything's going to be in New York, just like everything central defaults to Chicago. So at least we know what time zone it's in.
Details of artifact information.
Now,
what was that? Hold on. Chat, I'm grasping at straws here. I just am curious what gets on the screen after he goes to move this off the screen. Hold on. I don't know if this is in evidence or not in evidence, but it looks like messaging between something that says Christine phone. The message in yellow at the top says thanks for your understanding. The next message says let's do this. This is January 18th, 2023. The next one says what time works best. The next one says same time. These look like on January 18th, 2022, not 2023. The next one says sure. These say Christine phone. Then the bottom one says just want to confirm our appointment for today. Not sure if you need to change it because of the weather.
Now, when you, do you see the, what appears to be a conversation going on?
Would this be 111 then?
111.
Okay.
Yes, I see messages.
And in terms of the messages, what's the, are any of the devices that you had extracted present on these communications?
I'm sorry, can you ask the question again?
Or any of the devices that you extracted data from present on these communications?
Oh boy.
I see an item number and a label.
And are you talking about the yellow or the blue?
The blue, where it says local user.
Okay, and the label on that?
It has an item number and says Christine phone.
Now, did you hear testimony regarding Windows today or even days before?
I recall Windows being mentioned.
Okay, and in this communication, in your expert opinion, can you conclude a date as to the communication?
Sorry, the angle changed and
Judge, I'm going to object
I was covering Queen's face again with the, here, we'll just do it this way.
to the witness testifying to the contents of the
Do you
document.
wish to have this in evidence?
Yes.
Any objection?
Judge, I would object. It's hearsay.
Yeah,
We
it's
do
hearsay.
not have the speaker testifying.
111, Your Honor.
It's
This
hearsay.
would be for, as an extraction.
It's here. Just because it's extracted doesn't mean that the words aren't hearsay.
That he's identified.
I understand, but there's still hearsay and it's what the objection is.
Well, Your Honor, I would say that this is an extraction through digital forensics.
Okay, but the words in the conversation are still hearsay. It doesn't matter that the conversation was extracted because of a digital forensic examination. The last time I checked the evidence code, but Your Honor, it was extracted by Celebrite isn't an exception to the hearsay rule. It's part of foundation, but it's not going to help with the hearsay because the words are the hearsay, counsel, the words.
Through sound principles, which he's testified to.
Right.
But Your Honor, it was extracted properly. Still hearsay, my guy.
This is an extraction through digital forensics, through sound principles, which he's testified to.
Right, I understand that, but inside that, there is hearsay. So I'll sustain objection as to hearsay.
Okay.
Counsel, how? How? Just
So you see
how?
what is described as a discussion about windows?
I do.
And when does that take place?
Judge, same objection.
He hasn't moved it in yet.
Correct.
I'll allow that question.
I'm sorry, repeat the question.
Again, Judge, the objection is to the witness testifying as to the contents of the document.
I understand. I'll allow that question.
What date is the, oh, just went out.
Oh, boy. I suspect what counsel is trying to do is to say that Christine was the one having the conversation about the triple paned windows being installed. I suspect that's where he's trying to go. However, you're not going to get that in with this witness. And the window installer or the window salesman already testified, and he testified about the conversations he had with your client. So unless you have an exception to bring in the statements that you think are attributable to the victim, that's just not going to work. But I think that's what he's trying to do.
I think I have a power issue.
Can you use another computer?
Yeah, I think you probably do. You need like a snacky snack. I do think it's a power issue. I don't think it's a tech issue, but I do.
Is yours?
And now counsel is over at the side of the courtroom talking to the witness that was yeeted off the stand by counsel yesterday. His other tech, the Fed guy. I'm still at 1.5 speed, chat. Make sure you don't sleep. I think he's talking about the computer, not you, counsel. He's talking about the computer. Oh boy. And we're on 1.5. The jury is sitting there in real time with this. I'm going to just zoom past them having a conversation about this because I can't imagine what the jury's thinking. They're thinking they're not going to have time to go buy snow snacks is what they're thinking. Because this was on Thursday last week. And they're sitting there going, I need to do laundry before this Snowmageddon. I have things to do.
These communications were taking place.
And Judge, to clarify the objection, he's asking for information contained within the document, which is hearsay. If he's asking about
Still fucking hearsay. Agreed.
the date they're extracted,
Allow the
yes.
date. Your objection is
Okay,
overruled.
thank you.
The judge said, and the judge, you can tell we're at 1.5 when the judge speaks. We're, as to the date, your objection's overruled.
6/28/2022.
6/28/2022.
Would this be 113 then?
113.
Okay.
Sir, based upon your extractions, based upon the information that you looked at from Christine's phone, do you recall this?
I don't recall doing a dive specifically into Windows.
Into the specific topic of Windows?
Windows came up much later in the investigation.
Okay.
We
And
know-
So
We now know exactly when Windows came up.
when the Windows came up was during the
the
initial
walls.
recant in October, correct?
Yes,
Was that the first time you'd heard about Windows?
I believe so.
Had you been involved, would you have been in a position to advise whomever was there as to what the content was on her phone?
Possibly.
Okay. Were you ever asked about it?
No, because he wasn't on the case at that point. He'd already
I
been
think later
moved.
on, Windows came up. I can't recall the exact artifacts that I looked at, though.
And they came up because, well, let me ask you this. Did they come up because they were taking the orders and things like that were taken off of my client's laptop?
I just I recall conversations with Detective Bryant about windows that came up later in the investigation.
Okay, and did you do anything?
We know why windows came up. We know why windows came up. Two people testified about it today that windows came up because of Juliana. Oh, come on, counsel.
To determine whether that was what Juliana Perez Magalhaes had said was true relating to the artifacts that you looked at?
I don't recall specific artifacts that I looked at relating to that.
If you had been involved when she first said that, or been in the room, would that have been an opportunity to inform the questioner?
No.
Judge, objections to form. I don't think it's clear. Inform the.
Objection. This is a stupid question. Counsel. That's not even how that would work. If Juliana brought up the issue of windows, even if Bro had been in the room, nobody had any idea. It would have been like, let's go back and look later, which seems to be what they did. Nothing would have changed if Miller was in the room. Where it happened. Okay, now we've switched songs. I guess there's that.
The questioner?
Judge, objections to form. I don't think it's clear. Inform the objections to what?
Okay. In the room when the recant on October 25th.
The interview?
If you had been in the room, would you have had the ability to inform any questioner as to what the specifics of the window purchases were?
Nope.
I don't think at that time I would have been prepared to do that.
If you had heard that for the first time, as many did, would you have been able to track that down?
Judge, I object to the form of the question. What is that?
Would you have been able to track down information relating to the window purchase?
Yes.
And what would it take in order for you to confirm or deny what she was saying in the recant?
Going through the devices, keyword searches, things like that.
Okay. And in this instance, do you see the writing on the screen?
He's not going to be in the room that they're having a proffer interview going through 8 terabytes of data to search about the windows to find out that it was accurate. Okay.
I do.
I think that would be 113 or?
Yes, 113.
Is that what was done in this situation?
I don't recall making the screen capture.
Can you look at it and tell whether or not that's a search for windows?
I could assume it is, but since I didn't create the screen capture, I don't know definitively how that came to be.
Right.
Sir, can you see
I didn't make that screen cap, so I don't know
the
how they did it.
communication with what it says is Christine's phone on December 3rd, 2022?
Yes.
And the communication?
Judge, objection is to form.
You can't get the hearsay in just because you asked
I'll just do
different.
objection to form.
What does this artifact indicate to you?
For the record, that's 115.
115.
Fucking hell.
Again, it's a screen capture of artifact information. Says summary windows, which is highlighted in yellow.
And is that indicative of a search for windows?
Again,
Bro
I
said
didn't create the screen
IDK.
capture, so I can't state how that came to be there.
Well, in terms of the standards that you live up to as an expert in digital forensics, is this something that you would require of yourself if you're doing a screen grab?
Huh?
Objection is to form. Is what something he would require of himself?
The item that's on 115.
The artifact information here? When going through artifacts, yes, I would look at a breakdown of the data surrounding it.
And what can you opine about what you see there?
That it's a screen capture with a summary of windows. There's an email address associated with the calendar. Time zone is UTC. It's a calendar event.
And do you recognize the email that's being used?
I do.
Okay. And what email is that?
cbanfieldrn@gmail.com.
Okay. And is that her email, her personal email?
Objection, Judge, is that whose email?
Is that Christine Banfield's email?
Yes.
Your Honor, I'd move into evidence.
The window guy already testified.
Defense exhibits 110, 115.
110 is already in evidence. 111 was
110 is admitted, 111 was already offered and
offered
denied.
and sustained. Yes, the objection was sustained. So we're up to, you want 115, which is the last artifact.
Yes, 115.
115, no objection. 114, objection. Hearsay.
He only offered 115.
Oh, I thought he said 110 through.
I initially said that.
Okay, so 115 is in evidence. We can go there. Now, do you want 112? Are you looking for the other ones as well?
Yes, sure.
All right, let's go to 112. I just got to get it on the screen. Can you get 112 on the screen for me? Because I believe that's
Oh, fuck.
109.
What's happening? The defense is not organized. He's trying to get things into evidence that he can't get into evidence. There were things that were already denied. He's now trying to move them in again. The court's like, what are we doing? And the prosecution's like, huh? So they have a calendar event that was created with Christine Banfield's Gmail that says Windows. The individual that talked about getting the windows testified that he dealt with the defendant. Okay.
110, 111. That's 112.
112.
112.
Objection, hearsay.
All right, the objection's hearsay.
Your Honor, I would, may we approach?
Approaching is not going to help. I think he is going to try to somehow negate that bro got triple paned soundproof windows, planning to murder his wife because she made the calendar event. I would imagine you would have to tell your spouse if you're going to replace the windows in the entire house, though. So, okay.
Sure.
We're back from sidebar and still nothing.
Recognize the data from this particular slide, slide 1,
The record mark that's 116.
116.
It appears to be a screenshot of the cprn920gmail.com.
And what's the date?
Different Gmail.
January 9th.
This is the new
2023.
Gmail.
Yes. Now, what are the 3 entries there as best you can tell?
They just appear to be potentially emails with subject lines. One of them is blank.
And the other?
One says pics, the other says pics 2.
And is this the email account that's alleged to have been created by someone other than Christine Banfield?
Yes.
Based upon your investigation? And what is this that you see
He
here?
didn't even answer. Yeah.
Screen capture of what appear to be logins with IP addresses and dates.
Okay. And do you, specifically January 9th, do you see that login?
I do.
And what does that indicate to you, and what device does that indicate is logging in?
Looks like a Samsung SMG 991U with Android 13.
And do you know who whose device has that identifying characteristic?
If memory serves, 2 devices have that pedigree.
Have SMG991U?
If memory serves, Mr. Banfield's IRS phone also has that same, it's the same model number.
That was 117.
117.
And now this is 118.
118.
Okay.
Okay.
This would be
Sorry, Judge.
19 then?
Yes.
You went back to 118.
I went back to 118.
Okay,
I think I hit 119.
All right, that's fine. 118.
Detective Miller, what do you see here in this slide?
Again, screen capture with IP addresses with what appears to be login information.
And is there anything you can get from that login information?
The user agent is on the right.
Okay.
And how is that being logged in?
I mean, poor Miller's eyebrows are going to get
No,
struck
Windows device.
in quizzical.
Can you tell whether that's a phone or a laptop based upon what you see there?
He didn't do the work. He
From
didn't
what I see there,
make
be
the
laptop
screen
or a
cap.
computer running Windows.
Okay.
Why are we just asking him about shit that he didn't do?
Get 119. Oops. Can you identify what that is?
Oh, I'm sorry, Judge, I can't even begin.
That's my favorite objection so far. Your Honor, I can't. Your Honor, I can't even begin. Your Honor, I can't. Oh boy.
Can you identify what that is?
Oh, I'm sorry, Judge, I can't even begin.
Make it a little bigger, maybe so you can see some of it.
I'll do that. We'll just look down the center column.
I felt that deep, deep in my soul.
Can you see that, sir?
Yes.
And what does it show? What does it indicate to you?
Again, it appears to be a screen capture with emails and artifacts.
Okay.
And is there anything there that can identify what device was being used?
Not that I'm picking up from the screen capture immediately.
And is it any information that you can look at that can identify what device?
He has a bunch of screen captures that this witness didn't create. And he's like, hey, what can you tell me about this? Does this mean anything to you? How about this? He extracted 8 terabytes of data and is now being presented with random screenshots that he didn't create that I think he's never seen before. And it's just like, hey, but what's this? And bro's like, honestly, I don't know. Honestly, I don't know. I don't know, counsel. I don't know what the fuck it is. I don't know.
Is being used?
Judge, I think asked and answered.
Same question you just asked.
Okay. Or what, how the, what email is being used?
I see the email address of cbrn920@gmail.com.
Okay. And what do these appear to be to you?
Email records.
Communications? And who are they from?
I see a lot of FetLife. And then, oh, they moved.
Oh, sorry. Were you talking about? Just trying to give you something else to look at.
No, that's fine. We can.
You can scroll down.
He said, I see a lot of FetLife. Sure. Because that's the second email
Yes,
address.
I see FetLife.
Terry, we're still at 1.5.
And FetLife?
Mm-hmm.
Yes, FetLife.
Mm-hmm.
And more FetLife?
I'm gonna start pulling up some of y'all's
Can
member
you tell from the
chats,
screenshot whether these
super chats
so
while we're going through this? Thank you to everyone who
are
gifted
you
memberships.
satisfied that they're all FetLife? Just based on scrolling around?
Objection, I think that's a mischaracterization of the evidence.
No, counsel, we're never going to be satisfied. If we're going to stay in the realm of Hamilton, never going to be satisfied. Never going to be satisfied, counsel. How can you ask an expert, are you satisfied that all these emails are from FetLife if he hasn't seen the data?
Another question to answer.
I can see what's in the screen capture, but again, I did not create the screen capture.
Okay. But if you were
Right.
if you were trying to create a screen capture from digital forensics, this would be the form in which it would come?
It could be, depends on what I'm trying to take a capture of.
Is there a way for you to determine whether these are still active or they've been deleted, anything like that?
From the screen capture?
Yes.
Boy.
I can move it if you need me to.
I would love you to move it, counsel. I would love you to move it. I would love it. I like to move it.
I'm not seeing a deletion marker in this.
I'm sorry, what? The location marker?
You asked if I could tell if something was deleted from what I'm looking at.
Yes. Do you need me to move it to someplace where you could tell on the screen grab?
Yeah. Yeah, I do.
I don't think this screen capture has everything in its entirety.
What makes you say that?
Fantastic.
If you scroll back up to the top,
I don't think this has everything in it. Yes, we're still at 1.5
So
speed.
if I were looking at it, like in a portable case or in actual Axiom or something like that, I would be able to see all of the data fields. But since I didn't create this screen capture, I don't recall if there's any data fields beyond what was taken in the screen capture.
What kind of data fields would you include in your screen capture?
What was relevant, and if there were specific artifacts, I would try to tag them when appropriate or make them known.
And in terms of the FetLife account, in this case, what would be relevant for categories for a screenshot?
I mean, I would want to look at everything.
What more than what's here?
I would want to look at everything. Right.
Again, I don't recall off the top of my head what other fields would be on that. And again, this is a screen capture that I didn't create.
Okay, but if you could create any screen capture, what more would you want?
Objection asked.
The prosecution came in hot with objection asked and answered so fucking fast. So fucking fast. But if you could create anything in the world, what would it be?
And answered, he said he doesn't know what other fields would have been available.
That's what he stated. I'll sustain objection. Next
Okay, and in terms of dates and times, things like that, can you opine about those?
I see dates and times.
And do you recognize a range of dates?
They don't appear to be in chronological order. I see that they're jumping around.
Would these be maintenance records relating to the FetLife account?
Jumping around, you say? Like, jump. House Payne's from Massachusetts, aren't they? Are we back to Boston today? Yep. Yep.
Maintenance records.
Yes.
I'm not sure I follow.
Would these be maintenance emails and communications?
They appear to be incoming communications from FetLife.
Okay, from FetLife to cbrn920@gmail.com?
Yes.
And what, if anything, does that indicate to you?
Oh boy.
That
Nothing.
the email address was receiving communication from FetLife.
What does that indicate to you? That emails were being sent to the email address? Big Fan of Justice asked earlier, why not just call Klingen, the other prosecutor? There are a lot of different attorney issues with the defense trying to call the former prosecutor on the case. There would not be a lot the former prosecutor could testify to, and it would be very difficult for the defense to be able to call the former prosecutor on the case. So he called law enforcement, and it's not getting better, because at this point, he's just like, I see emails. I see dates. I see skies of blue.
Your Honor, I move, I think 119 was the last one.
This is 119.
119. So 116, 117, 118, 119.
All right, we want to start with 116. Could you move back to 116?
If we can go back to what that was, I believe it was the screenshot of CBRN with the 1923.
Do you have any objection to 116?
No,
Okay,
Judge.
116 is in evidence. 117, which is the next one. Any objection to that?
No, Judge.
Okay, 117, and then 118.
No,
We're,
Judge.
All right,
we're still at
119.
1.5. We're still at
No, Judge.
1.5.
All right, just to clarify, should 119 be under seal since there are names of a lot of individuals that are not involved in this case?
Yes.
Okay,
if they
is that
redacted.
119 under seal?
Yes.
Okay, 119 is evidence under seal. We're going to stop right there, Mr. Carroll. I'm going to stop because we're already past 5:30, okay? So ladies and gentlemen, we're done for today.
Oh, Judge A. Oh, Judge A. Yeah, Mr. Carroll, I'm going to stop this here. I'm going to stop this here. Thank God. I'm going to stop you there. I'm going to stop you there. Thank God. Thank God. The judge is like, we're so fucking done here. I want to hear what the judge says. No, excuse me, chat. I want to hear what, if anything, the judge says to the attorneys.
We'll start back up at 10 a.m. tomorrow. So don't do any outside research. Don't talk to anybody about the case, okay? We'll see you in the morning. You can stay right there for a second. All right, thank you. You can step down.
Oh boy. All right, I'm going to put this back at normal speed because the judge is clearly ready to get the fuck out of there. I want to hear what she says to the attorneys at the end of the day. Oh, goodness.
All right, so have we worked on jury instructions?
Mine are in my office right now. I'm going
Okay.
to send them to them tonight.
All right, 9 o'clock tomorrow, we're going to go over jury instructions. Okay.
Oh, she tells them. She tells them 9 o'clock tomorrow. We're going over jury instructions.
Okay. 9
That's
a.m.
fine, Judge.
Tomorrow we'll do jury instructions. How many more witnesses do you have after Detective Leah?
Potentially 3.
3 witnesses, so you
Yeah.
should be done tomorrow. Is that correct?
Nope.
I don't know.
Okay.
Could be. I don't know.
Chat for everybody who's just clicking in. This is from last Thursday. So last Thursday, the court is saying, how many more witnesses do you have? 3 more witnesses. The judge, great. You should be done tomorrow. And he's like, yeah, no, probably not tomorrow. And the judge is just like, excuse the fuck out of me, counsel. What do you mean you're not going to be done tomorrow? Spoiler, they were not, in fact, fucking done on Friday. So.
Potentially 3.
3 witnesses, so you
Yeah.
should be done tomorrow. Is that correct?
I don't know.
Okay.
Could be. I don't know. It could be long.
Okay.
I'll try.
All right. We'll see about that. And then you said your rebuttal evidence is not.
Judge, I think, yes, we have 2 witnesses at most.
Okay.
The words the defense is not saying when he says it could be long is because he has not told anyone that his client plans to testify. That happens Friday morning. I don't know, Your Honor. It could be long. Well, damn.
So there is a possibility we might be able to get done tomorrow. My goal would be to get done with the evidence tomorrow and then have closing arguments whenever we come back from the snow. Have our jury instructions already done and closing, if we can get there. Okay, but I understand your witnesses. If we don't get there, we don't get there.
Right.
But if we have a 5-day break in between something, that's what I'm trying not to do. I want to try to get all the evidence in and then have a 5-day break and then do closing arguments. But
Right.
I mean, if we can, if we have to stay a little longer tomorrow night, I don't think any of them would mind. So
Right,
keep that in
right.
mind to be ready to finish everything tomorrow if we can.
Judge, we were ready to finish everything today.
Well, I understand that. Okay, if it can be done.
Judge, has a little update. We just
The prosecutor's like, I've been done, Your Honor. I've been ready to be done.
were told that
This is saying there's a nationwide Microsoft outage causing our email.
There's a nationwide Microsoft outage causing our emails to be down.
Causing what down, to be down?
email to be down.
Our email in our office.
I'm, okay, well, you'll figure it out. I'm not worried.
We'll figure it out.
Yeah.
The other thing, not just another housekeeping matter, exhibit.
Yes, chat, I've seen your motion. We have been streaming for 8 hours. We can look at like the first 10 minutes of Friday morning because tomorrow I'm probably going to just summarize Friday and then zoom into real time when they resume court tomorrow. So we can look at the first 10 minutes of Friday. We can look at the first 10 minutes of Friday. We can. We did it in the podcast too. But yes, we can look at the first 5 minutes of Friday because we're going to summarize Friday.
Exhibits 10 and Exhibit 16 have the included pages.
10
and I can share that with counsel and then we can address that tomorrow.
Back to defendants 10?
Yeah, 10 and 16, Judge, there were the letters that it said
That
2
were
out of 3.
truncated. Yes, the letters that were 2 out of 3 pages, and then the other one just stopped after
Okay.
2 pages, and we anticipated that there was more.
All right, so you need to add more to.
I also know that those of you who have already seen Friday morning just want to see defense get yelled at again. I understand. Because, yep.
One of these.
They're already done. I'm just going to share them with counsel and then we'll be ready
All
to.
right, but 10 was never submitted into evidence.
Correct.
Only 11. So we have to update 11. But we need to update 10 as well. Because
We would need
Well, 10 wasn't submitted because
It
one,
wasn't,
the one page
They were not
was.
admitted.
so now 10 is admitted.
Once we.
Once you get
I'll share that with them
All right.
if
10
Microsoft
and
Edge doesn't.
What
This
was
is
the
how
other one, 11?
disorganized this
16.
is.
16, 10 and 16. Okay, got it. I got the two. All right.
And so we
So
can
as
do
soon as we
that
get
first thing. Yeah.
First thing in the morning, we can take care of that. I'll see you at 9 o'clock with jury instructions. Okay.
Yes, if council wants to send that early, I mean, we're still waiting on yesterday's exhibits, so.
Oh, we don't have 82 yet?
I have a video that has been downloaded on the hard drive.
We haven't looked at it yet, reviewed it.
Oh,
I
boy.
have, yes.
Okay, so that
Correct.
is 82.
Correct.
So we have 82 and 83.
I don't have 83 because it was under seal.
Okay.
The prosecution's like, we still don't have the defense exhibits from yesterday. Ugh.
But the one that actually, I think I do have 83. It was the one that he gave me that was.
Right, I understand that, but you have all the videos there. But do you need today's video?
I do need today's without audio.
Without.
And Judge, what I'm raising is the Commonwealth is still missing yesterday's exhibits that were supposed to be submitted by close of day. We never received copies. We addressed this morning that the link that was shared did not allow us permission.
Oh, that's what they approached about first thing in the morning. They approached first thing in the morning that they were supposed to get the exhibits from yesterday and they didn't get them. Oof.
So
Oh, right,
we
'cause it
still
went
haven't,
back
I
to-
can't confirm.
So
that-
82 and 83, you need, can we email?
I can
Ugh.
email it. I can save it and email it to you all if you.
That's fine.
Well, we'll email 82 and 83 to you.
Okay,
Shannon
thank
will.
you. And then anything for today.
And then anything for today.
Counsel's so ready to go. Counsel's like, I got my
80
bag,
So.
my cut
to clarify,
matches. I'm ready to get the
82
fuck
is the
out.
continuation of Beckner's video, the second half.
Correct,
Okay,
yes.
we don't. We need to see what's been submitted. I still don't
Right.
know.
That's fine. 82, you need 82 and 83, and then whatever from today.
Yes.
Okay.
No wonder the court's so frustrated.
All right. We can do that. All right. Anything else?
I don't think so, Judge.
Okay. All right,
you.
9 o'clock.
Thank you.
Again, Judge A, off the bench with the
Judge.
Okay.
speed of
All right,
light.
9 o'clock.
Thank you.
9 o'clock. Peace. Oh, Judge A. Oh, Judge A. So at the end of the day, on day 6, the defense chose to recall to the stand Detective Miller. And you're going to say, but Emily, why? I don't know. I don't know why they've recalled Detective Miller. I don't know. I don't know. So far, they have shown Detective Miller a number of screen grabs of technical data that he did not create. They were trying to talk to him about, it seemed, a search for Windows, not the operating system, Windows, the ones reinstalled in the house. And they're trying to get into evidence that he didn't collect, he didn't sort, and that he extracted. He then confirmed that he extracted somewhere around 60 devices in this case. But the defense keeps showing him things saying, okay, but what about this? And he's like, I didn't create that. It seems like the defense is trying to lay a foundation, but is not going about it well. And then at one point, the defense was trying to bring in communications that had not been authenticated. The prosecution objected to hearsay, and the defense is like, but they've been extracted through reliable scientific means. And the court's like, yes, they've been extracted, but the words in the conversations are still in fact hearsay. So at the end of day 6, we have learned a lot, but not a ton that was helpful to the defense. I still can't figure out why they called the victim advocate. The head of the victim advocate division, the thing that sticks out about her testimony to me is that she was incredibly restrained when defense was asking if she wanted the defendant to be detained. And at one point she said her concerns about the defendant were the safety of the child. And then she kind of said, I'm not quite sure what you mean. It seemed to me that the victim advocate was being incredibly restrained and mindful, saying, counsel, I'm not sure if you're asking what you think you're asking, but are you asking me if I was afraid for everyone's safety while your client was not arrested? Is that really what you're asking? So she kept saying, I'm not quite sure what you're asking me. I'm not quite sure what you're asking me. I don't have the power to arrest anyone. I don't have the authority to make those decisions. And she really tiptoed around not just saying, yeah, I thought your client murdered his wife, so I did have concerns. And I was surprised that the defense continued to ask so many times. And I think she was incredibly mindful in those responses. But she did talk about something that made her think that this case, she wouldn't use the word catfishing because the defense wants everyone to use the word catfishing. But I think she accurately described it when she said we had questions about whether this was a setup, whether Joseph Ryan was set up in this case. And I think that's an accurate way to describe it. Was this a setup? And she said she started having questions about whether this was a setup the first night after the murder had happened in the morning, the defendant's birthday, when they got the defendant, the au pair, and the 4-year-old a hotel room. And it was heard that the 4-year-old was asking Juliana, "Can I call you mommy now? Are you going to marry my daddy?" And Juliana responded, "I wish." And that's really all I remember from the testimony. And I was left with the impression, as the victim advocate was staring at the defense attorney, that she was incredibly restrained. So, chat, a lot of you are asking if we can look at just a little bit of Friday. We will look at Friday morning real quick. It was in the podcast, so some of you have already seen it. We will look at Friday morning real quick, and then I am going to go have dinner with the kiddos. Tomorrow, I am probably going to Zoom the day on Friday and condense that testimony in summary form, and then see if we want to catch up to court in real time. Because if the defendant is going to testify and the defendant's one of the next witnesses in the stand, we're going to just do that. We're going to just do that. We're going to just do that. A few of you have asked about the days for trial. Here's the issue. At one point, Court TV had gotten the days wrong as they were labeling their videos. So I think there's been some widespread confusion about the day and date because the titles on the Court TV videos are wrong. But then in the Court TV video, their bumpers are correct. They corrected it yesterday. So we're going to do just a few minutes of Friday. Let me pull that video up. I did not have that prepared because we're going to indulge chat. So moderators, thank you. I know it's been an 8-hour video. Thank you. Team Baker, thank you. We're not going to keep it in the summary. It's just for the chat. For everybody who hung out this entire day. This one's for chat. This one's for chat. So, this one's for chat. All right? Yes. Perfect. We'll do a bit of a sneak peek for Friday's testimony. Because it's not enough that here we are in this trial. Emily, I don't have time for gavel to gavel coverage. Also, Emily, fuck, here we are now. We're in it now. We're in it now. We're in it. We're in it. We're just in it. We're in it. We summarized a few witnesses. We did get a few witnesses summarized. That was helpful. We did do that. All right. Let me grab the link to this video real quick and change this over. Thank you to I imagine that all of the moderators are also like, yeah, let's ride. I want to see Friday too. I want to see the beginning of the day. We're not riding any further than that. But all of you do deserve a moment of Judge A being done with these attorneys because we're done. Because all of us are done. All of us are done. And then I'm going to go have dinner with the kiddos because we've got more snow days tomorrow. All right, let me back this up. Okay. We are taking a brief look out of pure schadenfreude at what happens Friday morning. So remember, end of the day, they rolled late. Wednesday, defense ends an hour early, and the court's like, we're going to have to make up this hour somewhere. I'm fighting a fucking snowstorm. What are we doing? We need to get trial done. Thursday, we just watched. And the judge was like, what are we doing? And said, are you done tomorrow, counsel? Are we ready for jury instructions? Jury's back at 10 a.m. Friday. Attorneys are back at 9 a.m. Friday. The attorneys are back at 9 a.m. Friday to decide the jury instructions. So here we are.
There are duplicates. We've identified those.
Here we are for the beginning of jury instructions.
Judge, we've identified those which are duplicates. We've identified those which we object to of the defenses and would posit ours. The disagreements are primarily in the charging instruction, and the Commonwealth has two versions at this point in time, depending on what the defendant is
Okay,
saying.
well, let's see what we have.
So the prosecution tells the judge, hey, we have two versions of jury instructions depending on whether or not the defendant takes the stand. And the jury's not there, so there's a note that outside the jury's presence, the jury's not here. The judge is ready to do jury instructions. The judge is ready to have a jury instruction conference.
Yeah, that needs to go. I'll be right back. You got this?
The judge is speaking to the attorneys.
Can you,
Your mic.
I'm sorry, could you say it again?
Do you have a preference as to whether we're numbering or lettering?
No, it doesn't matter to me.
Okay. So,
typically, the prosecution numbers in the defense letters so that they know who's proposing which instruction. The attorneys should have talked before this
may I just chat with her? Maybe I can narrow this down.
to see what they agree on.
I have a whole list. So, Judge, this is going to be a waste of the court's time.
I'm sorry, but this is when I set it for, and I told you 2 days ago, so we are doing it now.
I understand, and I'm
What should the attorneys have done? The attorneys should have talked to each other and gone through which jury instructions they agree on and which jury instructions they don't agree on. We've seen this in jury instruction conference after jury instruction conference. Your Honor, we are agreed on model instruction number this through number this. We disagree on these model jury instructions. They haven't talked. And so the defense is like, I need to talk to the prosecutor to see which ones we agree on. And the prosecutor's like, Your Honor, this is going to be a waste of the court's time. And the court's like, I don't give a fuck. I've been telling you for days. I've been telling you for days. We're doing it now.
Judge, this is going to be a waste of the court's time.
I'm sorry, but this is when I set it for, and I told you 2 days ago, so we are doing it now.
I understand, and I'm happy to do it now, but if we have 2 minutes to discuss with each other, we would be able to.
It is 10 o'clock. You could have discussed at 8 o'clock. You could have discussed at 9 o'clock. It was 9 o'clock now. You could discuss at 8 o'clock. You had time yesterday. I told you 2 days ago, so we're doing it now. So let me have a copy of your instructions.
Why is no one ready?
I've been telling you for 2 days we're
Judge, I
doing the
would note
jury
that
instructions.
We will have another set that will be final, again, depending upon what happens.
I understand.
With testimony.
That happens in every case. In every case, you have to do this at least twice, if not 3 times. But Judge A looks like it looks like she is trying to just disassociate from what they're doing in court so she doesn't throw things at them.
And I'm sorry, Commonwealth will letter, defense will number, or what is what's the court's preference?
That's fine.
I will letter. John, could you number?
She is the site judge of the entire courthouse. And y'all show up and are just like, we're not ready, Your Honor. Okay, well, I set aside this time for you to be ready. We're doing this now.
I just gave her mine, so I'll number Judge.
All right.
Look at her. There's nothing she can do. They have to do the jury instructions. They have to have court time to do the jury instructions. She doesn't want this to be done with the jury waiting. So this is what's leading up to the end of the day Friday where she's like, get your shit together. And look, they're doing this now. They should have been in court doing this before the court came in at 9. She's sitting there staring at them. I'm actually kind of sad she's not angrily typing because that I miss the angry typing. I really do. I miss the angry typing. Just sitting on the bench.
Instructing the jury that they will have, and I think already has instructed the jury that they will have all of the evidence back with them, so we can skip the model that tells them that they'll
That's
get.
fine.
Okay.
Do you have a copy for Mr. Carroll?
I'm sorry.
Do you have a copy for Mr. Carroll so we can?
He was emailed.
He already has a copy.
Yeah, he has the digital copy.
All right.
This
See
is
that
both
here?
of their faults. This is both
right.
of their faults. The end of the day for Friday is in the podcast from this week. If you've not watched the Emily Show yet, it's in the Emily Show. I covered it then. This is painfully bad. And we are not on 1.25 because I wanted to see how long it took in real time. Listening to him flip paper is pissing me off. I can't imagine how the judge feels. The paper is
Judge,
pissing
on
me
an
off.
unrelated matter, Detective Bryant has been released by defense. He was their subpoenaed witness. May he join us in the courtroom for the duration of the trial?
Any objection to that, Mr. Carroll?
There you are.
Okay, that's fine. Thank you.
Thank you.
I think we could remove the gum.
Oh, I'm sorry, Judge. 1 second.
The prosecutor's chewing gum. You're chewing gum? I mean, you haven't worn a suit for the murder trial, but you're chewing gum? Oh my God. Judge A's gonna lose her mind. She's gonna lose her mind.
Remove the gum.
Oh, I'm sorry, Judge.
I didn't even notice that she was chewing gum. Judge A's like SOSing. Shit, the angry drop of the pen. Uh-huh. Uh-huh. Oh, Your Honor, I feel you. I feel you. You don't chew gum in court. You don't chew gum in court. You wear a suit to court. You don't chew gum in court. You come to court prepared. Yikes. The judge needs a clicky-clacky keyboard to exemplify how angry she is so she can just angrily type out emails. I mean, banging the bench does work. Your Honor, I'm here for you tapping out SOS on the bench.
She just came, she just walked in.
I'm here for it. The disrespect is crazy. Defense is still just flipping fucking papers at a glacial pace. I don't know if you can flip papers any slower, honestly. It's been 10 minutes, right? Has it been 10 minutes? It's been 10 minutes?
Commonwealth then.
It's been 10 minutes? Has it been 10 minutes?
You have a copy of the Commonwealth's?
I do, Your Honor.
Okay, great. So then first instruction A is just that the defendant is presumed innocent. I assume you have no objection to that.
The court's face. The court's face. And he was not trying to hurry. It seems like the defense was going as slow as possible. He didn't seem like he was trying to move it along to help the court.
Instruction.
Judge, I have two versions of it. Would it be the bold one?
I have one where it says Brendan Banfield is presumed to be innocent. You shall not assume Brendan Banfield is guilty. There's no burden on him, and it keeps going down. There's no burden on him to produce any evidence. It's the same as your instruction 1, except they put his name in it. And it doesn't, yours says the defendant, and his, theirs says Brendan Banfield, but other than that, it appears.
I don't have an objection. That's number 1?
No, that's their instruction A.
A, sorry.
So then you'll withdraw instruction 1 then?
I will, Your Honor.
Okay, 1 is withdrawn.
We're going to zoom just a little bit. We're going to zoom just a little bit. I don't know where we had the closed captioning on.
Any objection to that?
No.
Okay, B is.
We're going to zoom until we get to them asking about the homicide instructions. We're not going to go through the entire jury instruction conference. They're going to have to do this again, especially if the defendant testifies. So we're not going to go through the entire jury instruction conference at this time. If we need to do this later, we might.
This hour, 9, 20.
I was just trying to see which one we were on. We don't know which one we're on. All right.
Definition of willful act.
I believe I did, Judge. I don't have an objection to.
All right, we're just finding which one we have to withdraw from yours.
I found it's.
I have 27 as a definition of willful, deliberate and premeditated.
Yeah, that
Okay,
matches.
so we'll withdraw 27. All right, J is the charging for aggravated murder.
And J should have been the instruction for child endangerment. Then this letter.
I don't have that. I have instruction.
J is
Oh boy.
aggravated murder. And yes, there are 2. There is one for Joseph Ryan and one for.
So J and K.
Yes, ma'am.
JK, you thought the lawyers were going to be prepared. You told them for 2 days. They knew at the beginning of the case what the case was.
Their J and K is.
Yeah.
In the order that they gave it to me, the next one was crime of child endangerment.
I didn't, but it's not what I have. I have J.
So skip down one more. It's okay.
It's still disorganized, so we're going to zoom until they get to talking about the aggravated homicide and second-degree murder. Let's see. We're going to zoom because they're still talking about J and K. They have no idea what's happening. All right, continuing on.
No.
Okay. M, N, the fact that the defendant's been indicted by a grand jury is not evidence. I assume no.
Okay, perfect. Zoom. Let's see.
Passion instruction, then wouldn't you be?
Backing up for Q.
You can't consider it. Any objection to that?
No objection.
All right, Q is a malice instruction, which also goes into heat of passion. Do you have any objection to that?
I don't have
Well,
it
if
in
you're
that
giving a
order,
heat of
Judge.
passion instruction, then wouldn't you be second-degree waterfall?
The next instruction after.
I'm just asking a question here.
I'm sorry, Your Honor.
Your instruction Q has the definition of malice and also heat of passion.
Yes.
So then the defense is like, but Your Honor, and she's like, I'm asking a question. We're not done here. Can you pay attention to what we're doing?
So if we're giving a heat of passion definition, that's a second.
And again, Judge, depends upon whether or not the defendant testifies. There would be a replacement for malice that does not include heat of passion.
Is the defendant going to testify, Mr. Carroll?
Yes.
Yeah, excuse me?
Yes.
He is going to testify.
Okay, then presumably.
I still don't know who gasped. Somebody gasped in the courtroom. I just don't know who. Did you hear that? Somebody gasped.
Malice that does not include heat of passion.
I think it came from family.
Is the defendant going to testify, Mr. Carroll?
Yes.
Yeah, excuse me?
Yes.
He is going to testify.
Okay, then presumably, depending upon what he says, this
Okay,
would
so
stand.
Q, so you don't have objection to Q then?
That's Q's malice.
Malice and heat of passion.
Yep. So that's how Friday starts. That's how Friday starts. Somebody gasped. Tomorrow we will be back streaming to see what happens. So we will not be in real time with the court. The defense is saying that the defendant will testify. However, after Snowmageddon, the defendant can change his mind. The defendant can change his mind until he is sworn in on the stand and starts talking. The defendant may change his mind. He may not. But as they're talking about the jury instructions, there will be potentially different jury instructions if the defendant testifies and if the defendant doesn't testify. So we will see what's going on in court tomorrow. I'm going to do my best to condense Friday and summarize the testimony because today was really rough. And based on the court at the end of the day on Friday saying, y'all, what the fuck are you doing? I imagine Friday is just as bad. So I'm going to try to condense that down. And then we'll just see what happens. Because I have no idea if I still have to travel or don't have to travel. We have all kinds of things going on. So we're just going to play it by ear, which means you need the Lawnerd app. We built it for you. It's free on iOS and Android. If you don't have the Lawnerd app and are now invested in this trial, even if it's against your will, I'm sorry. I'm sorry if we are dragging you to trial against your will and you're like, damn it, now I need to see what happens. So we will see what happens and we will do our best to work around EDB family scheduling and all the rest of it. So hopefully you guys are staying warm. Your roads are clear. You can replenish your snow snackies. And, you know, if you still have snow days, at least you have power because it seems like we're back in court in real time tomorrow. We're only one day behind. We're going to summarize that day as best we can and maybe just jump back in to day 8. I can't do it in real time. I cannot do it in real time. If there is not Zoom room, if there is not room to have these attorneys at least 1.25, if not 1.5, I will rage quit. So we're definitely going to need some Zoom room because damn, I don't think I can deal with this attorney I can't deal with this defense attorney at normal speed. I can't. I refuse. I absolutely will not. I know it makes it hard on the spoilers for the mods, but I refuse. I will not. It is way too painful. Thank you, everybody, for hanging out today. It's good to see you. I really don't know what's going to happen with this case. I am really surprised with the way the defense is proceeding. I really am. It's incredibly surprising, but you can't make this up. If somebody came to me and was like, this is what's going to happen in trial, I would be like, no, it's not. No, it's not. That can't be real. That's not true. That can't be accurate. And yet here we are. So, poor Judge A. I don't think I've ever seen anything quite like that. I really don't. And it's not, I laugh, but it's not comical because the victims deserve a good trial. The defendant deserves a good trial. And the defense attorney stands up, and it seems that every single time he is coming across this information for the very first time, and it is a whole new world to him, and he's just like, we're all going to learn together. No, we're not all going to just learn together and hope it comes together at the end. Because it's just not going well. It's not going well for the defense at all. And I think the defense has oddly made the prosecution case stronger at the end of day 6. We'll see what testimony they elicit on day 7, and we'll see what happens on day 8. The judge wanted this case to be done on Friday. It was definitely not. And I don't know how many more days they can do this, but the The court told them at the end of the day Friday, get it together. It's in the podcast. We'll summarize this tomorrow. I will let you know in the app what time we're going live tomorrow once I talk to the family and check in with them. A couple of you said that doing jury instructions felt like the worst group project ever. Yes, it did. Yes, it did. Yes, it did. Because it's just painful. Team Baker, Law Nerds, mods, thank you so much. I appreciate you. I can't believe that this is real. I really can't. It's shocking. So, join me in disbelief tomorrow and we'll see what happens on our day 7 summary and jumping into day 8, I guess. Maybe it'll get better. We did learn new things today that we hadn't learned the day before. So fingers crossed. All right. Get some snacks. I'll see you tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.